So, my lord, that shows the song being sung on various iterations. The last iteration of that song is in Senekal in October 2020. And there, members of the EFF are singing the chant, kill the Boer, kill the farmer, and they are using the words kill, not kiss. And to provide a bit of context, at Senekal, the reason why there was a protest was that there was a hearing, a bail hearing with regards to people that were accused of murdering Red Warner, who was a 21-year-old farm manager, if he murdered in a particularly brutal way and put on public display, and that his a rope was tied around his neck, and a knife and a hat were put out pointing in his direction. There is also, on this same occasion in Senekal, Dr. Ndlozi sang a song called Bizani Fire Brigade, and the translation of that song is, call the fire brigade, this is fire, call the fire brigade, burn these Boers, EFF into this place. Now, my lord, what I intend on doing, having set up some of the basic facts, is to turn to what the legal tests are. I will then turn to the particular testimony that was led at court.
Before we go there, Mr. Matt, your case is that the singing of the song contravenes the provisions of the Act. But you during the trial itself, as I understood, and in fact the pleaded case also, because this case started off with the affidavits and all those submissions, and you'll recall during the case management, I sought to persuade the parties to say, why don't we focus mainly on the papers rather than the oral evidence? Now, as I understand where we are now, the case is, we will show that this contravention through the evidence that shows that there is a correlation between the matters that happens in the farms and the singing of the song. Now, if one finds that there is no correlation between the two or causal connection between the two, what then happens? What should the court then do?
My Lord, the law is quite clear on this front, which is that there is no requirement of a causal connection whatsoever. The purpose of the evidence is to explain the legal context, which is part of the test set by the court in Cologne. So, my Lord, it's in my heads of argument at page 80, at paragraph 256, Cologne, the court held, considering the next phrase to incite harm, it is imperative to point out at the outset that there is no requirement of an established causal link between the expression and actual harm committed. At 259, Court in Cologne says, to require a causal link would in and of itself undermine the very same objectives of the Equality Act to prohibit unfair discrimination, in that not every instance of harmful and or hurtful speech will result in imminent violence. There may be expression which certain groups find hurtful and or harmful, which does not actually result in violence, but that does not take away from the fact that such expression would have been hate speech. So, my Lord, my learned friends' heads of argument are very much built on the premise that what the complainant needs to prove is that there is a causal link between the singing of the song and people being killed. That is not the test. The Constitutional Court makes it incredibly clear that's not the test.
Yes,
the purpose of that evidence.
In fact, that's also what the Cologne case says.
Yes.
Because if you look at the Cologne case, what happened there was that the statement was made against the certain group of people. And even though there was no evidence, it appeared that any one of them, except that there are examples which are used, but there was no oral evidence led to say, this group, this is what has happened to them specifically. That I understand. And I'm raising this question because this case took 5 full days. It took us almost, 3 months before we could even get to here. Now, I've been wondering as to whether going forward in the future, isn't that one needs to also look at, do you necessarily in matters of this nature need to lead such long evidence? And also, in fact, I would want to be addressed, I guess, at the end of the case, we're going to also deal with the question of the costs, whether this was really necessary. And as I say, I sought to persuade the parties to say, why can this matter be considered on the papers? And I've gone through the papers again. They almost traverse every issues that were traversed during the trial.
Lord, let me deal with some of that then up front. The first is that the Constitutional Court identifies a 5-part context test, and then also makes reference to the role of experts and what their proper role is. Now, my Lord, at page 76 of my heads of arguments, it says the experts in the matter should not be used to determine the meaning of statements. The evidence of experts as to patterns of discrimination, historical uses of language, its harmful effects, can only give assistance to this court.
So just give me the page again, Mr.
It's page 76. It's so just above paragraph 250. There's a paragraph there that follows on from the prior page.
Yes.
It says the experts in this matter could not be used to determine the meaning of the statements. Evidence of experts as to patterns of discrimination, historical uses of language, its harmful effects can only give assistance to this court. Expert testimony colours the context that we need to understand before we can properly assess the statements, before we can assess the statements properly. With careful management and circumspection, expert evidence may be used and may be useful to courts in adjudicating hate speech cases. So that's why the evidence is important. And as I say, that the court then identifies this 5-fold context test at page 81 of my heads of arguments at paragraph 260. The court in Cologne held various factors have to be identified and have been identified in international law that justify the curtailment of freedom of expression. These include 1, the prevailing social and political context; 2, the status of the speaker in relation to the audience; 3, the existence of a clear intent to incite; 4, the content and form of the speech; 5, the extent and reach of the speech; and 6, the real likelihood and evidence of harm. So a lot of the expert testimony is about filling in that social and political context. And so that amplifies what's in the papers. Ultimately, what your Lordship is correct in noting is that the elements of the case are on paper that initiates a claim. In other words, it sets out what the words are, it sets out what the legal test is, it demonstrates their hate speech, and the meaning of the words must be determined by this court. They mustn't be determined by an expert. Experts are prohibited from saying what the song means. And so Mr. Woods doesn't really provide evidence on that basis, but he provides evidence of the social context. And I'll go into detail about what that evidence was regarding the prevalence of the killing of white Afrikaners and how they are killed. But the purpose of that evidence was not to say there is a causal link between these two things. That's not what needs to be shown by the complainant. But what needs to be shown is to say what's the context in which the speech occurs. This is not speech that occurs in a vacuum. It occurs within a social context, and that's identified by the Constitutional Court. So, my Lord, what I intend on doing then is briefly setting out what the legal tests are, beyond some of the points. But first, let's start off at page 69 of my Heads of Argument, at the top there. In August of 2016, the United Nations Committee on the Elimination of Racial Discrimination produced a report about hate speech in South Africa. The report stated the following: the committee is further concerned at the rise of hate crimes and hate speech in the state party, including physical attacks against certain ethnic groups and non-citizens, discriminatory statements by state officials and politicians, and the increase in the use of media and the internet to propagate racist hate speech. The committee further recommends that the state party ensure all incidents of hate crimes and hate speech are investigated and prosecuted, and the perpetrators are punished, regardless of their official status. The committee calls on the state party to conduct educational campaigns to address the root causes of prejudices and promote tolerance and respect for diversity, with a focus on the role and responsibility of journalists and public officials in that regard. Now, there have been prior rulings on Kill the Boer and Kiss the Boer. In the matter of Freedom Front versus South African Human Rights Commission and other, it was held that the slogan, kill the farmer, kill the Boer, as chanted at the ANC rally at Kimberley at the funeral of Peter Makabe and Polokwane, is hate speech as defined in terms of section 16(2)(c) of the Constitution. Now, my learned friend in his Heads of Argument says that there's something improper about this finding that is done in terms of the constitutional test. Now, what we must remember at this juncture is that the test provided in the Constitution is the strictest possible test. It's 16(2)(c) is the advocacy of hatred on listed ground, race, gender, ethnicity, or religion, and that constitutes an incitement to cause harm. So that's the strictest possible test, and on that strictest possible test, the Human Rights Commission found that the words, the chant "kill the Boer" amounts to hate speech. The Commission found that the slogan under consideration in this appeal was chanted at high-profile functions organised by the African National Congress, the ruling party of this country. These events and the chanting of the slogans were widely publicised. There can be no doubt that the slogan, given its context, its history, and the context in which it was chanted, would harm the sense of well-being, contribute directly to a feeling of marginalisation, and adversely affect the dignity of opponents. The slogan says to them that they are still the enemy of the majority of people of this country. It contributes to alienation of the target community and conveys a particularly divisive message to the majority. The target community is less deserving of respect and dignity. This generalized slogan is directed against an entire community of people. Words convey meaning and do cause hurt and injury. There's a real likelihood that the slogan causes harm. Now, my learned friend takes a point in his Heads of Argument that the term Boer isn't a prohibited ground. Now, the Human Rights Commission, by the way, this is not a point taken in their pleadings. They don't challenge that. But the term Boer as found by the Human Rights Commission, says it was common cause that the slogans were based on race or ethnicity. The term Boer is defined as a descendant of the Dutch or Huguenot colonists who settled in South Africa. In the South African context, the term has been used to refer to Afrikaners generally and Afrikaner farmers more particularly. So the Human Rights Commission there makes a finding that Boer refers to race and ethnicity. Arguably, it also refers to language groups, and that Afrikaners speak the language of Afrikaans, which is also a protected category. In the Bond judgment, the court stated, an important feature within the ambit of the range of permutations is the ability of the speaker to so structure the delivery of the message as to cause the audience to attribute different meanings to the words and the meanings which are ordinarily attributed to them. This elasticity of meaning has been manipulated by persons who are skilled in the art of words since time immemorial. It shows filled with parody and innuendo to name but a few. It's possible to illustrate this point by recalling that at a point in time, Malema was saying, kiss the Boer. On the face of it, these words are innocuous. It is only when consideration is given to the range of knowledge available for the audience and to which the audience will use to decode the words, the true meaning becomes apparent. At the time the words were uttered, the words kill the farmer, kill the Boer were controversial and could not be used as they had been recognized as hate speech. The fact that the words kill the farmer, kill the Boer were hate speech was well known to all members of the audience as it has been widely publicized. At a superficial level, the word kiss is sufficiently close in sound to the word kill for the audience to make the link between kiss and kill. Once the audience makes the link, it becomes apparent the coded message is that to which the link refers, namely kill the Boer, kill the farmer. There can be little doubt that it was no coincidence that the speaker used the word kiss when he encoded the message, wished the audience to receive. The elasticity of the meaning to be attached to kiss is that it means kill. Hence the word actually used, a word demonstrating love and affection, is in fact a word which is intended by that use to produce the image of the exact opposite. Now, the finding of that court at paragraph 108 of the Le Monde judgment says, I accordingly find that Malema published and communicated words which could reasonably be construed to demonstrate intention to be hurtful, to incite harm, and promote hatred against the white Afrikaans-speaking community, including the farmers who belong to that group. The words accordingly constitute hate speech. Now, at the time, there was some ambiguity as to what the test was, and the Constitutional Court has settled what the test is. But it must be noted that all the elements of the new test are met by the finding of Le Monde. Hurtful is no longer a requirement, but the promotion of hatred against a group and the incitement of harm, if both of those are met, then there must be a finding of hate speech. Now, Judge Le Monde also takes it to mean that Boer refers to white Afrikaners.
But maybe we could also accept that the Judge Le Monde in the judgment actually dealt with the test that was subsequently overruled by the Constitutional Court in the Kolani matter, because he used the test that included hateful.
Yes, so my lord, if the Judge Le Monde's finding was that the words are hurtful, therefore they are hate speech, and that was one way the test could be used, because it was read by some courts in a disjunctive manner, and so the requirement was, is it hurtful, harmful, incites harm, and so some courts read those as and requirements, and some courts read them as or requirements. If Judge Le Monde had said the words are hurtful and said nothing about the incitement of harm or the propagation of hatred, well then obviously it wouldn't be a very good precedent. But that's not what Judge Le Monde does. Judge Le Monde says it meets multiple sections of the test, and so it is in line with the new test set by the Constitutional Court. For clarity, what the Constitutional Court finds the new test to be, it says, subject to the proviso in section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more prohibited grounds against any person that could be reasonably construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. And the listed grounds includes ethnic or social origin, race, and language and birth. Now, to understand that test properly, it means that there must be a clear intention to be either harmful or to incite harm, so that's an or still, and promote or propagate hatred. And so long as there is one element from both 1 and 2, then the statement falls foul of the test, and it's an objective test. So what Lamont does is he says, well, there is hurt, doesn't need to find that anymore because hurt has been struck out by the Act, but he does find that there is the propagation of hatred, and there is the incitement to harm. So, in other words, if he were to use the test set out by Causality, he would make an identical finding, because those two levels are met by him. My Lord, on the question about what your Lordship how it should read the one judgment, common cause between the parties that the order between the parties has been that the parties have agreed not to be bound by the order and that they are bound by a settlement agreement reached at the Supreme Court of Appeal. But the judgment is not set aside. And
so the judgment is? The
judgment has not been set aside. So the judgment still binds this court. It's in a court in the same division. It's presumptively binding, and unless it can be shown to be clearly wrong, then this court is bound by it. The order is not binding, but the ratio is binding. And so the ratio identifies a number of things. The one is that the song constitutes hate speech, and it uses the test that, as I said, matches up with the test used by the Constitutional Court Causality, and it makes a finding about what the meaning of the word is, which is that it refers to white regardless. And
in a sense, the order was abandoned by the parties. But what the parties didn't do when one reads the mediation agreement is they did not abandon the principles which were set out in the judgment.
Yes. So the judgment, so the judgment stands, the order doesn't stand, but in other words, it's the ratio that's binding on this court. If I might say one other quick thing, I made reference to the Human Rights Commission's finding. And my learned friend in his heads of argument says that the Human Rights Commission later made a finding about the song. And I just want to point out that my learned friend errs in this regard. The Human Rights Commission made a finding about a speech that Mr. Nlema gave at Newcastle, and that finding in the Human Rights Commission that the speech did not constitute hate speech is on review. But the song, Kill the Boer, is not part of that case. So the Human Rights Commission has made this finding in 2003 about the song, and it has not changed its mind since then.
And what would be the status of the of the findings of the Human Rights Commission in relation to the fact that it's a review vis-a-vis if it was an appeal? Does it have any impact?
Well, my Lord, for clarity, in other words, my little friend says in his state of argument that the Human Rights Commission recently, I think it's about 2016 that the speech occurs, and the Human Rights Commission makes a finding sometime after that. He says that the finding the Human Rights Commission makes is about this song. I just want to clarify on the fact that's not the case. The Human Rights Commission makes no such finding about the song.
But assuming one was to read the finding in that way, what would be the consequences of or the implication of the review to that interpretation in relation to what this court's position would be in terms of, is it persuasive, is it binding, is it something that the court should take into account, or should the court adopt the attitude that says it's a review, therefore it's pending, it's suspended?
Yes, well, I don't want this court to labour under the assumption that the Human Rights Commission ever changed its mind about the song. So, in other words, there's a hypothetical question, which is, if the Human Rights Commission made some finding about this song in 2018, what would the effect of that be, given that it's under review? And I suppose I'd say the court should be agnostic about it. But I want to make it very clear that the Human Rights Commission made no such finding in any recent review. Their finding is in 2003. And the effect of that 2003 finding, I'd submit is that it is persuasive authority for this court. In other words, the Human Rights Commission, which is a Chapter 9 institution, considered facts that are very similar to the facts in this case on that side, made a finding. The court in Lamont was aware of that finding and seems to acknowledge that some constitutes hate speech, so it's incorporated into our law. And so to the extent that it's in Judge Lamont's judgment as a finding of hate speech, well then it's presumptively boundary. On its own, I'd say it's persuasive. My Lord, I think it's also important to point out what the Causality Court says about the nature of hate speech. It says that it is a truth universally acknowledged that to be hated, despised, and alone is the ultimate fear of all human beings. Speech is powerful. It has the ability to build, promote, and nurture, but it can also denigrate, humiliate, and destroy. Hate speech is one of the most devastating modes of subverting the dignity and self-worth of human beings. This is so because hate speech marginalizes and delegitimizes individuals based on their membership of a group. This may diminish their social standing in the broad society outside of the group they identify with. It can ignite exclusion, hostility, discrimination, and violence against them. Not only does it wound the individuals who share this group identity, but it seeks to undo the very fabric of our society as envisaged by our Constitution. We are enjoined by our Constitution to strive for a society built on the democratic values of human dignity, the achievement of equality, and the advancement of human rights and freedoms. Hate speech is the antithesis of the values envisaged by the right of free speech. Whereas the latter advances democracy, hate speech is destructive of democracy. Now, at page 74 of my heads of argument, the Causality Court makes a finding about how to assess hate speech and says that it's an objective test. Before this court, the parties debated whether the phrase that could be reasonably construed to demonstrate a clear intention postulates a subjective or objective test. In my view, it is plainly an objective standard that requires a reasonable person test. This is based on the gloss, reasonably be construed and to demonstrate a clear intention, implying an objective test that considers the facts and circumstances surrounding the expression and not mere inferences or assumptions that are made by the targeted group. This approach accords with the interpretation advanced in the Kamalo case, that the objective tests in section 10.1 implied in the terminology used to articulate it, that an intention shall be deemed if a reasonable reader would so construe the words, because the objective test of the reasonable reader is to be applied. It is the effect of the test of the text, not the intention of the author that is assessed. And the judge says, I endorse this approach. Furthermore, the court in Kamalo explicitly endorsed non-racialism in the application of the objective test and held, in South Africa, however, our policy choice is that utterances that have the effect of inciting people to cause harm is intolerable because of the social damage it wreaks and the effect it has on impeding a drive towards non-racialism. The idea that in a given society, members of a subaltern group who disparage members of the ascendant group should be treated differently from the circumstances were it the other way around has no place in the application of the Equality Act and would indeed subvert its very purpose. Our nation-building project recognizes a multitude of justifiable grievances derived from past oppression and racial discrimination, racial domination. The value choice in the Constitution is that we must overcome the fissures among us. That cannot happen if in debate over robust among ourselves, one section of the population is licensed to be condemnatory because it's members of the victims of oppression, and the other section understood to be collectively the former oppressors are disciplined to remain silent. In other words, the court says different racial groups will be treated with the same law. That if you are white and you target black people, the same rule will be applied as if you are black and you target white people. With regards to the meaning of the words, in Masuku, the court held, and this is the other constitutional court case, making a determination as to the meaning of words is a task that rightfully falls to the expertise, competency, and responsibility of courts. That said, it would be remiss of me not to acknowledge that words are naturally colored by the context in which they appear and are used. Indeed, this court in Nauru discussed the importance of determining the meaning of words with recourse to their context. The primary meaning is the ordinary meaning given to the statement in its context by a reasonable person. The reasonable reader or observer is thus a legal construct of an individual utilized by the court to establish meaning. What this means is that whilst the determination as to whether words are likely to be harmful and propagate hatred and thus constitute hate speech falls within the exclusive aegis of the court, evidence that shines a light on the context of these words may be of assistance to that court before conducting this exercise. And I spoke briefly about the proper role of experts. In other words, an expert is not to come to court to say the words mean the following. That would be improper for them to do. But it is proper for them to provide a context for the words. And it might be useful to give an example that was used in Polani of how evidence was treated. And this goes to your Lordship's earlier question about how long these matters should go on for and what evidence is important. And in Polani, at paragraph 14, the court says, extensive evidence was adduced in support of the Human Rights Commission's hate speech complaint against Mr. Polani. A brief outline will suffice. A more comprehensive narration will follow. The Human Rights Head of Legal Resources, Mr. Gregiari, testified about the numerous complaints received from members of the LGBTI+ community, even before the articles were published. These complaints related to numerous horrific violent attacks against black lesbians and transgender persons, a lack of policing in the form of the police being seriously remiss in their duties to properly investigate complaints by members of the community and exhibiting an anti-LGBTI+ inclination. He further testified that there were complaints from the community about the denial of access to essential services there. Ms. Mokwena, who was the Executive Director of People Opposing Women Abuse, confirmed parts of this evidence relating to the brutal attacks against lesbians, including the repulsive practice called corrective rape. Evidence, too, reflected poorly on police for their disturbing apathy in respect to these types of complaints. Ms. Mokwena alluded to 5 widely publicized instances of horrific violent attacks against lesbians. The last witness called by the Human Rights Commission, Ms. M.N., whose name is redacted, a 52-year-old who identifies as a lesbian, testified in camera for fear of reprisals. She recounted her personal encounters with homophobia and discrimination on the basis of her sexual orientation. Ms. M.N. broke down in the witness box while narrating the verbal and physical attacks perpetrated against her. She pointedly remarked that she did not bother to report some of these incidents since, in her words, the law does not protect people like me. At paragraph 18, the Psychological Society led the evidence of its former chairperson, Professor Nell, a research professor at the University of South Africa with a special interest in LGBTI+ related work. Apart from recounting his own lived experience of ill treatment and discrimination on the basis of his identification as a gay man and the psychological trauma suffered generally by the LGBTI+ community due to their exclusion and rejection, Professor Nell also commented on the severely deleterious psychological impact the article had on that community. Now, my Lord, I refer your Lordship to these sections of the Polani judgment because my learned friend in his heads of argument launches an attack on the relevance of the experts that were led by the complainant. And I'd submit that the type of evidence that was led in the Polani case is very similar to the type of evidence that was led in this case. Furthermore, the fact that Mr. Nell, who was brought in as an expert, also stated that he personally had endured attacks and that he himself was a member of the gay community, showed that he had a particular kind of interest in the outcome, that he cared for the community's sake. And I'd say that's similar to the evidence led by Mr. Roots.
But would that then mean that the test to apply in weighing the credibility of an expert witness in cases of this nature would be different to the well-established test and jurisprudence around how expert witnesses are expected to, the standard that would be required of expert witnesses?
I would submit so, my Lord. I'd submit that that the Quality Court jurisprudence is developed in quite a different way from the jurisprudence in other courts. So these matters are sui generis. They are not civil matters. They are not criminal matters. And the courts have made it clear that they are to be held to a different standard. So in the case of Woodways and Valley, the court says It's clear to me that the Act creates an informal and inexpensive platform for the adjudication of unfair discrimination disputes. It marks a shift from the conventional way of litigation, which emphasises elegance in the formulation of the pleadings. It creates a space for the victims of unfair discrimination to tell their stories, so that systematic inequalities and unfair discrimination, which as the preamble states remain deeply embedded in social structures, may be eradicated. The promise of equality and easy access to justice, which the Act seeks to fulfill, would never be realised if litigants in unfair discrimination cases were expected to be meticulous in the manner in which they plead their causes of actions. It's for this reason that only a judge or magistrate who has completed social context training may be designated to hear unfair discrimination matters under the Act. And in the matter of George and others versus Minister of Environmental Affairs and Tourism, the Court held that an integral part of the Equality Act then is the focus on the creation of a user-friendly court environment where proceedings are conducted along inquisitorial lines with an emphasis on informality, participation and the speedy processing of matters. This objective itself goes to the essence of what equality is about, because it emphasises the need to make the judicial process available to all, including the poor and oppressed, who are usually the victims of unfair discrimination and inequality. The formal, adversarial, often expensive and potentially intimidating proceedings that prevail in an ordinary magistrate's court or high court, which may act as a barrier to those seeking justice, have no place in the Equality Court. Judge Lamont made a similar sort of finding about how he dealt with evidence at paragraph 58 of his judgment. He says, "During the hearing, I allowed much evidence to be led which would not normally be permitted in a court of law, as it appeared to me that it was proper to allow the parties to the dispute to fully and completely ventilate the issues between them, even if such ventilation involved the admission of evidence in the form of speeches which were made during the course of the trial."
So what paragraph is that from?
Paragraph 58. So I'd submit, my Lord, that these proceedings are just fundamentally different in nature. That we have an instance, as I say, with regards to Professor Nell, who is himself a victim, who is able to testify to the broader context in which the gay community found itself in. And he could testify as to what he himself had endured. So,
well, isn't there a difference, and one seems to find quite often where the legislature create the specialized tribunals and courts, there seems to be an approach of seeking to make those procedures much more informal, to do away with the technicalities that you find in the general civil litigations. But I'm not too so sure whether that goes even to the question of the standard that would be required of an expert, because an expert, even in the general normal proceedings, in a sense, one could refer to that person as a specialized person. And the purpose of that evidence, it's mainly to assist the court. So the court, in a sense, defer to the better knowledge and experience of that person. And it seems to me, my understanding is that the reason why the standard is set so high for them is to ensure that in giving to the court and the court accepting that evidence, it's not colored by the position they hold in as far as the subject matter is concerned, their involvement in the subject matter, their biases that may be brought in by the position that they may have taken on the subject matter. So are you saying that even in this kind of cases, one would have to relax that standard in relation to the overall purpose of why the court was created?
Well, my Lord, I'd submit that, in other words, the essence of what an expert is someone who can provide the court with evidence that it would not otherwise have. So, for example, it's not the expert's role to explain the meaning of words. The court can do that itself. But the expert can provide this fuller context. And I'd submit that one way to assess the credibility of that expert is to determine, is it a matter of listening to what they say things are, or do they back it up with evidence? So it's not merely a matter of saying, I'm going to believe this person's personal story about things. Are they the kind of person who really has the genuine expertise? Have they done the research? Can they demonstrate it with reference to external facts? And I submit that Mr. Roots has done exactly that. Mr. Roots has written the book on farm killings. That his book has 1,000 footnotes in it. That at any opportunity that a claim is made by Mr. Roots, it can be backed up with external evidence. And throughout my heads of argument, what I've done is, in my citation method, I've cited his testimony in the transcripts, also the particular parts of his book which relate to that, and then furthermore, where there's an external source, like a newspaper article that talks about a particular killing, that external source is also mentioned. So in other words, one doesn't have to take Mr. Roots at his own word. One can go and check at every juncture whether his word matches reality. And so I'd submit on that basis, he very much meets the test of what an expert is supposed to do. In the PwC case, what the court there finds is that that expert just didn't have the relevant expertise. So that he purported to say, I have an expertise as an auditor and expertise around agricultural products, but he didn't actually have the relevant expertise. And so that's a good reason to say that person is not an expert. But of course, that setting is within a civil context, and I would submit that the standards in the Equality Court must be different. And things like having a personal interest, I think, are different. It's also not clear that Mr. Roots' personal interest at any juncture taints his evidence. In other words, he makes it clear that he thinks that the killing of Afrikaners is a bad thing, and that it's important to stop that, and that speech which incites people to go and kill more Afrikaners is a bad thing. But his accounting of the context is done in a neutral manner. There's no distortion of any facts. My learned friend, the respondents don't leave any contrary evidence whatsoever. They don't call an expert to say these facts are wrong. This isn't what's happening with regards to farm killings. So I'd submit that Mr. Roots meets the standard of what an expert requires, and it's very much in line with the kind of testimony that the Constitutional Court endorses in Kulani. And similarly with regards to the other bits of evidence that are led. So MN is someone who personally endured homophobic attacks. And so the complainant in this case led two witnesses who both had endured attacks themselves. And the point of that is to provide the context, to know what it is that's being called for. When the third biggest political party in South Africa says, kill the Boer, we should know what that means. We should translate that into a real situation. So hearing the testimony of Mrs. Muller, hearing about her husband being shot in the head, or hearing about Duncan Prinsloo having his wife murdered in his arms, that reminds us of what's actually being called for, and having that testimony is important, and that's the kind of testimony that the Court in Kulani endorses. Similarly with regards to the psychological harm, you had experts talking about the psychological harm of these words, and that's met by the testimony of Mr. Human. Now, with regards to, we were talking about the meaning of words, Judge Lamont provides some further insight on this front. It says, the meaning of the words uttered by Malema was an issue. In order to understand the meaning of the words, it's necessary to place the words in their proper context. Words individually have meanings which are elastic, and that the meanings that they convey can vary substantially. Groups of words similarly have elastic meanings. The permutations increase as one adds to the equation. The context in which the words are uttered, the circumstance in which the words were uttered, the way in which the words were uttered, and the gestures which accompany the words and what the words imply. In this whole equation, sight must not be lost to the fact that notwithstanding the words used, the speaker, when he composes the message he wishes to deliver to the audience, is so able to compose it as to simultaneously convey multiple meanings to the whole audience and constituent parts of it. The occasion, the history of the conduct, and the response of the public and press, gesture and physical movement, crowd interaction, the words, including the expression and delivery of the words in a chant-like manner, are relevant to determine the context of the song. They altogether contribute to form the manner in which the message was delivered. This is partly why I wanted to show the video. In other words, it's one thing to see the words on a page, it's another to see how they are performed. That they are performed with pow-pow gestures, that they are performed in front of a large group of people, and that they are performed in a context where they are very close to judicial proceedings, where those that are accused of murdering someone are present. All of that tinderbox stuff is important to bear in mind. With regards to the term hatred, Constitutional Court in Islamic Unity held the following. Expression that advocates hatred and stereotyping of people on the basis of immutable characteristics is particularly harmful to the achievement of these values as it reinforces and perpetuates patterns of discrimination and inequality. Left unregulated, such expression has the potential to perpetuate the negative aspects of our past and further divide our society. In the Canadian case of Hearsay, which has been endorsed by our courts, a person's sense of human dignity and belonging to the community at large is closely linked to the concern and respect accorded to the groups to which he or she belongs. The derision, hostility and abuse encouraged by hate propaganda therefore have a severe impact on the individual's sense of self-worth and acceptance. This impact may cause target group members to take drastic measures in reaction, perhaps avoiding activities which bring them into contact with non-group members, or adopting attitudes and postures directed towards blending in with the majority. Such consequences bear heavily in a nation that prides itself on tolerance and the fostering of human dignity through, amongst other things, respect for the many racial, religious and cultural groups in our society. And Canada finds itself as a multicultural society in a way that South Africa is as well. We have a rainbow nation of many people who live amongst it, and that if certain sectors are vilified and targeted, this will have an effect. The authors of the Constitutional Law of South Africa state that hate speech can increase social tensions and the risk of violence, discrimination and other antisocial behaviour, both because the hateful messages may persuade or incite people to hateful views and actions, and because the targeted persons may react violently to the speech. Hate speech also undermines the values of pluralism and diversity. By communicating a message that some members of the community are less worthy than others, merely by virtue of their membership of a particular group, in the South African context, hate speech thus undermines the pressing goals of overcoming our divisive past and pursuing the tasks of reconciliation and the building of a democratic society. Hate speech may weaken the community building necessary for democracy to be sustained. And Kolani, citing Watkat, the court says, representations that expose a target group to detestation and to inspire enmity and extreme ill will against them, which goes beyond mere disdain or dislike. Representations vilifying a person or group will seek to abuse, denigrate or delegitimize them to render them lawless, dangerous, unworthy or unacceptable in the eyes of the audience. Expression exposing vulnerable groups to detestation and vilification goes far beyond merely discrediting, humiliating or offending the victims. Our learned friend points out that freedom of expression is a pivotal value in our Constitution, and the complainant cares very much about the right to freedom of expression. And words that are merely offensive are protected speech. But the Constitution makes it very clear that hate speech is not part of the free speech right. That once you meet that hate speech threshold as set by the court in Kolani, free speech does not play a role. And that is the realm that we are in today. We are not dealing with words that are merely offensive. We are dealing with words that propagate hatred, incite harm, and are themselves harmful. On that question of what constitutes actually harmful words, the bottom of page 79 of my heads of argument, the court in Kolani says that harmful can be understood as deep emotional and psychological harm that severely undermines the dignity of the targeted group. Citing Kamalo, the court says 3 types of harm were illustrated. First, the reactions of persons who read the utterances and are inclined to share those views and be encouraged by them to also shun, denigrate and abuse the targeted group. Second, the type of harm experienced by the targeted group, which includes demoralization and physiological hurt, and the harm caused from responding in kind, thereby creating a spiral of invective back and forth. And third, harm to the social cohesion in South African society, which can undermine our nation-building project. Now, the other leg of the test that could be met but isn't a requirement, in other words, because propagation of hatred must be met, propagation or promotion of hatred must be met, and then one can either have the words themselves being harmful or that the words incite harm. Gordon Kolani says that considering the next phrase to incite harm, it's imperative to point out at the outset that there is no requirement of an established causal link between the expression and actual harm committed. Something that we discussed earlier, my Lord, is that it's not a criminal assassin test. It's not saying this person spoke words to call someone to kill, the gun went off, that person died. That's not the test envisaged. So the ordinary meaning of the phrase incitement to cause harm suggests that one should not look to the harm caused by the speech itself, but rather to the impact of the speech on third parties. Does the speech encourage, stimulate or call for others to cause harm? In addition, in order to amount to incitement, the expression ought to amount to an instigation or active persuasion of others to cause harm. Black's Law Dictionary describes it as an act or instance of provoking, urging on, or stirring up. Now, I've already discussed the context and the likelihood of harm, that fivefold test that the court sets out. Thus far, the legal test that I've set out all relates to hate speech. But there is a second complaint that is raised by the complainant, which is in relation to unfair discrimination dealt with by Section 7 of the Act. And the Act says that, subject to Section 6, no person may unfairly discriminate against any person on the ground of race. So we know that this particular section is limited to racial grounds, and I submit from what I've said earlier about Boer that that's a racial group. So you can't discriminate unfairly against any person on the ground of race, including the dissemination of any propaganda or idea which propounds the racial superiority of any person, including incitement to or participation in any form of racial violence. So, in other words, speech which propagates ideas on the grounds of race, which incites people to perform racial violence, would constitute unfair discrimination in terms of Section 7 of the Act. In the matter of Hugo, the Constitutional Court held, the prohibition on unfair discrimination in the interim constitution seeks not only to avoid discrimination against people who are members of disadvantaged groups, it seeks more than that. At the heart of the prohibition of unfair discrimination lies a recognition that the prohibition of unfair discrimination at the heart of the prohibition of unfair discrimination lies a recognition that the purpose of our new constitutional and democratic order is the establishment of dignity and respect, regardless of their membership of particular groups. The achievement of such a society in the context of our deeply inegalitarian past will not be easy, but that is the goal of the Constitution. But that is the goal of the Constitution should not be forgotten or overlooked. This is of fundamental importance. There is a temptation to say that we ought to have different rules for different races, and our courts have stood fast in saying that that is not the kind of society that we're going to live in anymore. We had a society like that. During apartheid, there were different rules for different races, and it was unconscionable. We will not do that again. So the fact that Mr. Malema, who is black, targets people who are white, doesn't grant him any special protection. That he should be treated exactly the same way that a white person who acts in a racist, hateful way does against black people. Furthermore, the court in Hugo says that the more invasive the nature of the discrimination upon the interests of the individual affected by the discrimination, the more likely that it will be held to be unfair. My Lord had asked earlier about the referral to prosecution. What the Act says at section 21(2)(n) is that after holding an inquiry, the court may make an appropriate order in the circumstances, including an order directing the clerk of the Equality Court to submit the matter to the Director of Public Prosecutions, having jurisdiction for the possible institution of criminal proceedings in terms of the common law or relevant legislation. So it could be done in broad terms like that. It could be done in the way in which the complainant has done, which is to specify the particular areas that deserve investigation. Now, I'd submit that the DPP then has, once it's been submitted, then they can investigate, and it's up to them to decide what they want to do. That all they're required to do by the court is investigate, but they're not required to institute charges. They can apply their own minds, and they can determine whether there's a good case or a bad case to be met. The ones that are identified are a breach of the Rights Assemblies Act. So section 18(2)(b) of the Act provides that any person who incites, instigates, commands or procures any other person to commit any offence, whether at common law or against the statute or statutory regulation, shall be guilty of an offence and liable on conviction to the punishment to which a person convicted of actually committing that offence would be liable. This section has been tested by the Constitutional Court. Constitutional Court has held that it meets constitutional muster, and specifically says for serious offences that things like calling for the destruction of property or calling for murder, that the Act holds, that the section of the Act holds. And so this court has the power to refer this matter to the DPP to investigate. Then there is the issue of perjury. Perjury consists in the unlawful and intentional making of a false statement in the course of a judicial proceeding by a person who has taken the oath or made an affirmation before, or who has been admonished by someone competent to administer or accept the oath, affirmation, or admonition. Now, Mr. Malema took the oath, testified, and I submit that there is reason to investigate his conduct, and I'll deal with the particular evidence that he gave later. But in brief, he was asked whether he and the EFF would be able to make payment of the R500,000 that is sought by the complainants to the organisation that combats racial hatred, and he stated, "I have nothing and the EFF has nothing." Now, the EFF is an organisation that is compelled to disclose its donations in terms of the electoral legislation, and has disclosed that it received a donation very recently in the sum of R3 million. And Mr. Malema is on record as saying that it's well known that he wears famous brands like Gucci. So I'd submit there is good reason on the face of it to investigate that it's a very serious matter when an opposition politician would perjure himself in court, and there appears to be a basis for such investigation. But again, that would be done by the DPP. On contempt, the court in Faki says that for this to be a finding of contempt of court, it must be found that there was an order which came to the notice of the accused, there was non-compliance which was willful and mala fides. So the complainant in this case doesn't seek a contempt of court finding by this court, but submits that that's a matter that could be further investigated. And then finally,
so you're saying contempt? What about contempt?
The complainant doesn't seek a contempt of court finding now, but says that that's an issue that could be investigated, and the contempt relates to the agreement between Mr. Malema and AfriForum in the SCA about what his conduct would be in relation to the singing of further songs. So this court doesn't need to make such a finding now, but it is a matter that could be investigated by the DPP. And finally, criminuria, which consists in the unlawful, intentional and serious violation of the dignity or privacy of another. So, my Lord, what I've endeavoured to do then is set the legal framework so that Your Lordship is aware of what the full test must be, and to give an indication of why certain evidence was led. And now what I intend on doing is dealing with some of that evidence.
But the contempt about, sorry, just before we move from there, the contempt about the finding, or I guess you're referring to the SCA mediation agreement. Isn't that the process that ought to be followed is to raise the contempt with the court affected by the conduct? Isn't it ordinarily like, for example, if this court, if a person doesn't comply with the court order of this court, you then bring an application to this court to say he or she has not complied with the order?
Yes, my Lord, I'd submit that. So there's a recent matter of Liberty Fighters Network in the Supreme Court of Appeal, and the court there made a finding that the head of Liberty Fighters Network had committed act of contempt ex facie of the court, and then directed the DPP to go and investigate it. So I'd submit that, in other words, that contempt process, because it is a crime against the court, against the institution, is the kind of thing that can be dealt with by the DPP, and it might very well be correct that when it does that, it must launch contempt proceedings in the correct court, and it must determine what that correct court is, whether it's in the SCA, whether it's in the Equality Court, and it must, if it decides to go through that, it must meet the thresholds required by FACI, and it can make the determination.
Well, isn't it that in contempt of court, contempt may take various forms? It may be a contempt where clearly it's criminal conduct, where somebody jumps in the middle of the court and insult and do all sorts of things. That would be a criminal offense. But where there is non-compliance with the court order, as I understand, the jurisprudence says that it's a civil disobedience, although the test that gets applied in determining whether there has been breach or non-compliance with the court order it's a criminal standard of proving beyond reasonable doubt. So I'm not too sure whether we're not going to be referring to the NPA some case that necessarily may have to be dealt with the court affected, because it's the court that's affected by that conduct that needs to protect. And I think in Faki, Cameron J states very clearly that it's the dignity of that court that needs to be protected. And it is that court that needs to ensure that its dignity is actually protected. Now, if by his conduct, Mr. Malema has defied what has become the court order, the agreement in the SCA, isn't it surely that you should be approaching the SCA and say there has been contempt of your order, and we want you to stop that behavior?
Yes, I'd submit that the complainant would have such a right, so it could go and approach the SCA on that basis. It may very well be that the NPA has such a right as well, but I'm mindful of your Lordship's distinction between the ex-facia situation and the breach of an order situation. My Lord, at this juncture I'd like to say as well that during these proceedings, and your Lordship gives an example of contempt of court, there were people who invaded this court and were told to leave and refused to leave and sang Dibulu Bunu. I think this is a shocking moment for all judicial officers in this court to see that happen. It's something that I've never witnessed in my life. But outside of court, there were supporters, voters and members of the EFF who were singing, chanting, "Kill the Boer, kill the farmer," at the representatives of the complainant. Now, this is an issue between the parties as to whether this evidence ought to be admitted. I'd like to show this video at this juncture and then discuss what ought to happen with regards to that evidence. So, my Lord, there it's quite evident that the members of the EFF are seeing "kill the Boer." They haven't substituted the term for "kiss." Now, the complainant offered the respondent all of its procedural rights. So after this happened, I think it was on the second day of the matter, this video was shown. It was then shown to the protesters themselves, that the respondents were able to have a meeting with those protesters. They picked someone from that crowd to testify. He gave evidence on it. That Mr. Malema was shown this video. That he gave evidence on it, and that this court directed that the way for it to be included in evidence, because the applicant or the complainant had set out in its application that it reserves the right to supplement its papers, that the correct manner for that to be done was through an application for the admission of the evidence, and the complainant did launch such an application. The respondents have opposed that application, which is sort of strange in the circumstances, on the basis that Mr. Malema was given an opportunity about how that evidence should be dealt with. He was given an opportunity to consult with his lawyers. He said, "I'm waiving that. I'm going to speak to it now. I don't need to speak to my lawyers about this." but he was afforded such a procedural opportunity, that all of the things one would expect one to have were met. In other words, they knew about in advance. It's pertinent information to this case. Mr. Malema's, I think, opening lines when he sat to testify was, "I don't even know why I'm here, because I don't sing Kill the Boer." And so it's very pertinent that that phrase is being sung outside this very court by members of the EFF. And Mr. Malema then gives much testimony about that and what he thinks ought to happen. I'll go into that testimony later. But basically says, there's nothing wrong with those people singing that. He says, I would sing that song, after saying, they've got the wrong man. So, especially given what I stated earlier about the standards for evidence in this court, that the kind of technical point taken by my learned friends has no place here. That to say that it ought to be part of the bundle, it is part of the bundle. It's under oath by Mr. Roots. It explains what had occurred. An application is brought as directed by this court. That whatever rules would apply in a criminal setting, that those rules don't apply in this setting, but that there's been no procedural prejudice to the respondents in this evidence being included. And I submit that this court ought to make such a finding that the evidence is included.
But isn't that a different incident? As I understand, in the papers, the pleaded case relates to a number of incidences where the song was sung, but on the main, it relates to the song being sung at the Senekal hearing. Now, that's quite clearly defined in the pleadings. And that's what was before this court. Now, I'm not too sure whether, if in the middle of a hearing, another incident, very similar or exactly the same, with the one that's under consideration, it means then that the court must then proceed.
Well, my Lord, I'd submit that what occurs is that the papers are supplemented. In other words, to include the fresh complaint. And they're supplemented in the form of this application for the admission of the video.
Is it supplemented or you sought an amendment of your papers? Because I don't recall any application being made to amend the papers.
I'd submit that that's not what was asked of the complainant. In other words, in the discussions between the respondents and your Lordship, that the directive was, and this especially comes out in the transcripts, the directive was an application for admission of the evidence must be launched. And that was the directive, and that's what's been complied with. It's not like a particulars of claim where one would amend, that the way that these are initiated is under oath. And so Mr. Roots, in that finding affidavit...
You can still supplement, you can still amend your notice of motion, even in motion proceedings. The
yes.
right to amend is still there.
Yes, my Lord, it doesn't proceed on notice of motion. That these proceedings...
It proceeds on the, as is required by the Act, but
yes.
That's very similar to whichever way you can compare it either to an action proceeding or notice of motion, but what the legislature has sought to do in seeking to informalize these proceedings is to allow for papers to be filed. Now, my difficulty is, does it mean that because you don't have summons, you don't have notice of motion, therefore, in these proceedings, you could bring in issues and matters as the proceedings go ahead?
Well, my Lord, I'd submit that's exactly what occurred in these proceedings, that throughout the matter, the bundle grew. The bundle grew very late in the day. So, for example, during the evidence of Mr. Malema, I think after cross-examination, he then testified on a video that was uploaded on that occasion of Thabo Mbeki talking about Simbamba. That there was an issue raised about whether the book Treegrond existed, and so the complainant added that to the bundle. That as the matter continued, more and more was added to the bundle, and that during the party's initial meeting with your Lordship, it was understood that this is how the matter would unfold. In other words, these proceedings are different to a civil matter. It would be very strange in a civil matter for that to occur. But in these proceedings, the idea would be that as the matter develops, that more evidence would be adduced by the parties, and both parties took this opportunity. And it seems ignoble for the respondents to now say, well, we used all these opportunities, Mr. Malema said there's nothing wrong with me testifying in this video, and now when it starts to chafe, to say we want it excluded.
Sorry, just bear with me. Thank you.
My Lord, I'd now like to turn to the evidence that was led during the proceedings, and I'll start with the evidence of Mr. Roots. As I stated earlier, the way...
Just while we're on that point, so your point is, just for my understanding, your point is that in the nature of the way the proceedings were conducted, parties submitted further documentation and evidence during the hearing. And similarly, this is what happened with the incident that occurred at the gate. Now, that incident, as I understand it, also had some form or some kind of a hearing of its own, and evidence was laid. Now, you're seeking only to incorporate that evidence into this hearing. The outcome of that process stands on its own. Because if I recall, I did make some ruling on that particular matter.
Yes, my Lord, it was, as I say, at the time, it was that proceeding happened for two reasons. The one was that there was a concern about how these proceedings would continue. In other words, the members of the EFF were blocking access to the court. This had happened early on, and then this incident happened in quite a dramatic fashion. And so the first part was to ensure that the proceedings could continue in a safe manner. What ultimately happened was that the complainants' representatives had to take a separate entrance into the court and be smuggled into the building so that they weren't accosted. But that was the first part of it, was to ensure that the proceedings would go in a civil manner. If I might refresh your Lordship's memory, this concern was raised right in the beginning, on the first day of the hearing, because Mr. Ndlozi had sent out a tweet with the words Dibulu Bunu in relation to an image that Mr. Roots had put saying that we're going to be in court. So there was already a concern that there was going to be a call to action, that representatives of the complainant would be accosted, and this very much is what occurred. And so that was the first part of the proceeding, was to ensure that they go smoothly and civilly. The second part was to say this is essential evidence for this matter. In other words, the complainant says, you are singing the song Kill the Boer. Sometimes you sing it with kiss lyrics, and sometimes you sing it with kill lyrics. And you've denied that you sing kill lyrics, and then you walk outside of court and you're singing, very evidently, Kill the Boer. And a member of that crowd testifies here, and he says, no, we weren't singing kill, we were singing kiss, despite the fact that he was shown footage of the crowd singing kill. So that sort of level of denial, their approach to the evidence, very important that it was canvassed for this complaint. Now, the relief sought in the complaint itself is to say that the song must be declared hate speech, and so this is just an instance of this being sung. It provides, useful additional evidence for this matter, and so the court can make a determination about the EFF singing this song, and this is a particular egregious instance of it.
So it's more of a collateral evidence to your main complaint.
Yes, my Lord.
Thank you.
If I then might turn to the evidence of Mr. Roots. So Mr. Roots is the head of policy and action at AfriForum. He is trained as a lawyer, and he testified that he was in the process of completing his doctorate in law on the question of minority rights. And he's the author of the book Kill the Boer, which was published in 2018 and deals with the phenomenon of farm murders and attacks in South Africa. And the book is the basis for that testimony. As I stated earlier, that book is fastidiously referenced. There's 1,000 footnotes, and is the standard for determining this phenomenon around farm murders and their brutality. The book required 3 years of research, and it involved both academic and field research. Mr. Roots argues that the phenomenon of farm attacks is a unique crime phenomenon for 4 reasons. First, the frequency of the attacks. Second, the level of brutality. Third, the unique role that farmers play in society. And fourth, the practical reality that farmers live far away from their neighbours and police stations. A farm murder is basically an attack that happens during a farm attack, so when someone is murdered during a farm attack. And according to the National Rural Safety Strategy, the definition of a farm attack is that attacks of violence against persons on farms and small holdings refers to attacks aimed at persons, residents on, working on or visiting farms and small holdings, whether with the intent to murder, rob, rape or inflict bodily harm. In addition, all acts of violence against infrastructure and property in the rural community aimed at disrupting legal farming activities as a commercial concern, whether the motives related to ideology, land disputes, land issues, revenge, grievances, racist concerns or intimidation are included. Mr. Roots referred to a list of 1,700 victims of farm murders, which include farmers, their family, farm workers and visitors. Those 1,700 names are included in the book Teruggrond, which lists between the years 1990 and 2012 those farmers that were killed and the dates in which they were killed. I will state then it was bizarre that after having been provided with a copy of this book, the respondents took the view that the book does not exist. Mr. Roots relied both on external and internal sources in establishing the data on which he relied for purposes of his book. The internal sources comprised information collected by AfriForum's own team, whereas the external sources are those figures collected by authorities such as the South African Police Service. And AfriForum has been collecting data on farm attacks and murders since 2013. It employs a media monitoring team which collects and verifies reports of farm attacks and murders from the mainstream South African media. It attempts to contact the families of such reported victims. It also has a trauma unit with 4 full-time employees who perform trauma counselling for victims and assist such victims with preparing to testify in court. The trauma unit is another internal source of statistics, as this unit communicates with victims across the approximately 150 AfriForum branches nationwide. Finally, AfriForum also relies on its network of members. It has now 300,000 registered members across the country. A premium is placed on verifiable and credible information. Mr. Roots testified that if we say there were 79 murders in a year, we have a list of the names of 79 people who have been murdered during farm attacks. I only work with numbers that we can prove. When we say that there were 2,000 farm murders, I mean that there were 2,000 farm murders for which we actually have the names of the victims, which means the actual numbers would be much higher. Mr. Roots referred to 4 main sources of data and statistics with respect to farm attacks and murders, apart from AfriForum's own investigation. The sources are the 2003 Parliamentary Committee inquiry into farm attacks, the South African Police Service reports, individual statements given to the SAPS, and data compiled by TAU. SAPS has published annual reports for several years. However, Mr. Roots noticed that there was a period of 3 years when statistics were not reported. He said AfriForum has a good relationship with SAPS. They meet with them regularly as possible to discuss the crime phenomenon and sometimes exchange data. It is not, Mr. Roots testified that it is not that we are trying to collect this data in competition with the police or to try to prove the police wrong. Our approach is to be a stakeholder and a contributing party in the fight against farm murders. That is why we work with the police as far as we can. We have found that there is significant value in collecting the data ourselves as well. Sometimes we find that the police miss cases. There was this problem of the police just simply refusing to release these numbers earlier, which also made it even more important for us. Now we try to work with the police. Mr. Roots in his book also refers to other sources. I made reference to Land of Sorrow, or Tregrond, which is the translated name. It's a book about farm murders in South Africa which took place between 1990 and 2010. Verification took place either by confirming the crime with the local police station, obtaining reports by credible media institutions about the incident, or by making contact with surviving victims or relatives of murdered victims. Every case that could not be verified was excluded. The result was an extremely credible, detailed list of the incidents that ought to be referred to as a minimum number of the actual incidents. It's vital to put names to the numbers and prevent the analytical exercise from losing emotional impact. It's important to have the discussion about statistics because that is the analytical side of the crime phenomenon. It shows us that you are not making something up. It's an actual problem. But it can become heartless if you only talk about stats. To commemorate the thousands of victims of farm murders, the White Cross Monument was erected with each cross representing a farm murder. And, my lord, at page 49 of the book, there's an image of this hill filled with white crosses, each representing a person who was attacked and murdered. Drawing on the above sources and analysis, Mr. Roots can conclusively establish that farm attacks and farm murders are disproportionately frequent in comparison to the general murder rate. In the report of the Committee of Inquiry on Farm Attacks, it stated that in the year 1991, there were 327 farm attacks which resulted in 66 farm murders. 10 years later, in 2001, a total of 1,011 farm attacks were committed, resulting in 147 farm murders. This amounts to an increase of 209% farm attacks and an increase of 122% in farm murders. During these 11 years, 6,122 farm attacks and 1,254 farm murders were committed. And at page 33 of the book, there is a graph which illustrates this. If the reference by the SAPS to at least 12,245 farm attacks and 1,700 farm murders in 21 years is used, and the 3-year statistics gap, which no statistics allegedly exist, is excluded, this would imply an average of 680 attacks and 94 farm murders per year. This is basically 2 farm attacks a day and 2 farm murders per week. Mr. Roots referred, in addition to the data and stats collected by SAPS, as presented graphically in this book, to AfriForum's data. My learned friend takes a point in his heads of argument where he says Mr. Roots doesn't have a degree in statistics. And he asks Mr. Roots this question and implies that, well, you need a degree in statistics to produce these graphs. Now, I think maybe there's a reason why many lawyers studied law, is because they're not very good at mathematics and they see it as a very mysterious thing. To be a statistician is a very niche thing, and it requires an understanding of probabilities. It's a forecasting exercise. So, for example, in this court, it would be probably quite common to encounter statisticians in the form of actuaries who will do a diagnosis about someone's future loss of earnings, for example. And they'll say, given what I know about you now, and given the probabilities of how your life will unfold, I think your loss of earnings will be X. That requires a degree in statistics. That is a difficult exercise. What Mr. Roots has done doesn't require a degree in statistics. It requires taking data that is known and graphically representing it in the graph. So we're all used to seeing bar chart graphs because of COVID, where you count the number of, let's say, COVID deaths in a particular day. The next day you count more deaths, and then you can see a wave that occurs. And that's exactly what Mr. Roots has done. In these graphs, you have a wave pattern, which is basically just saying, this is the data that occurred on this occasion. And Tregrond, for example, does exactly that. It says, on the 3rd of January, 1992, this person was killed. And then you plot that number. And then you can produce a visualization of that. That visualization exercise doesn't require a degree in statistics. Mr. Roots says we can include as many data as we can. This was the amount of victims. This was the amount of attackers. This is the time it happened. These are the weapons that are used. This is the modus operandi that was used. We include all of that. We also add when it was reported to the media, which does not always happen. We add also links to the news reports. Our list is very comprehensive in terms of information about every incident. AfriForum takes a conservative approach to counting. It says that it's probable that there's an undercounting of attacks. I can guarantee that the actual, Mr. Roots says, I guarantee that the actual number of farm attacks would be much higher. We just don't know how much higher. If we err, it would be on the side of downplaying rather than exaggerating it. Now, on calculating the farm murder rate, Mr. Roots made it clear that raw numbers are insufficient to drive home his point regarding the farm attack phenomenon. He refers to a number of premises and comparative statements that are useful to refine and extrapolate the seriousness of the phenomenon. So, for example, South African farms were 16.7 times more likely to be attacked than South African households were likely to be robbed.
Mr. Hoffman, can I interrupt you for a second, if you don't mind? I'm just concerned and worried that we're going to end up needing another day for this. I always complain in this court that counsel has got a tendency of saying, we give you this work to go and prepare and read. You spend your sleepless night reading, and then you come back in court. That's now been read back to you. Is it not any other way that you could just talk to those? Because this is one case where I would say preparation has been done, and very useful heads have been put before me by both parties. So I'm not sure whether it's the best use of the time, and as I told you, I have some other time pressure today, that you can talk to these issues, and if need be, you may just refer me to the paragraphs. Your heads of arguments are paragraph numbered. You can tell me and say, look, I would like the court to particularly focus on this paragraph, rather than having to read the heads of argument sentence by sentence, paragraph by paragraph.
I understand, my lord. I will endeavour to deal with only the salient details and make the references as necessary, and I will ensure that we finish by today, my lord.
Okay, thank you.
So, my lord, really on this question about the farm murder rate, the idea is to point out that there is a dramatic difference between the general murder rate in South Africa and the rate experienced on farms. So the murder rate in South Africa is 34 out of 100,000. The way that rates are described is in terms of 100,000, and that shows you, out of a population of 100,000, how many people are murdered on average. Now, the distortion with that general statistics is that it includes all murders, but a large percentage of those murders are what are called social fabric crimes. So a social fabric crime is, let's say, a bar fight or a domestic violence interaction where the parties know each other. These are different from intruder attacks. So, in other words, if someone breaks into your house and kills you, that's not a social fabric crime. But all farm attacks are intruder attacks. It's necessary in the definition. It's not a situation of a farmer killing his wife. That would be domestic violence, not a farm attack. And so we know that if we exclude the social fabric crimes, the true murder rate in South Africa is between 5 and 14 out of 100,000. Now, if we look at the farmer murder rate, so this is a proxy that Mr. Roots uses, which is basically to say how many commercial farmers are there, how many commercial farmers are murdered, and he says that if we look at that rate, what we see is that it was 98.8 out of 100,000 in 2011, 132 out of 100,000 in 2014, and 156 per 100,000 in 2016. So this means that the murder rate is between 3 and 5 times the national murder rate, and many more times if social fabric crimes are excluded. So we're dealing with a crime phenomenon that is just dramatically different from all the other crime phenomena in South Africa. Now this is very important because Mr. Malema makes this statement in a speech where he says there are no farm murders. No white people are being murdered on farms. And then wants to sort of say, well, you know, there's just the phenomenon of murder. These things are all the same. They're not the same. You have a minority group that's being targeted and killed in proportions that are much, much higher than the national murder rates, and that's something that's important for the context. Now, the other thing that we find that's different about these attacks from ordinary crime is the brutality and the violence that's entailed in the attacks. That Mr. Roots describes it as overkill. That what is done is beyond what's necessary for the mere committing of a crime. In other words, if the reason why someone wants to commit the crime is to steal a car or steal money, that there's no need to torture someone for hours. And this implies that really the spoils of the attacks are a bonus. In other words, the primary aim is to torture people to death, to kill people. It's not to get the few £100 out of their wallet. Now, some of the kinds of tortures that are perpetrated against the victims include beatings, stabbings, and burnings with boiling water, molten plastic, and hot irons. There are cases where people are dragged by a rope from behind their vehicles. People are burnt, stragged, gagged, and they're faced with firearms. And it is the case that torture is accompanied by, in 20% of these attacks, there's torture. And in my heads of argument, I detail some examples of this, and I'll read out a few. The Viana family, the wife was raped, her husband was murdered, and their minor son was drowned in a bathtub of scalding water. In the De Villiers family, the parents were murdered, their disabled son's eyes were gouged out, and he was left for dead but survived. The Swanepoel couple, the elderly wife was raped while her husband was forced to watch before being killed. They were tortured for hours. Roger van Parijs survived after having a sword shoved down his throat after hours of torture in his house. Nikki Simpson survived hours of torture with a drill and the killing of her dog. Her vehicle was stolen only to be found abandoned. All of this implies that we're not dealing with an ordinary crime phenomenon, that we're dealing with something that requires special attention. And that context is vital for when we're looking at the words sung by the respondents. There's also this phenomenon which I alluded to earlier of denying the phenomenon. Now, Mr. Roots testified that the impact of denying that you've got this phenomenon is particularly egregious. He says, a father had to bury his daughter who was murdered in front of his grandchildren. It was a wife who was murdered in front of her children, then she was buried by her father. What should someone like this think? So you've personally experienced members of your family being tortured to death. And Mr. Malema says, it's not happening. There are no such things as farm murders. That just adds salt to the wound. The singing of the song takes place in a political climate that romanticizes and encourages the suggestions and actions depicted in the lyrics from influential public platforms. Now again, if we look at the test set by Kolani, knowing the context is important, knowing the speaker is important. What's the status of the speaker? This is not a retired estate agent from the middle of nowhere like Penny Sparrow. This is the leader of the third biggest party. This is someone who testified that he will be president. And how is he doing it? In mass public rallies. The singing not only takes place in such a climate, but plays a determinative role in creating it. The harm and victimization experienced by families and survivors is magnified by the singing of songs like Kill the Boer in public, as well as the use of slogans like One Settler, One Bullet. Mr. Roots testified that to argue that all farm murders are motivated by racial or political factors would be inaccurate. But it would be equally inaccurate to suggest that the political climate that exists in South Africa today is irrelevant when it comes to the safety of South African farmers. And he identifies Julius Malema as the most influential figure in propagating this view, and the EFF in being the most influential group in this regard. The message that's being sent is this group matters less. That if a white farmer is killed, it doesn't matter as much as if someone else is killed. They are rendered subhuman, they are dehumanized, and that it's okay to call for their killing and to say, well, this is the climate we live in. Now, with regards to the motive, we know that there can be multiple different motives, but not all of those motives are discrete. So, for example, one can have the motive of theft while also being motivated by racial hatred. And that racial hatred can manifest in who is targeted. So, In other words, if one's deciding who it's okay to rob, and one says, well, these people don't matter, there are only white Afrikaners, we can go after them, that target selection shows that there's a racial hatred. When those people are tortured to death, that's evidence of racial hatred. And there are also particular instances of people confessing to this fact. Mr. Roots gives the example of Knowledge Mandlazi, who was charged for committing 5 farm murders. He responded in court that he had murdered these people because he wanted their money, and added, and this is his quote, "My hate for white people made me do it." And he said that he regarded murdering white people as merely going to work. Now, I mentioned earlier that the organization that the complainant says ought to receive the R500,000 is the Potgieter Foundation. And it's named after Wilmien Potgieter, who was a 2-year-old child who was murdered during a farm attack. And her father was stabbed 151 times in front of his wife and then executed by gunshot. And a sign was then hung on the gate which says, "We have killed them, we are coming back." That's not ordinary crime. That's sending a signal. That's saying, you don't belong here. And we're coming for the rest of you. So that's the climate that we deal with. Mr. Roots deals with what he calls the zeitgeist in South African society, and he says that from the early 90s, there's developed a culture where it's okay to vilify white and Afrikaners in particular as constituting a source of evil in South Africa. It's a climate in which white farmers are depicted as racist criminals who stole the land and exploit the workers. In the political sphere, the white farmers become a personification of the Afrikaners or the Boers, and the Afrikaners or the Boers have become the personification of everything that is wrong with South Africa. Consequently, white farmers are repeatedly slandered from political platforms in speeches and in statements and even in struggle songs. It's been argued that white farmers acquired what they have through violence and that there is no qualm about responding to this violence with physical violence. As a result, violence towards white farmers is frequently romanticized, especially in struggle songs. These songs are not merely sung by fringe groups, but by government leaders. The slander often takes the form of ascribing collective guilt to the white Afrikaner population and the notion that a group should be denigrated for historical misdeeds. Such groupings, as done by Malema, involves tarring with the same brush young and old, male and female, all Afrikaner people into a single entity which is collectively guilty and deserving of violence for such historical crimes. Mr. Roots argued that such collective group blaming is analogous to Nazi propaganda against Jewish people prior to the Holocaust. It's exactly what the Nazi Party did. Is that they would go and identify particular Jews who they said had committed crimes, and they would say all Jews are responsible for this. This is an evil people and they must be eradicated, and they were. So there's a danger when you vilify groups, when you ascribe collective guilt, when you can say, and Mr. Malema testifies, he says, Afrikaners today are the same people as 370 years ago. In other words, people of today are equally responsible for things that happened 370 years ago. And this vilification technique, this stereotyping, this ascribing of collective guilt, is incredibly pernicious. Whites and Afrikaners are often portrayed as visitors to Africa rather than citizens of South Africa with an equal stake in the country. The idea is that they are land thieves who are responsible for all ills and misfortune that black people experience in modern times. This train of thought leads to the grouping of society into victims and perpetrators. Mr. Ruth testified that to take every possible negative attribute that one can find, or any possible atrocious deed committed by people who are white and at some stage in history, and then attributing it to that entire group and saying, well, this is what you did. In other words, when Mr. Malema says this, he talks about the group of white people. And then he says that white people have to be punished, have to carry the consequences, have to fix what they did. So it's presenting as if just one homogenous group and everyone is equally guilty, because he's not applying that logic to the good work that is done. So there's a mismatch. In other words, if you have a member of the group who does something beneficial, that's not attributed to the rest of the group. But any misdeed done by a member of that group is attributed to the whole group. and that whole group must be punished. Mr. Roots referred to the writing of Farrell Huffagy, who was the editor-at-large of the Huffington Post, who stated that black obsession with whiteness and white privilege is all it seems we ever talk about in sustained ways in our national conversation. To my ear, it sounds as if whites are spoken as if they were the majority in power rather than a small group of varied political sentiments. Now, in my heads of argument, I detail instances of other politicians who have added to this climate. I won't go into the detail now, but the point of that evidence is to say that there is, we think about South Africa as a boiling pot, that all of these other actors are adding to the flames, adding to this sense of a tinderbox moment where further speech can be used that will ultimately lead to eruptions of actual violence. And that context must be taken into account. Mr. Roots does have a positive message about what we ought to do. And he says that this notion of collective guilt is inimical to the values of the Constitution. And he says we should be working together about unity and diversity and all the things that are increasingly under threat. People should be judged on the content of their character and not the color of their skin. Section 1 of the Constitution states that South Africa is a nation founded on the value of non-racialism. And I mentioned this earlier with regards to Judge Sutherland's judgment in the Kamalo case, that it's fundamental to the success of our society that we treat each other in this manner, that we don't judge people based on the amount of melanin in their skin, but rather on the content of their character. Mr. Roots gives a specific incidence of someone who committed an attack, who then claimed that the reason why they committed that attack was because of the song Kill the Boer. He refers to the case of Godfrey Hewer, a farmer who was murdered in front of his wife Amy on their farm near Vryheid. The perpetrator was a man named Ntukuku Chwene, who was 28 years old. He was found guilty of and convicted of murder and sentenced to life in prison. He later testified to the Truth and Reconciliation Commission that the singing of the song Kill the Boer influenced him to kill. He said that I could have killed any other white man I came across at that time. My frustrations were directed to white men because they had what we did not have. Mr. Roots also then testified about the use of the song Kill the Boer and shows that it was popularized by Peter Makaba, who was a former president of the ANC Youth League. And in reaction to the singing of the song, Makaba said, "Let me make it clear what I said was kill the farmer, kill the poor, shoot to kill. This is our culture, this is our tradition. Those who disagree can go to hell." Mr. Malema was mentored by Peter Makaba and says that he shares all of his ideas. He testified that we should replace Paul Kruger's statue in Pretoria with Peter Makaba's statue. And those are the events that led to the Human Rights Commission's finding that those words constituted hate speech in 2003. Now, as I discussed, the Lamont judgment deals with a prior instance of Mr. Malema singing Dibulu Bunu, and that was in 2010, and the courts there made a finding that the words constituted hate speech. Now, my learned friend takes an interesting point in his heads of argument, which is not raised in the responding affidavit, which is this notion of res judicata. He says, well, another court has dealt with these parties and these facts, so therefore this matter is res judicata. Now, this is analogous to someone who assaults his girlfriend, goes to court, is found to have committed the crime of assault or the civil wrong of assault, and enters into a settlement agreement where he says, I won't do it again and I'm sorry. 10 years later, he assaults the girlfriend again. Is brought before a civil court, and he says, we've been here before. This is res judicata. Cannot be the case, my lord. That the facts in the Le Monde judgment are from 10 years before. The facts are different now. There cannot just be a finding of res judicata. I thought I would raise it at this juncture to point out that there's a strange obsession with technicalities, but such a plea is the kind of plea that one would expect in the pleadings. It's only raised an argument, and of course, there is no substance to it either. Mr. Roots also testified to provide some further context to Mr. Malema's speeches.
Well, it would be slightly different if just for my own clarity, it seems to me it would be different if the judgment in Judge Lamont's judgment had actually not only found that the song is prohibited, but banned the song for life. Then it seems to me in that instance, one could then probably plead res judicata, that the matter has already been determined and your relief would be different to come into this court in the form of this. Am I?
Yes, so in other words, you ought to be correct that if there was a general ban on the song, and then the applicant approached this court and sought the identical ban that was already present, well, that would be res judicata. But that's not what occurs. In other words, what there is to say, you must be found liable for committing an act of hate speech in terms of this act, which you've done on repeated occasions. That can't be res judicata. It's a new instance.
Well, that seems to be very similar to what the counsel for the respondent argued with the incident happening outside. If I recall, one of the arguments was that that incident is distinct from the incident that's before this court. So my understanding of his argument was that if you need to address your complaint about what happened at the gates of the court, you must now lodge a different and separate complaint. So that's the point about the res judicata not really being applicable in this kind of situations.
Yes, my lord.
Okay.
My lord, I see that it's 5 to 12. This might be a good juncture for us to take the lunch adjournment as discussed earlier. To provide further context as well, in the papers we reference speeches made by Mr. Malema, and one of the most notable speeches was in front of the Newcastle Magistrates Court after he'd been charged for inciting people to invade private property. He stated, "We are not calling for the slaughter of white people, at least for now. The rightful owners of the land are black people. No white person is a rightful owner of the land here in South Africa." And responding to the criticism of this speech, Mr. Malema stated that, "My wish is to see de Klerk suffering for a very long time for the crimes they committed against black people. It belongs to you. It is your land. It is the land of your forefathers. It is a land that was taken from us by white people by force through genocide. They killed our people. I'm asking politely for the land to be returned. And if they do not return it, I cannot guarantee what will happen. And the EFF is coming for you, boy. Just pray. Just pray to your ancestors. Pray to Milan. Pray to Verwoerd. Pray and ask them for EFF not to come into power. Because we come into power, Afrikaner male, this side. This is where you belong. We are not scared of Afrikaners. This is not your land. You must know your place. You are visitors here. And the long stay of visitors depends on their conduct. If you continue to misbehave, feeding our people to lions, putting our people who are still alive in coffins, then you are applying for something else." Malema reiterated, "We do not back whites. We do not care about their feelings. They have made us suffer for a very long time. It is our turn now. They must be happy we are not beating them up. They must be happy we are not calling for genocide." Such statements reinforce the notion of group criminality, that simply based on the color of your skin, you are by definition a criminal and deserving of violence. Based on the color of your skin, you have to be treated like a criminal because all whites are land thieves and criminals. Mr. Roots also provided testimony about this correlation between the singing of the song and actual farm murders. As I stated at the beginning today, my Lord, this is not a requirement that the complainant needs to meet. In other words, it's not necessary to show that there is a causal link between the two. But it is important to be aware of the fact that there is a correlation, and this was taken into account by the court in Kwalani, saying that there's this correlation between hate speech and prevalence of attacks on members of the gay community. So it's something that the court can take into account, but it's not a threshold that needs to be met.
But isn't there a difference between those attacks and the evidence that's before this court? Because in the Kolani matter, as I understand, there were cases where the attack were specifically and very particularly could be seen to be targeting those people because they are gay or lesbians. Whereas here, to a very large extent, the evidence is they are farm murderers, and those murders may be related to the singing of the soul. So the question would be, is there any direct evidence to link the two? As I see it, there's very little connection between the murders in the farms and the singing of the soul. But that's not an issue, and you've already addressed me on it. I don't want us to go back to it. That's not the issue in determining whether the singing is prohibited or not. It's a prohibited statement.
Yes, my Lord, well, it goes to context. In other words, so the complainant doesn't have to prove a causal link, but the kind of evidence that the court dealt with in Kwalani was to say, is there a correlation? In other words, we can't prove causation between the publication of this article and violence against the gay community, but we can see that as these sorts of statements rise, we also see, violence rising.
It's a context in which the events are taking place and the threat that may, or the risk that may arise from the singing of the soul. That's my understanding of your case, because also here we're not dealing with your typical criminal case where an event has happened where somebody is being shot. You then have to prove that this person was killed beyond reasonable doubt, and these are the reasons. Here, what the legislature seems to envisage is to actually address the risks that are associated with hate speech, rather than saying, let the hate speech occur and then bring these people to court to be charged. It's saying, it's like a, a mitigating factor or anticipatory fact that the policies sought to address.
Yes, I think that's a good way of putting it, my Lord. So in other words, it's an aggravating circumstance if the environment in which the hate speech is being uttered is an environment in which the targeted group is being murdered disproportionately. And so that goes to that context. And Mr. Roots gives evidence of, as I say, incidences where the song is sung and incidences where people are murdered soon afterwards. And he shows this in relation to Mr. Malema's singing of the song in 2010, and then also a sharp spike after the song was sung by Peter Makabe in 1993. I'll deal with some of the issues that came up in cross-examination of Mr. Roots. One of the points taken by my learned friend regarding Mr. Roots's credibility is about a statement made regarding information that was published on Mr. Malema's Facebook page. And I had, during the trial, sort of wanted clarity about the difference between a page and a profile. And it said, in other words, there's a distinction because the one is personal. In other words, you can have a one that is administered by a person and they can create friends, and the other one would be like a business type website, but that can also be done in someone's name. And Mr. Roots clarifies that what he saw on this page, he has no idea whether it's administered by Mr. Malema, but it is sort of like a business page that says Julius Malema, had at the time 12,000 followers, and there were various posts made by supporters of this page on that page. And the point of his testimony was to say this gives us an indication of what the supporters of Mr. Malema believe. So the kind of claim made by my learned friend in his argument is that there's a false accusation made that Mr. Malema has a Facebook profile when he's not on Facebook. Mr. Malema, when shown what Facebook looks like, readily admitted.
But
well,
Mr. Opperman, I thought ultimately it came down to the fact that somebody has posted on a Facebook, and that posting seemed to link to the question of the risk that we've just alluded to earlier. It seems that's where we are.
Yes, exactly. That's exactly the point of it. It's to say that this gives us an idea of the climate, that we've got supporters of Mr. Malema.
Let's then move on from that one then.
Yes. I'd then like to turn to the evidence of Mr. Human. So Mr. Human was testified as someone who works at the trauma unit of AfriForum, and he said that the trauma unit goes out to visit victims of farm attacks to debrief them and help them overcome their emotions and lead normal lives, and that he's personally worked on 25 cases and supervises a further 60. And he uses cognitive behavioral therapy to assist victims and their families to take back control of their lives, he says, so that they can look life in the eyes again and start living. And the purpose of Mr. Human's testimony was to kind of, we start Mr. Ritz's evidence as a really bird's eye view, giving us the stats, telling us the magnitude of the problem, the murder rates, how they differentiate, and then giving us some instances of particular attacks. Mr. Human fits in the next layer to say, well, I've surveyed a number of people who've survived these farm attacks, and I can tell you what the impact is on them. And so that evidence is similar to the kind of evidence led by Mr. Mokwena from Power in the Kolani case, giving a sort of psychological view of what's entailed by these attacks. And so during these trauma sessions, the victims can tell Mr. Human what they went through, and they can narrate the circumstances of what they went through. And he also points out that this process isn't just directed at people who survived the attacks, but also at the farm workers as well, and that the unit has assisted a number of farm workers who had been tied up in a garage by the attackers. And he testified that the nature of these attacks, it affects individuals, but it affects the structure of that community as well. It affects the family life, it affects trust within the communities. These are the kind of attacks that have a broad social impact. He specifically says that it is felt by people that are both black and white. The attacks create shock, fear, and disbelief in the community. They undermine the strong social and cultural bonds that were established. People become hyper-vigilant, and they don't know who they can trust. They feel powerless. And the trauma creates a memory, and these memories can further re-trigger the trauma. So this is an important point to note, which is that when someone has endured a traumatic event like surviving a farm attack, that there are certain things that can re-trigger that memory, and it can bring back memories of the trauma that they went through. And I mention this because if we think about the test set up by Kolani about what are words that are harmful, it's in reference to this. It's not just that one hears the words and is temporarily sad or angry or offended, it's that it causes a deep psychological trauma, and it severely undermines one's dignity. And this is the kind of evidence that Mr. Human gives of the deep psychological trauma that persists in people who've been attacked. And then there's evidence later, which I'll get to, Mr. Prinsloo, about how he feels when he hears people singing this song and the re-triggering of it. Mr. Human also went into some detail about the violent methods that were used by attackers, and he outlined a series of real cases. Gives an example of someone who was shot repeatedly with an assault rifle while being attacked, a woman who was burnt with an iron, people who were tortured by being doused with hot water, pesticide and diesel, a woman who was raped multiple times in front of her daughter, a teenage girl who was forced to parade topless in front of her attackers and humiliated and terrified that she would be raped. And that victims experience flashbacks of what happened to them that can be brought on by the triggers, and that they cannot escape the fear and anxiety. People never forget what happened to them, and they can be triggered for months or even years. Extreme trauma cases, extreme trauma causes people to become depressed and feel that they should not go on with their lives. He says that post-traumatic stress disorder has a long-term effect on victims' lives. They struggle to work and they avoid returning to where they were attacked. They become anxious, hypervigilant and withdrawn from their friends and community. People never forget what they went through, and extreme trauma can persist for 3 to 6 months, but for some it's even a year or longer. He says victims report being re-traumatized when they hear about people singing the song "Kill the Boer, Kill the Farmer." They feel the same emotions which they previously did. They feel anger towards those that are insensitive to what they've been through, and that politicians are unaware of what they experienced. Mr. Human testified that there is more than just talking about who is right and who is wrong about farm attacks. These are human beings that are suffering. These are communities that are suffering. Complainant then led the evidence of 2 people who themselves had survived farm attacks. And that evidence outlines in some vivid detail what it is to be attacked. Mrs. Miller talks about intruders invading her home, shooting her husband in her head, in the head, that she survived and her children survived. Her husband was in rehabilitative therapy for a long period of time, miraculously survived despite being shot through the head. And this is meant to sort of give us an indication of what is being called for. When the respondents say, "Kill the Boer," what are they calling for? It's not something abstract, it's something real, something visceral, something that happens in South Africa. Mr. Prinsloo gave evidence about the attack against him and his wife, and he talks about how when the attackers came in, they shot his wife, she died in his arms, they paralyzed him. He memorably testified while having to walk in on crutches, and he describes in some detail the nature of that attack. And when asked about the motive, he says he finds it difficult to believe that the motivation was robbery because they did not look for more money in the house. They did not ask for the safe keys, and when they initially entered the room, they shot to kill and only asked for money afterwards. And when asked about the after effects of the incident, he testified, "It's very difficult to really explain because your whole world has crumbled in 1 second. You've lost your wife, you've lost your mobility. My children were so traumatized that my eldest daughter decided that they were going to immigrate to Australia and they left." He says, "Even though you're forgiven, you can never really erase what you've experienced. I've enjoyed my work so much that it was really an extreme loss for me not to be able to function at the level that I used to function at. So I'm still working, but obviously very limited in what I can do." And he said that he had a very good relationship with the community, and they were very upset about the attack on him. And he mentioned that he speaks isiZulu fluently, and I think your Lordship had asked him questions in Zulu, which he responded to. He was asked specifically what his response was to hearing parties like the EFF singing songs like Tivulu Bunu, or Kill the Boer, or Kiss the Boer, or Shoot to Kill. And he testified that it upsets him because he remembers what happened. Secondly, he testified that youngsters are influenced and affected by the singing of such songs, that they follow that example and think that's the right thing to do. When asked whether he had any personal feelings when hearing the song, he testified the following: "We had planned so many things for us, because I was not very far from retirement, and I had a good marriage, and everything just disappeared in 1 second. People ask me how things are going. I'm living from day to day. I'm in constant pain because of the injury. I cannot enjoy any of the things that I used to enjoy. It has taken away my whole life. So that is the feeling that I get when I see these things. I'm reminded of what I've lost." That's vivid testimony of the words causing harm, of re-triggering someone who's gone through a traumatic event and bringing back the trauma. The complainant then called Mr. Gabriel Kraus to give evidence, and the importance of that evidence really was to set the scene at Senekal. And he testified why there were gatherings in Senekal, that it was after the murder of Brendan Horner, that, as I stated earlier, Horner was murdered in a very public way, or that his body was put on public display. Mr. Krause testified that a group of vigilantes had attacked the court on the 6th of October, and he described this as an unacceptable act of mob justice performed by vigilantes. And he said that the farmers in that community described them as outsiders, as not members of the community and not sharing their values. They expressed the suspicion that they may have been paid to make the farmers look bad. Former President Motlanthe had warned that more friction in Senekal could lead to civil war. Mr. Malema's response in Newsroom Africa was, so be it. So that sets the scene. In other words, it's an incredibly heated tinderbox situation. You have a member of the community who's murdered, he's young, his body's put on public display, there's further friction caused by external vigilantes attacking the court, and then the EFF arrive on the scene, and this is the scene in which they sing, kill the farmer, kill the Boer, and they don't sing kiss. Mr. Krause had said that he personally didn't feel safe performing interviews there in his function as a journalist, and he witnessed the crowd singing kill the Boer, kill the farmer, and he witnessed Mr. Ndlozi singing the song calling for fires to be set. He said that when figures like Julius Malema speak as figures of authority, it creates the effect that ordinary South Africans will stigmatize white people. People wearing EFF insignia threatened Mr. Krause with violence, and he was told they should only interview white people, that he should move to the other side of the gathering because this is where whites belong, and that if the Daily Friend, being the publication that he works for, wants to interview members of the EFF, interviewers should be black. He said a member of the EFF crowd hurled a piece of broken concrete in the direction of the anti-farm murder protesters, and that members of the EFF accosted a young man wearing an ANC Youth League t-shirt. They said it was wrong for him to wear it, and that the ANC is a racist organisation. They pulled off his shirt and set it on fire. Mr. Krause testified, it does not actually take most South Africans to have a civil war. It just takes a few highly organised, highly vocal South Africans that are willing to do violence, to drive wedges through social salient cleavages, and to abuse our history to serve their own nefarious immediate agendas. It only takes a few to bring this country to its knees. I'm sure everybody knows that from the experiences in July last year, referring to the riots, and from the xenophobic problems that we've had since 2008. That was the evidence laid by the complainant. My Lord, I'd submit that that evidence was all necessary for this matter. Part of it is it follows the same structure as the evidence in the Kolani matter. It provides a full context from a bird's eye view down to a personal situation. Particular context is provided about one of the occasions in which the respondents sang the song Kill the Boer at Senekal. And knowing what it's like to survive a farm attack is vital for this court and vital for the public to have a sense of what situation people find themselves in and the sort of danger of this vilification. Mr. Malema then testified, and this testimony is enormously useful for getting a sense of what his views are and what the party's views are about race relations, about the use of violence, and about the use of this song. He testified that it would be not wrong at all to sing Kill the Boer, that he would sing it, and that the EFF should be free to sing it. On the message of the words shoot to kill a man, he says, when we say shoot to kill Nyamazane, we are commanding Nyamazane to shoot and kill. He acknowledged that it is a command to shoot and kill. He says MK guerrillas were called Nyamazane. The message in the chant is very clear. Shoot to kill Nyamazane, shoot to kill the enemy forces who are standing between us and our freedom. My Lord, at this juncture I'm at page 58 of the heads of argument. My Lord will note that I've used inverted commas to show when it's an exact representation of Mr. Malema's speech. And the heads of argument are very detailedly footnoted to the exact parts of the transcript. He says, if I want to sing, my Lord, kill the Boer, kill the farmer, I will sing it. I said to you, I do not sing it. It does not mean I will not sing it. I can sing it. Anyone who sings it will be well justified to sing it. It is a struggle song. When asked about the miming of the firing of guns while chanting shoot to kill, he testified that if everything was meant in a literal sense, we would have taken guns and shot them in the air. When asked if he would stand on a stage with a real gun and shoot, he testified that there is a criminal case before the East London Magistrates Court where it is alleged that he shot a firearm on the stage in an open space where there was a public. He testified that Kiss the Boer is sung to offend racists that are upset by black people kissing white people. Now, the test as set up by Kolani about who determines the meaning of the words is this court. It's not a matter of experts, and it's not a matter of the person singing it. Judge Lamont has already considered this question as to what could be meant when someone says kiss. And I'd submit that Mr. Malema's account of it is a false account, the idea that it's about offending racists. That the rest of his demeanour and the rest of his language and what he says throughout this testimony indicates that what is clearly meant is that kiss is coded language for kill. And that he has no problem with using the words kill. He said people should be free to sing it. With regards to the members at Senekal, he says he does not know if the people wearing EFF t-shirts and chanting "Kill the Boer, kill the farmer" were members. So you must pay 10 Rand to get a membership card, and they were not displaying their cards. However, he refused to condemn them for singing the song. So there's this funny technical move to say, well, all those guys who are at my rally who are wearing EFF hats and EFF shirts, well, I couldn't possibly know if they were members because I didn't see their membership cards. He did a similar thing later with regards to the protesters outside. He testified that he exercises influence over his members, supporters and voters, and that all three categories of people were present outside of court. After being shown the video of those people outside of court chanting the words "Kill the Boer, kill the farmer," he suddenly denied knowing if they were members or supporters. But he refused to denounce their singing of the song and said, "I told you I can sing it myself." He then said, "When I mention the word farmer, I see a white person." He said there were small pockets of black people in the farming community who were playing a very insignificant role. So given Mr. Malema's testimony that when he says, "When I hear farmer, I hear whites," it's odd to me that the respondents would take the line that they don't know who's being referred to. They describe the Boers as a mystical people, and who knows who's being referred to, when all the other tribunals and courts that have dealt with this question of who are Boers know that it's people who are Afrikaans, who are white, who speak Afrikaans. And here, even on the term farmer, Mr. Malema says, talking about white people, and that's his own testimony. When asked if he saw a risk that chanting "Kill the Boer" would influence people to go and kill, and whether that would stop him singing the song, he responded, no. When questioned by the court, he acknowledged that singing the song mobilizes and activates people. He accepts that whether the use of the slogan is a chant or a song is still a form of communication. This is meeting the thresholds of the test. In other words, is it incitement to harm? Well, he acknowledges that it's motivating and activating people, and that it's a form of communication prohibited by the Act. He says, its meaning, my Lord, is the attack on the white system. Let us not make a mistake about it. It's not like we're just singing in jail. We are singing with a clear conscience in our mind that if opportunity prevails, we will bomb the union buildings. Now here, this is interesting, because this line of, well, it's metaphorical, it's about the system, he concretizes it. He says, when I say we're attacking the system, what I mean is we're going to get a bomb and we're going to blow up the union buildings. In other words, it's not an abstract thing. It's something very specific that he has in mind. When asked if the evidence of Mr. Prinsloo, that when he hears the song, it brings back the memory of the day that his wife was murdered and he was paralyzed, would motivate him to stop singing the song, he replied, I said I am not moved. Let me repeat 5 times, I am not moved by that case you brought here. I am not moved. And if that will make me lose a case, let me lose it. I am not moved. He testified that the song Our Mothers Are Happy When We Hit the Boer referred to mothers as a rhetorical device to justify killing people. They became happy with us because they were at a point where they could no longer tolerate that which was happening to them. We use them to demonstrate that if it can be approved by mothers, it means it is a justified call. Mr. Malema attributes genocide, wars of dispossession, and the killing of children in 1976 to white people. He stated that all white people are criminals and ought to be treated as such. He said that white people of today are the same that arrived in South Africa 350 years ago, and they remain land thieves. He holds white people as a group liable for the sins of their fathers. He says it is unfortunate that we find ourselves in a society where we coexist with such people who look at us and think of us as non-thinkers. When asked what it would mean to get rid of white people, he responded, so if we go into a conference and we go into Parliament and make a constitutional amendment that all whites must be driven to the sea and any white who remains here is going to be killed, then we engage in that type of program to drive all whites in the sea. It is an institutionalized decision, and that arises out of a particular collective decision. At his speech in Newcastle, Mr. Malema said, we are not calling for the slaughter of white people, at least for now. He said this meant that he was not ruling out the possibility. When asked to pledge that he would never call for the slaughter of white people, he said, "I will not do it." He said, "Madiba coerced us into reconciling the people we have never been one with. That was a myth. It is unrealistic. You cannot reconcile if you have never been together." So all of this evidence gives us an indication of what Mr. Malema's views are. In other words, this line that the song is about land injustice just doesn't square with the rest of his evidence. That when asked a simple question, to say, can you now say you will not call for the slaughter of white people? He says, no, I can't do that. The simplest of things. What human person, anyone with a sort of sense of humanity could say, I'm going to call for the slaughter of a racial group at large? Any reasonable person would say, of course I would never do that. But Mr. Malema would not take such a pledge. With regards to denying farm murders, he acknowledged in his Senekal speech that he said that there are no farm murders and that there are no white people being killed. He claimed that murder is not directed at farmers, it's just general killing and due to crime being out of hand. He was presented with the following case. In April 2010, Leon Kukumwa, aged 39, was attacked on a farm near Cullinan in Gauteng. The attackers screamed the words, "Die, white man, die, viva Malema," as they were attacking Kukumwa. Knowledge and Lazi admitted to murdering 5 white farmers in 3 months and said, "My hate for white people made me do it." Mr. Malema responded, "There is no problem of white people being killed. There is no problem of white farmers being killed." When asked if he was willing to condemn the murder of white people, he responded, "No, I'm willing to condemn murder, not of white people." He denied that it was possible for white people in South Africa to be victims. When asked whether he would condemn the murder of Brendan Horner, he avoided answering the question. Now, I mentioned earlier about this post on Mr. Malema's page, and he was given an opportunity to condemn it, and I'll read out the post. 3,000 farmers dead since '94. We lost more people than that. We are far from being even. So kill the boer, kill the farmer. You fucking white pigs, Malema is our leader. He will kill Zuma within 6 weeks. Look, go ahead, my fellow black people. We'll take them. We will take our land, and every trespasser, mainly white whores, we will rape them and rape them until the last breath is out. White kids will burn, specifically those in Pretoria and Vrystaat. Men will be tortured while I take a video clip and spread it on YouTube. Colin, we should stand together and rape these fuckers. It's true that Malema said silently we shall kill them. Police will stand together. Our leaders will lead us to take our land over. Mandela will smile again. White knives, we are coming for you. Households will be broken into. Families will be slaughtered. Now, it would be the simplest thing in the world for Mr. Malema to say, I condemn those statements. But he says, I cannot condemn statements of fake accounts. So he avoids answering. He says, well, I don't know the account. Maybe it's a bot. Mr. Malema was presented with the case of a couple that were brutally attacked after graffiti stating Debulu Ibunu, Viva Juju, Viva EFF was painted on their door. He said that the EFF sings the song Debulu Ibunu and that it would not denounce a member of the EFF painting that graffiti slogan. He was then presented with the following case. Alice Lotte at the age of 76 and her daughter at the age of 57 were tortured to death on their farm in the Free State. Both women were tortured for hours, being stabbed with broken bottles in their vaginas. One of the women also had her breast cut off while she was still alive. Helen's injuries were so extreme, the medical examiner was unable to tell if she had also been raped. Alice had been stabbed in the neck and throat and had drowned in her own blood. Their blood was used to write the words, "Kill the Boer" on the walls of their homestead. When asked if the person who murdered and tortured the two women was in a position of power over them, Mr. Malema said, "We do not know if they were farmers. We do not know their social standing. We do not know their relationship to the means of production." This callous attitude towards blatant acts of racist murder and torture, the most obvious egregious case where you have a race-based killing, and Mr. Malema relies on his Marxist understanding about power relations and says, well, we don't know their relationship to the means of production. I can't say whether there was a relationship of power by the person who tortured them to death. That shows you a level of callousness towards people on the grounds of their race. Mr. Malema describes the EFF as a very radical, very militant party. It's a Marxist-Leninist fanonist organization. He said, "I've never said I'm somewhat moderate. I'm very radical and very militant, and I make no apology about that." And he says, "I believe that I'll eventually be president of South Africa." This is why this case matters. This is not some nobody. This is the leader of the third biggest party in the country. This is someone who can call a press conference at the snap of his fingers, who's calling for genocide. When asked whether he would embrace violence as a process to decolonize South Africa, he responded, "Colonization is violence. It is like racism, and the only way to deal with violence, you must be violent. Therefore, there is nothing wrong in engaging in a revolution, and one to be suggesting that you cannot be engaged in violence. Revolution itself is violence." When asked whether he'd be happy to endorse the use of violence for his revolutionary aims, he responded, "My Lord, when the time comes and the conditions on the ground necessitate that arms must be taken, we will do so without hesitation. I am not scared of killing. A revolutionary is a walking killing machine, not scared of death. If that need arises, I will kill, and I will do so with no hesitation, especially in defense of my people." He testified that after the killing of Chris Hani, they wanted to kill, and they were waiting for a signal from President Mandela saying to us, "Let us not go for them. We are very angry. We are ready to kill." Now, on the question of damages, he was asked whether he personally and the EFF as an organisation could afford to pay the 500,000 rand that was sought. And he says that neither he nor the EFF could afford to do so because they have nothing.
Mr. Hofmeyer, you can run through that. It was very blatantly clear. He said, "I don't have the money, there's no money with me, AFF has got no money." In fact, there are 2 points there. He says, "Personally, I don't have the money. Secondly, EFF doesn't have the money," and I think you made the point at the beginning. I don't think you need to read the whole of that page.
Yes. Yes, well, my point is that given the facts of what's known about Mr. Malema's personal worth and the donations that are on public record of the EFF, it seems obvious that Mr. Malema perjured himself. With regards to evidence of Professor Gunner, she testified that song is not simply decoration. The song is not static, it can move, and it can carry a huge weight as an historical statement. It shows that songs can move through time and cause inspiration through memory to a later generation. She says they can play a role as speech, and you can enact a political idea through song. She acknowledged that listeners can deduce messages from songs. Now, Professor Gunner's testimony stands out for being incredibly evasive. That she holds herself out as an independent expert. She said on a number of occasions during her evidence in chief that she says, "I will not be told by anybody what I'm going to say. I speak my own mind." But when asked very simple questions, she suddenly got very evasive, and it was very evident in her body language that when I would ask her questions, she would face away from me and look up at your lordship in pleas of saying, "Do I have to answer these questions?" And when she was asked whether songs can be used to inspire people to perform action in the world, she replied, "I can see where you're going, and I'm not going there." But she acknowledged that the Rwanda Tribunal She acknowledged that at the Rwanda Tribunal that it was found that in Rwanda songs were deployed in a propaganda campaign to target the Tutsi as the enemy and to sensitize and incite the listening public to target and commit acts of violence against the Tutsi. She acknowledged that in the case of Rwanda there was the possibility that songs may constitute direct and public incitement to commit genocide. She acknowledged in the case of Mr. Chwene that he committed murder because he was influenced by the chanting of "Kill the Boer, kill the farmer." And she acknowledged that someone may well be traumatized by the song. She acknowledged that Mr. Malema is a professional politician with access to the media. Now, whatever evidence that she may have given about the meaning of the song, the court in Masuku makes it very clear that that evidence is irrelevant. In other words, it's not up to an expert to determine what a song means. They can provide the context. And part of what Professor Gunner admits is that songs are a form of communication, that in Rwanda, songs were a powerful tool to be used to exterminate people. She acknowledges that. But the evasiveness comes in saying, well, I'm not willing to apply what happens there to South Africa. And I'd submit that the situations are quite analogous in the sense that it's clear that songs can be used to incite people, that in Rwanda, Mr. Bakindi was ultimately held liable for crimes against humanity, inciting genocide with those songs, and that there's no reason why songs would be able to do that in one country but not in another, especially when we have, to say, the political context in South Africa of the delegitimization of an ethnic group on the grounds of their language, on their race, and with high levels of violence against them and high levels of torture against them. My Lord, what I intend on doing then is just showing how the law and the facts apply to each other. So the context, which is determined as being all important by the court in Kolani, is provided by all of these witnesses. And Mr. Roots sets out the context for the words chanted by the respondents. The frequency and brutality of farm murders is clearly disproportionate to other crimes committed in South Africa. He says that there is a zeitgeist in which violence towards whites and Afrikaners is romanticized and normalized. And there's this move of ascribing collective guilt and collective punishment. He says the tenor of songs like Kill the Boer have an evident and obvious vilification effect. Whites and Afrikaners are portrayed as the eternal enemy of black South Africans. With regards to the likelihood of harm, there's good reason to believe that chanting words that call on people to kill farmers in a climate where farmers are frequently tortured and murdered amounts to the promotion of hatred on the grounds of race and ethnicity and constitutes incitement to harm. The songs also constitute unfair discrimination, that they are racist propaganda which incites racial violence. The testimony of Mr. Human and Mr. Prinsloo demonstrate that these songs are also directly harmful, that they cause severe trauma by reminding victims of farm attacks what they went through. And in light of Kolani, harm is also expressed as harm to society, democracy, and the nation, and the nation-building project. Songs like Kill the Boer are inimical to reconciliation and create exactly the spiral of invective back and forth. Harm need not be physical and can also amount to an attack on the dignity and self-worth of the group targeted by the speech. This is obviously the effect of any song calling for the killing and shooting of a group, particularly given the above context. The complainants submit that singing Kill the Boer, Kiss the Boer, or Shoot to Kill is harmful both to the targeted group and broader South African society. On an objective reading, all the songs that were chanted, it's clear that they demonstrate an intention to incite. There is no other inference to be drawn from the language and the gestures used, both of which depict the use of firearms with a defined intention in mind. There's nothing ironic, poetic, or ambiguous about this conduct. The songs were chanted at mass rallies, which were then broadcast on television and then placed on the internet. The reach is immense. The EFF is the third largest political party in South Africa and enjoys considerable support at the voting stations. The controversial and incendiary nature of the conduct naturally gives rise to extensive coverage in mainstream media. It's almost impossible for the ordinary South African to be unaware of the matter. With regard to the status of the speaker, Mr. Maleme's testimony demonstrates that he endorses violence and that he expresses extreme hatred for white people. He's a powerful political figure, and this is more reason to hold him to account. With regards to the payment of the 500,000 rand, I'd submit that it's a reasonable amount given the gravity of the words uttered by the respondents and their unapologetic stance. It's utterly improbable that they're unable to make payment. Now, my learned friend refers to a case between Mr. Gordon and Mr. Malema, in which the trial court, well, it's not a trial court, it was a motion court that awarded R500,000 in damages for defamation. And the SCA said that damages award should be dealt with by oral evidence through a trial process. So there isn't a concern about the particular amount in the method used to obtain that amount. In this particular case, a trial is run, that there's an enormous amount of evidence. And given that actually the amounts that are sought against each party is only 170,000 rand, it's not a particularly dramatic sum. But it's important to send a signal. It's important to send a signal to other people that this kind of speech is not protected speech, that there will be consequences, that one cannot merely apologize for it, especially under conditions where the EFF have been completely and utterly unapologetic about it. That sending a signal of the sum is important. And also the fact that the sum will be used for a good cause. The money is not going to AfriForum. The money is going towards people who have been victims of farm attacks, and that money can be used to restore their dignity. And that's what's envisaged by the Act. The complainants also seek an interdict and an apology. An apology would not be on its own sufficient, but it goes some way. And the interdict is vital, because we have a situation where the EFF have continued to sing this song, and they must be interdicted from singing it. And I'd submit that this court has the power to refer this case to the National Prosecuting Director, and it ought to do so. So ultimately what the complainant seeks is a declaratory order that the words sung on those occasions constitute hate speech in terms of Section 10 of the Act, that they constitute unfair discrimination in terms of Section 7 of the Act. There must be an apology and an interdict, and that's against those particular respondents. That there should be a directive requiring respondents to revise its policies and practices to ensure that hate speech and unfair discrimination be combated, and that protests and demonstrations be conducted in a manner that does not purport to endorse hate speech or unfair discrimination as acceptable modes of expression. In other words, the EFF as an organisation should be free to disseminate its political ideas that fall within the ambit of protected speech, but they must be advised by this court that their policies which endorse hate speech and endorse unfair discrimination must be changed.
But that prayer, Mr. Hoffman, it goes much broader than simply the soul. Am I correct?
I beg your pardon? Then,
I'm saying,
yes.
Reading this particular prayer under paragraph 290, it's much broader than simply requiring them to change their policies in relation to the singing of the song. It seems to require them to go into much more details about, I beg your pardon, any of their policies that may be seen to be discriminatory or may contravene freedom of, the protection under Section 10.
Yes, I'd submit that this court can make a finding about the song itself. In other words, they're interdicted from singing that song, and their policies should obviously exclude singing that song. But that, given that the case that's brought against them is that they performed acts of hate speech and unfair discrimination, that those policies in the broad category should be revised. There may well be other things that would amount to unfair discrimination or hate speech, and asking to change those policies.
But wouldn't the court be going beyond what's before it? What's before the court, it's the complaint as set out in both your documents and in evidence. I haven't had any evidence that suggests that there are other policies besides the singing of the song that requires the attention of the court.
Yes, well, my Lord, to the extent that there are no other policies which infringe, then they're unaffected by the order. In other words, if the only thing that constitutes hate speech that they do is sing the song, and that's the only policy that they have, well then the broad order doesn't curtail anything. It's also clear that they're all infringements of the Act. So in other words, no one has the freedom to have a policy which allows for that. It's just a matter of sending a signal to say, well, look, the equality...
It's just an interdict to interdict somebody from intimidation or somebody from threatening to kill. You have the pleading specifying that you're interdicted from killing this person, but to then take it further than that which would have been pleaded, I'm not sure whether this court has got those powers.
Yes, my Lord, then maybe it's a matter of narrowing that relief to say that they must revise their policies to not sing the song or not perform, in other words, to say that the singing of songs or this song in a manner that constitutes, the breach, that could be narrowed. And then the final bits of relief relate to the 500,000 rand and the referral. And then with regards to costs, your Lordship had raised this question at the beginning. I'd submit that costs ought to follow suit, that if the complainant is successful, it ought to be awarded its costs. That the nature of these proceedings was agreed in conjunction with your Lordship about the time. That the complainant had initially suggested a period of 5 days. Your Lordship suggested 10. Ultimately, it was heard over 9. That the evidence led by the witnesses was all pertinent. It's not a situation, in Judge Lamont's situation, he refers to there being unnecessary evidence that was led. In this case, I'd submit that all of it was necessary evidence. It goes to the context. It's in line with the kinds of evidence led by Human Rights Commission and Psychological Society in Kolani. In Kolani, ultimately the Constitutional Court held that the Human Rights Commission was entitled to its costs for that trial, so they were awarded those costs. And so I'd submit then that the complainant ought to be awarded its costs. The danger in not awarding it costs.
But awarding costs on attorney and client stay?
Yes.
What would be the basis for that? As I understand, when one has to consider the cost in this particular case, one is going to have to take into account the circumstances, the historical background. Now, the song, from the evidence I've heard, wasn't just sung on that particular day, but it's got its own historical context.
Well, my lord, on that front, in other words, that kind of case was the case brought before Judge Lamont. In other words, the line was, well, the song we're singing is Dibulu Bunu, and Dibulu Bunu is about the regime, and it's different from the song Kill the Boer, that it's unfair to translate it. That was the kind of case, and that song had a particular history and was accompanied by music, and they were lost in that case. In this situation, what we have is the singing of a song, Kill the Boer, Shoot to Kill, which the Human Rights Commission found in 2003 already constituted hate speech. That finding was further endorsed by Judge Lamont. The line about singing kiss instead of kill is dealt with by Judge Lamont 10 years ago, saying this constitutes coded speech, and the EFF continues to do it anyway. I would say those are all reasons to say that's why it ought to be a higher cost award. In other words, you have a situation with a person who has an unapologetic stance, knows what the legal framework is, knows it can't rely on a sort of history, because that's already been dealt with by the court in Lamont's matter, and persists. And Mr. Maleme's testimony, which amplifies all of this hatred, that goes into further detail about the vilification. All of that would amount to reasons for having an attorney-client's cost award.
I guess you would say that the court would also have to take into account the agreement concluded, although that agreement was with the ANC, but Mr. Malema also features in this particular case.
Yes.
He had agreed in the Supreme Court not to to cooperate. That's the phraseology used in that agreement, to cooperate with the other parties.
Yes, so in other words, he's personally bound. He has an obligation in terms of that agreement, and that agreement talks about counselling his supporters, and he clearly hasn't counselled his supporters. In other words, his supporters have gone and done the exact thing that he was supposed to not do, which is sing these sorts of songs.
Pardon, that agreement, that agreement, did he conclude it in his personal capacity or in his capacity as the ANC youth leader?
It's in his personal capacity. He cited personally.
He was cited, yes. He was
cited personally. There's a sort of, to give a sense of context, the parties are cited separately. He was ANC youth leader at the time, and the ANC was cited as a party, and Malema was cited separately as a party. And this is very soon before Mr. Malema departs the ANC. So it's sort of envisaged that this is someone who's not going to remain in the party, but may well become a future leader of, a future leader in some instance, not known that the EFF would form. But this is exactly what happens. What that agreement says, in the interest of promoting reconciliation and to avoid intercommunity friction, and recognizing the lyrics of certain songs are often inspired by circumstances of a particular historical period of struggle, which in certain circumstances may no longer be applicable, the ANC and Mr. Malema commit to counselling and encouraging the respective leadership and supporters to act with restraint to avoid the experience of such hurt. So there's an obligation on Mr. Malema in terms of this agreement. That's again further reason to award attorney-client scale costs. In other words, he personally says, okay, I'm going to counsel my supporters to act with restraint and avoid the experience of hurt. And he's standing on a stage with thousands of people in front of him chanting, shoot to kill. My Lord, I have no further submissions.
Thank you very much. Maybe just one question from my side, and maybe Mr. Kasiboto will also deal with it. If, assuming I was to find that Mr. Rhodes is disqualified as an expert, he has led evidence for a few days in this court. What happens? Does that evidence fall away, or should it be struck out? What's the situation? Or does that evidence constitute evidence by an ordinary witness?
Yes, well, I suppose first I would say that the evidence ought not to be, that his expertise ought not to be set aside, that he demonstrates all the things that would be expected of an expert in terms of giving an impartial view of the facts and of the circumstances, and that evidence is very much in line with the evidence in the Kolani case. If it were to be found that he was not an expert, then I would submit then using the evidence to the extent that it's set into the case as an ordinary expert, as an ordinary witness, might be one way to deal with that situation.
Thank you. Yes, Mr. Kasiboto.
No problem. Good afternoon, Your Lordship.
Good afternoon, Mr. Kasiboto. And I'm just wondering whether we should not start right away, before you even start getting into your head, deal with this issue about the expert.
Yes. If I could just allow
okay,
my
no,
brother
they
from
can,
EFF
they can
to
continue
finish.
sorting out their technicalities.
Yes. Well, Your Lordship, as you'd have seen the structure of my heads of argument, that is precisely the point I wanted to start with, because it fits into the rest of the argument. Because once you have a sense as to what form of evidence is admissible or not, then it informs the rest of the arguments that I'm going to address, Your Lordship. Of course, I'm going to start with the evidence of what I'll call the lead expert on behalf of the complainant, being Mr. Rhodes. I'm not going to take you through the entirety of the attacks that we mount against him. I think you've got a good sense of it. But just for purposes of recapping, let me make this point, Your Lordship. It's important that the court is fully aware of the status of the evidence that is being presented before Your Lordship. If someone is called as an expert, case law, PwC, I've cited it. As a matter of fact, with the court's indulgence, I beg leave to hand it over. I'll just hand up the hard copy in any event. I understand it's in the bundle, Your Lordship.
Yes, proceed.
The case law, Your Lordship, that was cited, PwC, tells us, firstly, what standard is expected of an expert witness. Of course, the complainant is legally advised. One must assume they would have been advised about this. PwC tells us, to the extent the expert witness, forget actual bias, there is a perception of bias, then for all intents and purposes, then he is of no use to the court, and it leaves it at that. There is no authority, I respectfully submit, Your Lordship, that suggests that an expert can morph into a lay witness solely because it does not meet the threshold of an expert witness. There's just simply no authority for that proposition. The complainant must suffer the consequence of the oversight. That's what case law tells us. We make the submission that with respect, Mr. Ward's evidence must be excluded for the following reasons. The first is that he's the head of policy at the complainants. The second is that on his own testimony, he is responsible for coordinating the campaigns of the complainant. He then plays a second role of being the complainant himself because he deposes to the affidavit of the complaint. He then tells us that he's an activist of the Afrikaner community. That is the quintessential example of what not to do as an expert witness. And those are submissions, Your Lordship, in the main. The second is the point about the data that is provided to this court. On his evidence, all he has at most is an LLM that focuses.
Well, just 1 second. Now, and I couldn't find any of the specific cases, but we know in the 80s, in the 70s, Professor John Dugard served quite frequently as an expert witness, particularly in forced land removals. And it is known what his views were about those issues. Would that have disqualified him? And as I say, I was looking for cases which could have dealt with his testimony, but I couldn't find any immediately. But I just want to, for my own understanding of how one approaches this,
yes.
When you have somebody of his stature, somebody who clearly had taken a stand about the illegal removal of people, testifying as a witness, would that have disqualified him?
Well, Your Lordship, my answer to you will be nothing short of speculation and suppositions. I do not know what the answer is. But we don't have to go to that realm, Your Lordship, because there's case law that tells you how to deal with it. And that's that case law provided to Your Lordship. If it so happened that there's case law that suggests a proposition that is now being accepted by my learned friend, then it was incumbent on them to bring it to Your Lordship. Because then we're venturing into speculations and all sorts of arguments that are not before Your Lordship. PricewaterhouseCoopers tells this court at paragraph 98 and 99 on how to deal with expert evidence. And that appears as paragraph 10 of our heads of argument. It says the duties and responsibilities of expert witnesses in civil cases include the following. Expert evidence presented to the court should be and should be seen to be independent, product of the expert uninfluenced as to the form or content by the exigencies of litigation. That's the SCA judgment on how you deal with expert witness. And then it takes the point further. It says an expert must be made to understand that he is there to assist the court. If he is to be helpful, he must be neutral. The evidence of such a witness is of little value where he or she is partisan. That's the SCA authority. And if there's authority that trumps this one, then it's incumbent on my learned friend to bring it to the attention of the court. We then make the point, Your Lordship, that based on the extract that I've alluded this court to, not only this court must find, you don't have to find that he was actually biased. It's sufficient if there's reasonable apprehension of bias. That's what the case law says. And I'm suggesting to Your Lordship that the very fact that Mr. Watts works for the complainant, 1, 2, he deposed to the complaint himself. 3, he's a self-proclaimed Afrikaner activist. 4, in his book, he says this is personal to him. 5, I had 5 points. Let me keep it at those 4. The 5th one escapes me. The sum totality of that, objectively speaking, is enough to create a perception of bias. And the SCA says, should that happen, then the evidence is of no value because it evidences that the expert is partisan. And the last point I wanted to make, Your Lordship, which is really important, the fifth element of why we're saying there's perception of bias. If I could just find it, Your Lordship. Yes, on his own version, I put it to him, Mr. Rhodes, do you have an interest in the outcome of this trial? To which he responded, yes. Now, if that's not actual bias itself, it's certainly in favor of my learned, or rather the complainant, a perception of bias. And Your Lordship can then make a finding in that respect. And I do not know if I've addressed Your Lordship's question on the question of what do we do with the evidence of Mr. Rhodes.
Well, just address me on the proposition made by Mr. Oppenheimer that by the nature of these proceedings and the nature of this court, yes, one need not take the technical and strict approach adopted in cases such as Pricewater about who qualifies as an expert witness.
Again, Your Lordship, there is no proposition or rather authority for that proposition. The case that's being relied on is Woodway CC versus Valley, which was in the Western Cape. The point being made is that it's merely persuasive or rather suggestive to Your Lordship. What that case dealt with was a question of access to courts, with particular focus to impoverished people. That's what that principle is about. The principle is not about doing away with the rules of court. It simply says, we accept that not everyone is conversant with the law, we accept that not everyone can be legally represented, and on the basis of the constitutional right to access to courts, for that reason, we will be lax when it comes to certain witnesses. For example, people that are not represented. We're not talking about someone who's legally represented and purports himself to be an expert, Your Lordship. So for all intents and purposes, Woodway is distinguishable to this case. The second reason, Your Lordship, would say the evidence of Mr. Rhodes must not bear any weight to this court is because it is fundamentally and to a great degree premised on hearsay evidence. None of the witnesses he testified about were before this court. Your Lordship would recall that this matter ought to have run as a motion court. Upon being approached by the complainant suggesting that let's have it as a trial rather, one must accept the consequences of that election, which is we'll run it as a trial. Now, what you find in a trial and what distinguishes it from motion court is precisely the question of examinations and cross-examination in particular. So you can't have an election of having a trial and then rely on hearsay evidence. He speaks about friends and family who experienced farm attacks. None of them were before this court. All we have is the ipsit dixit of what he says they told him. Now, that is completely inadequate for purposes of trial. The book is nothing but hearsay evidence that has been untested before the court. Even to the extent it comes close to providing evidence of a link between the song and harm, in whatever form it might take, even those witnesses were not called before Your Lordship. The sum total of my submission, Your Lordship, is that the entirety of the book, absent any corroborative evidence by any of the witnesses he purports to speak for or to narrate their stories, is mere ipsit dixit, it's mere hearsay evidence. And that's the sum total of the evidence by Mr. Rhodes with respect. Crucially, however, he makes a concession because at the start of the trial, the perception I certainly had was that the argument is that the singing of the song causes these consequences, i.e. farm murders and farm attacks. Now, over a period of time, and of course it was a justified assumption on the reading of the pleadings, because to give an obvious example is a question of the song Bizani Fire Brigade, where Mr. Rhodes says, Mr. Ndlozi, Dr. Ndlozi rather, sang the song. And then, second sentence, you are told that then there were farm burnings. Now, we see a slight shift now in tact as to what the relevance of those averments were. We're being told, no, we don't have to show harm. And that is not what we intend to do with that paragraph. Well, the difficulty is this, Your Lordship. The first sentence by itself would have achieved what they want to achieve. What is the purpose of the second sentence? Now, let's assume what they say to be correct and to be their intention, to merely say, all we're saying is he's saying a song that has a risk of causing harm. Then what is the relevance of the second sentence? Of what utility is it if it's not to show the causal link? Of course, the difficulty now my learned friend with respect faces is the difficulty of justifying or showing the link between the two, which is why now we see this about turn. All I'm simply trying to put, Your Lordship, is this. Even with the evidence of all these witnesses, what we've heard from them are actual physical harm and psychological harm. That's the entirety of the evidence we've heard before, Your Lordship. The intention must be then to suggest that the singing of the song has a causal effect, because that's all we've heard during this trial. We've been told about how gruesome the murders were. We've been told about the graffiti that's been left on the scene. We've been told about farms being burnt. That was the intention, to draw a causal link between the two. The spin that we now hear, Your Lordship, and I say this with great respect to my learned friend, is to deal with the question of how do you draw the causal link. They can't draw the causal link because there's no evidence to that effect. Now we have to shift tact in terms of what it is that we're actually claiming. In respect of this, Your Lordship, Mr. Rhodes himself makes a concession about the difficulty of finding the causal link. He says, when I put to him whether you can pin down a link between the song and any harm, he responds, this is a very complex phenomenon, and that there are many variables that could play a role as to why these attacks are happening and why. And I cite the transcript. The sum total, Your Lordship, and I do not want to belabor the point, there is just no evidence of a causal link between the song and any harm. What we, however, have is a report, and I put it to Mr. Rhodes, that it is an illustrious panel of experts from different fields that undertook this exercise of identifying the causes of farm attacks, and he accepts that point. And I say the terms of reference are quite comprehensive. Would you add any other term to satisfy yourself as to whether this is being done properly or not? He says, well, there's no other term of reference I could include. I then take him to the report itself. The report says, of the farm murders that were investigated, only 2% were racially motivated. 89% were motivated by robbery. Now, that's very fundamental to understand, because what we've been told today is that, well, there's a disproportionate number of farm murders in contrast to the rest of the murders and robberies that happen in South Africa. But it is only at 2% that the clearly identified motive was racially motivated. It gets more difficult for the complainant because of that 2%, we are not told of the race dynamics. We're not told within that 2% it's black people killing white people or vice versa. What we're told is merely 2%. But even within that 2%, there is no evidence that the song played any influence in that 2%. For all intents and purposes, Your Lordship, there's just simply no evidence of the song leading to farm attacks. I then put it to Mr. Rhodes that it could well be that within that 2%, it was a white farmer attacking a black person, a black worker, for example. He gives me a bizarre response. He says, well, it's neither yes or no. It could be both. I push him further on that question. He says, in theory, yes, that could be, but in practice, no. Now, I'm going to ask this court to take judicial notice of the fact that some farm murders so happen to be white farmers killing black workers. The sunflower murder, for example, is a classical example. My learned friend has made reference to a couple of other ones. A farmer being fed to the lions, a farmer being fed to crocodiles. Now, the court can take judicial notice of the fact that that in fact does happen. In practice, not in theory. And then, Your Lordship, now, this is a difficulty we have about statistics and accounts and what has been proven, what has not been proven. My learned friend has suggested to Your Lordship that there are several examples where there was a direct link between the singing of the song and the harm being caused. In paragraph 29 of our heads of argument, and I make reference in the footnote of the exchange, after I'd asked Mr. Rhodes whether there is a link between the two, and he says, well, there might be a political link, I say, and I quote, no, the question was different, Mr. Rhodes. The question was, is there any evidence that you can refer to me, or to the court, rather, whether there is a direct correlation between the singing of the impugned song and the farm attacks and farm murders? That was the question. He responds, no. The only example I have of this particular song that where there is very clear evidence in terms of someone testifying, I committed this murder because of the song, I am only aware of one such case. That's Mr. Rhodes' testimony, not the evidence that is being led by my learned friend before Your Lordship in submissions. Let's still now again brief Your Lordship with the decision of PwC, because it's quite instructive. Just for purpose of context, what happened there, Your Lordship, is precisely what you had alluded to earlier on, before witnesses were called. They called an expert witness before lay witnesses. He testified on evidence that was not before court. You raised that, Your Lordship. But there was an insistence that we'll start with experts, well, certainly by the complainant, because we started with lay witnesses. That is precisely the problem with PwC as well. You had an expert witness that was called and gave evidence on facts that were not before the court. Now, this is what the SCA said about that. And by the way, Your Lordship, the insinuation, or rather the inference there is that he testified on hearsay, and I'm alleging that Mr. Rhodes' evidence was also hearsay. The court says two courses of action are open to the judge. The first would have been to require NPC to identify the hearsay evidence that it wished to have admitted and make an application for its admission on any available ground, and then make a ruling on its admissibility. Such a ruling could have been revisited at a later stage of a trial if necessary. The second, insofar as it was indicated that witnesses would be called to substantiate the hearsay evidence, was to require that Mr. Collett's evidence stand down until such evidence had been led and was properly before court. That's what PW says is the manner in which you should deal with hearsay evidence of an expert. We of course know there was never an application to admit that hearsay evidence. We of course know that Mr. Rhodes did not wait for Ms. Muller as well as Mr. Prinsloo before he gave his evidence. So it was purely based on hearsay, and PwC is instructive in terms of how you deal with such evidence. I then now turn to deal with Mr. Human's evidence. Mr. Human is an expert who testified that he also works for the trauma, or rather, he works for the trauma unit of the complainant. Now, the difficulty with his evidence is this. Not only does he give us hearsay evidence, he does not have any corroborative affidavits to back up his evidence. It gets worse, Your Lordship. He does not give us or identify the persons. They are referred to as AABBCC. That's classic hearsay evidence, classic ipsy-dixit evidence. Now, the reason we're given for him, the reason we're given for the third parties that Mr. Human testifies about is that we have security concerns. Well, we don't buy the argument with respect, because how is it that Ms. Muller was called to come and testify to this court? How is it that the security risk does not extend to her? Similarly with Mr. Prinsloo. In any event, Your Lordship, this court has got inherent powers to run its processes. You could well have said, if our friends were genuinely concerned about this, they could have well have approached Your Lordship and said, we would prefer these witnesses to testify in camera. That was available to this court, available to the complainant. In the alternative, Your Lordship, they could have deposed to affidavits that could have been kept under seal. In the alternative, Your Lordship, they could have deposed to affidavits that are redacted. None of those structural safety measures were proposed before Your Lordship. All you're being asked to do is to accept the ipsy-dixit of Mr. Human's evidence. And that, Your Lordship, with respect, we say renders his evidence inadmissible, particularly because no application was brought to accept or to admit that hearsay evidence. We've already dealt with the question of the Facebook issue, Your Lordship. And sorry, I missed this point about the credibility of Mr. Rhodes, which was on the question of there is no hunger for land by black people, which was his evidence. I then suggested to him that, well, there is no basis for that foundation, basis for that argument.
Sorry, Mr. Kasiboto, before you bypass that point about the Facebook, you had my engagement with your colleague earlier on. What's your response to that?
Your Lordship, the relevance of the Facebook issue is the question of credibility of Mr. Rhodes. What we submit is this. He shifts tact at convenience. I made reference to the paragraphs in his book that were unequivocal about whose Facebook page that was. Because when I put it to him that Mr. Malema does not have Facebook, he says, well, I didn't say it in definitive terms. I did not leave out the possibility that it's not his Facebook page. And I'm saying, Your Lordship, at your leisure, and I think it's about page 208 of the book, I will not take you there now. There is no qualification of this could be Mr. Malema's Facebook page. It doesn't say Mr. Malema and or supporters. It specifically says, I extracted this text from Mr. Malema's Facebook page. Now, first it speaks to, well, how credible was the research that he'd undertaken. Secondly, upon it being put to him that's an incorrect account, he then shifts text to say, well, I did not leave out the possibility. So it was to speak to his credibility and nothing further, Your Lordship. And I suppose while we're on that point, Your Lordship, let's also deal with the question of sorry, Your Lordship, it's page 208, not 280 of his book. While we're on the subject of credibility, Your Lordship, let's talk about, and I know we had engagement on this during the trial, but it's a point worth restating, Your Lordship. The whole issue about the usage of the cell phone in court, when there was a court order to the effect that it should not be used. My learned friend, before Mr. Ernst Roets testified, said to this court, I have received instruction from my attorney that Mr. Roets did not use his cell phone. Now, Mr. Roets comes and testifies. He says, I in fact did use my cell phone. And then I made the argument, Your Lordship, and I repeat the argument because I stand by it. We must assume in favor of my learned friend that he abides by the ethics and the obligations as a legal practitioner. We must assume that in his favor. We must assume that he did take instructions from his attorney before he gave that account to court. We could have dealt with this by merely calling them and asking them to testify about the contradiction, but the problems with that should be quite evident, Your Lordship. All we're simply saying is make a ruling on this, Your Lordship, when you apply your mind. What is the probability that my learned friend would stand here, implicate his attorney, stand by a version, knowing very well that Mr. Roets is going to come and testify later, but yet put a flag on a mast that is not an instruction of client, knowing very well the client is going to come and testify? I would suggest, Your Lordship, reasonably, it must be that he took that instruction from Mr. Roets. He's got an ethical obligation to act on instruction. We must assume he did. That again speaks to the credibility of Mr. Roets, the chopping and the changing of versions at convenience.
But that consideration would then mean that you're in agreement with your opponents when they say that the evidence of the incidents that occurred should also form part of the evidence before this court.
No, Your Lordship. There are two sets of there's two sets of evidence here. The one is the video, the other is the testimony. If Your Lordship finds that they are linked, well then so be it. We'll make submissions as to why they're not admissible.
So which video? Are you talking about the video at the gate?
Indeed, Your Lordship.
Okay.
Indeed, Your Lordship. So the cell phone issue is one thing. That's the contempt of court issue. The video evidence outside of court is the new evidence they want to introduce. So the two are not linked in that sense. Because you recall, Your Lordship, your order was an order directing conduct of people inside of court. The videos that are sought to be admitted are videos of an incident outside of court. So there's no nexus between the two, certainly for purposes of considering the evidence itself.
Okay. The incident of the cell phone, you were contending that it was contempt. So it goes hand in hand with these proceedings. It was contempt of these proceedings because the order was meeting these proceedings.
That's the point, Your Lordship, I'm making.
Okay.
I've made the point about the cell phone and why it's improbable that counsel misled court. I submit it's actually Mr. Roets who misled court. Let me now deal with the question of Mr. Kroos, who was the third expert that was called on behalf of the complainant. I knew I was forgetting something. I promise it's the last time I'm going back to Mr. Rhodes. I'm taking a liking to you, actually. The last point, Your Lordship, is, again, speaking on the question of credibility. Mr. Rhodes testified that Mr. Malema is a dictator, he's not consultative, and he takes unilateral decisions. Now, bear in mind, this is an expert we're talking about. Someone, to quote Your Lordship's words, someone who operates at a high level. It's one thing if we're dealing with lay witnesses who, on emotion, respond a certain way. You are here to assist the court. Now, Mr. Rhodes did not take kindly to that line of questioning. I pressed him on what basis do you say Mr. Malema is not consultative? And I quote, because you can see it. Now, we're talking about an expert here who makes such a fundamental allegation, and being pressed as an expert to give evidence of that bold assertion. He says, because you can see it. Now, this, Your Lordship, speaks to the question of bias and the animosity that Mr. Rhodes has towards Mr. Malema. He is prepared without evidence to make such a bold allegation against him that he should discredit any evidence, Your Lordship, to the extent that it shows evidence of lack of independence. And then to quickly fast forward to Mr. Cross, and I'll be brief on him and why his evidence should equally be excluded. He came and testified about the events in Senekal. As far as we could discern, the only relevance of his evidence was on the question of what song was sung in Senekal. Now again, my learned friend has repeated this assertion that members of the EFF sang "Kill the Boy" in Senekal. They did not. At least there's no evidence of it being sung in Senekal. Yes, we saw a video of people saying "Kill the Boy" in Senekal. But what we identified and what we brought to the attention of this court was that the people who were saying "Kill the Boer" had no indication that they were EFF members. They were not in EFF regalia. They were not being led by any EFF leader. As a matter of fact, I put it to Mr. Cross that there is no evidence that these are members of the EFF, to which he responded, well, I did not say they definitely are. The point being made, Your Lordship, we still are without evidence of the EFF or any of its members singing "Kill the Boer." The second part of his evidence, which I thought was relevant, Your Lordship, is on this question of causation, which we discussed earlier on in relation to the burning of the farms, where Mr. Rhodes stated that, well, Mr. Ndlozi sang the song, "Call the Fire Brigade, it's burning," and then in the next sentence he says, then there were farm burnings. And then they attached an article. And then, of course, we made submissions that, firstly, that the fires, according to the article itself that they themselves annexed, started days after the song was sung. Secondly, the article says it was caused by service delivery protests. And thirdly, these farm burnings happened 3 hours away from where the song was sung. I then put it to him, then it's improbable that the singing of the song caused the burning of the farms. His initial response, on the face of it, that makes it even less probable. That's his initial response. And then, after engagement by counsel on behalf of the complainant with the court, taking issue with the line of questioning, Mr. Cross then changed tact again, and then he hypothesized and speculated about other factors that might justify the link between the two. I then invited him to stop speculating and work on the evidence that we have, to which he finally considered it is improbable that the two are linked. And that was the sum total of the evidence, Mr. Cross, at least as far as we found it relevant. And what is curious about this, Your Lordship, is that no evidence whatsoever was laid on this singing of the song by the complainant. None whatsoever. As far as Bizani Fire Brigade, which is a charge against the second, or rather the third respondent, Dr. Ndlozi, no evidence was laid on this. The only time this came about was for the first time when I was cross-examining Mr. Gabriel Krauser. Nothing whatsoever was said by the complainant in support of this claim. And with respect, then, that should be the end of the matter as far as Dr. Ndlozi is concerned. And of course, going back to the PwC judgment, which I'll keep making reference to, we know now that on at least 3 separate occasions, IRR, which Mr. Krauser represents, was funded by AfriForum or an AfriForum-related party. We're getting to the point that he who pays the piper calls the tune. There is reasonable apprehension of bias on an expert who is called by the very institution that funds his organization. It speaks to that question of apprehension of bias.
In fact, Mr. Possibility, before I forgot to raise this with Mr. Oppenheimer. The issue of Mr. Ndlozi, whether that case is still a case before this court, the singing of the Bring the Fire Brigade.
Well, for clarity on that, it's mentioned in the affidavit.
Yes.
My learned friend, in his response to that affidavit, or the respondents in the affidavit, say, we accept the singing of the song. It's common cause the song was sung. It is part of the complaint, it's not on its argument. It's a simple matter of this court using the relevant test in terms of the law to determine whether it amounts to hate speech and unfair discrimination.
Okay. Thank you. Sorry, Mr. President. Thank you.
Your Lordship, I now want to move to the substantive matters. Assuming, of course, you rule in favor of the complainant insofar as the expert evidence witness is concerned, then the substantive element becomes relevant. To the extent you don't, then it's not relevant. I will not read it to you, Your Lordship, but I'll just make reference to paragraph 91 of our heads of argument.
So I beg your pardon, Mr. President. I missed the point you're saying. The first point you started off.
The first point was this, Your Lordship. Perhaps I will deal with Ms. Muller now and Mr. Prinsloo now. Perhaps that would assist the court. The point I was simply making, Your Lordship, is you must exclude the evidence of Mr. Rhodes for the reasons given. You must exclude the evidence of Mr. Human purely because it is hearsay, unsubstantiated by any corroborative evidence, ipse dixit. We're saying you must exclude the evidence of Mr. Cross to the extent that it is not relevant, because a large part of it was irrelevant, save for 2 aspects that we found relevant. The first being the singing of Kill the Boer. And we say he made the concession that there is no evidence that the people who sing the song are EFF members. Secondly, on his own version, it's improbable that there's a link between the singing of the song Bizani Fire Brigade and the farm burnings. And I'm saying, Your Lordship, to the extent you're with us on those scores, then the question of all the evidence that I'm now going to get into is, for all intents and purposes, not relevant because you would have found that it is inadmissible. But to the extent you are not with us on that score, then you must consider that evidence. And that is what I intend on doing.
Thank you.
Your Lordship, at paragraph 91, I will not read the entirety of the case law we cite there, but to make the point about the importance of the right to expression. And then perhaps just to make reference to the Mamabulo judgment at paragraph 93 of our heads of argument, it says freedom of expression, especially when gauged in conjunction with its accompanying fundamental freedoms, is of utmost importance in the kind of open and democratic society the Constitution has set as our aspirational norm. last sentence. Therefore, we should be particularly astute to outlaw any form of thought control, however respectably dressed. And then when you flip over the page, Your Lordship, in Kwelane, a similar idea is carried out. And then paragraph 96, similar idea is carried out, but in more direct terms for purposes of our trial, which is why I'm going to read the excerpt from 73 of that judgment. It says, in addition, this court has highlighted that the corollary of freedom of expression and its related rights is tolerance by society of different views. Tolerance, of course, does not require approbation of a particular view. In essence, it requires the acceptance of the public airing of disagreements and the refusal to silence unpopular views. That's the Islamic Unit at 73. Langa DCJ, as he was then, goes on in the same judgment. Freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sect of the population. Such are the demands of pluralism, tolerance, and broad-mindedness, without which there is no democratic society. I feel that is very instructive, Your Lordship, and at your leisure you will have regard to it. And then, Your Lordship, just to foreshadow the analysis of Section 10, which I'm about to take, I want to make reference to the evidence of Professor Ghana, who was called on behalf of the respondents. And, of course, expansive CV, as skills and experience and accolades, which go into 30 pages, speak for themselves. And she made the point, and I want to quote her. Perhaps before I do that, she gives a context of what Dubulibunu means. And now, for the sake of everyone concerned, we need to understand that there is no difference between Dubulibunu, which was the earlier case in front of your brother Lamont J, and the allegation being brought before this court, Kill the Boer. We know there's no difference because that judgment itself says there's no difference. Secondly, because the complainant says there's no difference. It's just a translation of the two songs. So that's important to understand. It's important to understand because Professor Ghana did research on that song, Dubulibunu, and the role of political song in African culture. And what she says in summation is that those songs have a place even in contemporary South Africa. What must be fatal for the complainant is that they called no witness to counter that evidence. Your Lordship did not have the benefit of being told this is the alternative reading of the song. What we have is uncontested evidence of an expert witness, an expert particularly on the subject matter, and there's nothing to contradict the evidence. Your Lordship had the benefit of her testifying on another song with the lyrics, Malema utsela tupa, tupa ibon.
Tupa.
Tupa e waibon. Is that how it goes? You get the point, Your Lordship.
Yes.
The English translation is this. Malema will wield the stick. The stick, do you see the stick? The beating is coming. The beating, do you see the beating? Now, she made the point there that, as with this song, at the face of it, this song calls for violence and harm. It places at peril whoever the subject of the song is, at the literal understanding of that song. But she says, of course, that's not what that song is about. She says that song is about agitation of the incumbent government led by President Zuma. It's figurative for, at the elections, we will win at the ballot. That is what the wielding of the stick means. Now, if Your Lordship is with her on that score, it must follow naturally that you must be with us on the score of this song.
No, but this song, Otsela Tupa, is slightly different from Dubula. Otsela Tupa, you could use it in a sense in Setswana to say you're going to be punished. Whereas Dubula, as I see it and understand it from Judge Lamont's judgment, it carries a much heavier element of violence in it. Although Tupa also, we know that corporal punishment, it's basically corporal punishment, which is outlawed. And it's outlawed because it's got an element of violence. But here, it's more kind of confined to an individual who's going to carry out that violence. So the element of incitement, it looks to me that it's not going to come in because the person will come and punish you. It's Mr. Malema. Whereas in the Udubula Ibunu song, it's more kind of kill them. Kill the farmers. It's not even saying kill the farmer, kill the farmers, isn't it? So there seems to be some unnuanced distinction between the two songs.
Well, Your Lordship, it could well be, as a matter of principle. But Your Lordship is not seized with the question of to what degree the harm is. That is not the test. The test is there a call for harm, yes or no? It could well be, and I accept, that the form of harm in terms of shooting someone to death is more egregious than someone beating you physically.
And then broadly calling for the harm to even though the law does actually, and I think in one of the cases they point out that it may be an individual, but broadly speaking what is envisaged is to protect groups of people within the society. Now, in the Utubola Ibun, it seems to me that the interpretation you can give, it's targeting, in fact, let me put it this way, the case of the complainant is that it's targeting a group of people being Afrikaners and being farmers. That's their case. Whereas here, you're looking at somebody saying, this one will come and whip you.
Yes. The point I'm simply making, Your Lordship, is, and perhaps it will be a point that will become clearer once we make reference, and I should take you there, Your Lordship, now, at paragraph 158 of our heads of argument. Now,
right, found it.
What this case is about, Your Lordship, that we discussed there, is a case of Mr. Malema and Mr. Godan. And just for purposes of context, this is what Mr. Malema said about Mr. Godan, and that is at 156. This is the impugned statement that he made. Our attack on Pravin Godan is an attack on white monopoly capital because Pravin is a dog of white monopoly capital. We must hit the dog until the owner comes out. And once the owner comes out, we must deal decisively with the owner. Pravin is a cabal that belongs to the UDF and destroyed all good African comrades. He's not good, this guy. And then if you go further down, the last paragraph there that we cite, once you take a decision to go after Pravin, you must be ready. If you are not ready, don't come to the EFF. We have now taken a decision to fight Pravin, and therefore you must know Pravin is going to fight dirty. There will be casualties. There can even be loss of life. If you are not ready for that, stand aside. I'm not scared. I'm ready. I'm prepared to confront them one by one. Now, that's not just a song. That's a whole statement. And it's a statement about loss of life. It's a statement about beating Mr. Godan. And by the way, for purposes of context, we accepted, or the court accepted, that the cabal that was being referenced was the Indian cabal. So that's on the basis of race, or at the very least, ethnicity. That was the context of that decision. With that being said, notwithstanding this strong, violent language, this is what your brother Sutherland J. found. At paragraph 15, it says, that's the 158 we cited, the passages that speak to hitting the dog and the attack on the applicant are plainly metaphorical. 16. An allusion to casualties and the loss of life engendered much controversy. The use of casualties on its own might have been understood as a metaphorical, but for the conjoining of loss of life. Plainly, the image conjured is of the real physical injury. However, read as a whole, this literal meaning is not the meaning a reasonable person would attribute to the utterances, and this is the important part where we've underlined. It is plain that the allusion to loss of life is a mere example of an extravagant juvenile rant, stretching hyperbole to the extreme in the course of a demonstratively demagogic speech. Now, obviously, Mr. Malema did not take kindly being called an extravagant juvenile, but that's important for purposes of understanding the context of the speaker. Professor Ghana testified about the politics of Mr. Malema, that he's a flamboyant character. He uses hyperbole. To quote Judge Sutherland, your brother, it is a mere example of an extravagant juvenile rant stretching hyperbole to the extreme in the course of a demonstratively demagogic speech. Its function was to proclaim the speaker as brave and steadfast in the face of any foe, however mighty, and that the space to stand at his right hand is reserved only for the steadiest of fellows. The dominant impression is that it is a puerile self-aggrandizement, not a threat to the applicant or anyone else. Now, Your Lordship, the point we seek to make there is this. Once you get to the analysis of Section 10, Section 10 says there must be a clear intention to cause harm and to propagate hatred. And that test is objective. What that means is context is important to the analysis of Section 10. If you understand the speaker, which I suggest we all do, his politics and his approach to political matters, then you must understand the context and the ideas that he carry through usage of language and song. We all know the character that is Mr. Julius Malema. To use the words of your brother Judge Sutherland about the idea behind this very violent language, that notwithstanding the violence in the language itself, a reasonable reader will not understand him to mean that in literal terms. That is precisely what we're dealing with here, Your Lordship. We're dealing with a character who's got the personality that he has, who's got the approach to politics that he has, that Professor Ghana has alluded to as well. So whoever listens to Mr. Malema sing Kiss the Boer, which, by the way, is the only song he sang, at least that's the evidence that's been presented here, not Kill the Boer, Kiss the Boer. You must understand who he is and what his politics are, and they are captured by your brother Judge Sutherland. And in understanding the character, then you must understand that hyperbole is part of his political rhetoric. That's the reasonable reader interpretation that a reasonable person will give. That's the submission we're making, Your Lordship. And I'm saying, Your Lordship, if Judge Sutherland finds as it does, in the face of such violent language, because he understands how a reasonable reader will understand Mr. Malema in that context, we are inviting this court to do the same. And Your Lordship, the issue, Mr. Malema, when I led him in chief, the issue he took with the video footage that was broadcast is that it never gave you the full context of the speech or the full context of what happened that led to the singing of the song, what was said before, what was said after. And as a matter of fact, he testified that at these rallies, that's not the only song they sing, one. They sing songs that speak to the question of land, which is the cardinal pillar of the EFF. And part of the songs that are being sung there, to make the point that those rallies focus on the question of land, is another popular song that was not broadcast to this court, which is generally sang along with the Kiss the Boer song. And that song is From Cape to Cairo, Azania. Now, if you had the benefit of the full clip being played, you would have seen that Azania, for context, Your Lordship, it's a song about how we're going to take back the land from Cape to Cairo. So the whole decolonization of the African continent. That's what that song is about. And it is sung along with the song. And following that, more times than not, is a question and a debate, or rather is an address by Mr. Malema of his supporters about the land issue. Once you have that full picture of what this is actually what transpires at these rallies, you then begin to understand where this song fits within the entire narrative of the land issue. Similarly, Your Lordship, Professor Ghana brought to your attention the song Letu Mshini Wami, which is loosely translated to Bring My Machine Gun. I will not waste your time on it, Your Lordship, but the point simply being made is it's again another example of a struggle song that at the face of it, outside of the context of it being a political song, it appears to call for violence. And Your Lordship usefully brought to our attention an example of a song, Tambo Speak to Botha, to release Mandela, to govern. And the point that was being made is that, well, that song clearly calls for something specific. It calls for specific action. And it's got relevance to the time in which it is originally sung. And it has lost its utility because since then, President Mandela has since been released. Mr. Tambo has since passed on, and so has Mr. Mandela. But the point we're making is precisely this, Your Lordship. We brought to your attention video footage of the song being sung to date, as recent as 2016, literal as the song appears. The point we are making, Your Lordship, is that once viewed outside of the context of the politics, you lose the meaning of the song. Political song plays an active role in galvanizing people, in refocusing people on what the idea is. Mr. Malema has testified that all we have is political freedom, not economic freedom. It's to galvanize and rebuild on that spirit, the foundational spirit of where the struggle started, to galvanize the people towards whatever the goal might be now. That's the role of political song, which is why songs such as Tambo Speak to Botha are still being sung to date, because they don't have a literal meaning.
But this song, as I understand from Professor Ghana and I think from Mr. Malema, this song was sung at the height of the conflict between the various political role players in the country.
Yes.
And it seemed to me it wasn't galvanizing people to go and praise each other. It was calling on the one side to attack the other. Or was it not?
Are we talking about the impugned song or?
The impugned song.
Oh, I see, Your Lordship. Sorry, then I missed the question. I thought we were still talking about the Tambo song.
No, I'm talking about the impugned song.
Yes.
That its historical origin
yes.
didn't originate in a situation where there was harmony and peace in the country.
Yes.
And being sung to praise those who are in power, to say, you're doing very well, keep it up. It was sung in a context where almost one could say there was war.
Yes.
It is calling on people to stand up and fight.
Yes.
And it's now sung in the new era,
Yes.
where there's constitutionalism.
Yes.
But the lyrics haven't changed, have they?
Your Lordship, let me start at the start. Firstly, it was a testimony of Mr. Malema himself that there is no evidence that he knows of, certainly none before this court, that even at the height of oppression, when this song originated, no one was instructed through song to go and kill anyone. Instructions were given in direct verbal, direct language terms. That's the starting point. But let's accept the premise. That's what the song is about. The evidence of Professor Garner is that precisely the point I'm trying to make about this Tambo song, that the song might have the exact same lyrics, but the meaning, given the context in which it is sung, might differ. And Your Lordship, I'll make reference to a Victorian court judgment that deals particularly with this issue. The point I simply make, Your Lordship, is political song is not just speech for the sake of speech. Sometimes it is sung in memory. Sometimes it is sung to reinvigorate the spirit, the fighter spirit, if you will. It is to galvanize the people, to ignite that spirit that drove them to the eventual demise of apartheid. It does not merely mean what the words say. And this is one of the criticisms that I'll get to of Lamont J's judgment with respect. It is to completely ignore the context within the song, which the song is sung. In his own finding, he says, this song seems to have raised no concerns in the white community. Up until close to 2011, when it was eventually translated by the media to the English version. That's the finding of Lamont J. Now I'm going to deal with the question of what the problems are with some of the findings, but on his own finding, he says, it was immediately after the song was translated to English that the complaint arose, whereas it's a song that predates 1990. And there's never been a complaint about the song until the media translated it to English. Now, of course, being an English speaker in Afrikaner, a farmer, I hear the literal words, kill the Boer. Of course, then I'm going to bring a complaint. But that does not take away the fact that you might have missed the context because you're reading the English literal meaning of the words. And that's the difficulty, Your Lordship, with interpreting political songs outside of their context. You read or hear the words, kill the Boer. I'll take umbrage to it as an Afrikaner. I'll take umbrage about it as a farmer, whoever the target is, just reading the words in their literal meaning. And that's what we're warning against, Your Lordship. It's to understand that political song plays a far bigger role than the literal words that they convey. And again, Professor Garner, at paragraph 139 of our heads of argument, she says, and she captures the point, nevertheless, the Dubulubunu song in its generalizing capacity, its populist appeal, and its incisive focus had the power to bring the question of land and dispossession squarely to the public domain at tense time for the ruling party, the ANC. The song was not new. It had been brought back into public prominence by another son of Seshego, Peter Mukaba. The most astute of politicians, and this is the point, Your Lordship, and this evidence is not controverted, it's by an expert. The most astute of politicians, Malema set the song to use in establishing the issue of land as a key pillar around which his profile and make an important political intervention in a challenging and controversial way. Now, we say that's the context of the song, on evidence that has not been controverted. And the test in section 10 says there must be a clear intention to cause harm. I suggest to Your Lordship that this evidence by the expert creates doubt as to what the exact intention of Mr. Malema is. And soon as there's doubt in your mind about what his intention is, i.e. there's no clear intention because of the evidence of Professor Garner, for example, then you can't find that it is hate speech, particularly because the evidence is not controverted. And then at paragraph 140 of our heads of argument, and I apologize again, Your Lordship, I can't express this idea better than the author, so I'm going to be forced to read it, and I really apologize.
So what page is that?
It's page 38 of our heads of argument, paragraph 140. It's a research paper by an Oxford branch, Faculty of University of Oxford, and it was a paper prepared for the Legal Resources Centre, South Africa. This was their opinion. It could be argued that resistance songs, such as Dubulibunu, are an important form of political expression, and in some contexts a valuable way of remembering and depicting history. We did not find case law directly addressing this issue, but this argument could be developed from the principles outlined in the cases above. As a form of political expression, these songs continue to have relevance for vulnerable and marginalized groups who may harness the memories of togetherness, determination, and courage that they evoked to confront current challenges. And that's the point I made earlier. As Martin Luther King Jr. said of resistance songs in the U.S. civil rights movement, it is not just a song, it is a resolve. Furthermore, these songs may allow individuals to recapture memories and emotions surrounding historical events in a way that other forms of historical representations cannot. Therefore, this valuable form of expression should be afforded greater weight in the balancing exercise. And that's the point I was making, Your Lordship, that political song is not just political song. It plays a role in evoking emotion, in remembering times go by, and to reinvigorate the spirit towards a common goal. And the paper went further at 141. As a result, decoding the meaning of words or actions is one thing. Determining whether the actor had the required intention reasonably construed is another. This is one of the flaws in Lamont J's judgment in Malema, as he appears to suggest that because the words Dubulibunu mean shoot the Boer / Afrikaner, a reasonable person would construe these words as intending to be hurtful, to incite harm, and to promote hatred against the white Afrikaans-speaking community in all contexts. This fails to recognize that meaning and intentions can pull apart, a point that is discussed in greater detail below. Now, again, the point we make, Your Lordship, and we're going to make this point again when we deal with whether you should consider or you are bound by the decision of your brother, Lamont J, is that meaning and intention can pull apart. And that's the point that's being made.
By the way, before we forget, the most critical point to deal with in relation to the judgment is the point about res judicata.
No,
are you pursuing that point?
I certainly will.
Okay. Proceed then.
And then Rosenfeld also wrote, and we cite the article as footnote 68, where the alleged perpetrator is a member of a vulnerable or historically oppressed group, this may call for greater tolerance of offensive speech. We can argue about the merits and the demerits of that, Your Lordship, but that is the academic point that is being made. And he further argued, it is understandable that groups that have experienced historical oppression and ongoing disadvantage may vent their frustration or seek to build a sense of solidarity by using language that is less than temperate and may amount to hate speech if used by historically dominant groups. This venting could even be justified as a form of self-fulfillment, as a result that reaction by the oppressed, even if tinged with hatred, should be somewhat more tolerated than hate messages by members of traditionally oppressive groups. Again, you'll make a finding in respect of that, Your Lordship. And then perhaps let me fast forward to the question of res judicata. I just want to make sure I'm missing nothing, Your Lordship. Now, Your Lordship, before I get to the question of res judicata, let's quickly deal with the question of what harm is being claimed here. So now a concession has been made that we're not talking about physical harm. We're not talking about a causal link as a result of the song. This is the harm that happened in a physical sense. That has been put to bed. That's a concession that has been made. The second aspect, Your Lordship, is the question of psychological harm. The only evidence you've heard of the psychological harm with respect to Your Lordship is from Mr. Human, and we've already dealt with why his evidence should not be admitted. And the only other person, Your Lordship, that has made reference to psychological harm is Mr. Prinsloo, who was in front of court. The question was put to him as to how he feels when he hears the lyrics of the song, to which he responded, well, something along the lines of he takes offense to it, and it causes him great distress and causes him psychological harm. What we suggest, Your Lordship, is that he clearly tore up in court, and that reaction was prompted by the question of him, or rather, it was prompted by him narrating the story of his attack. When the question was put to him on whether he suffers any psychological harm as a result of that attack, he says it does. And then he says, rather astonishingly, that the cause of his harm are the lyrics of the song, which are sung, and I'm struggling to find the reference, which are sung by young black men. And Mr. Malema is responsible for them singing this song and prompting them to cause these attacks. And then I put it to him, how would you know this? To which he responded, well, I suppose I don't know. Now, the point is this, Your Lordship. If there is going to be a link made by Mr. Prinsloo between the song and the psychological harm, he must be able to make that link. He can't on the one hand say, these young black men attacked me and they were prompted by the song which is sung by Mr. Malema. And then the question is put to him, how do you know they have any political affiliation to Mr. Malema or his party, or that they even know the song? He says, well, then I suppose I don't know. Now again, we have no evidence of any psychological harm caused by the song itself. Of course we are sensitive to the farm attacks. Of course we are sensitive to its brutality. But what we're simply submitting, Your Lordship, is it is not a result of the song. There is no evidence to that effect. And this is simple submissions that we make. Now, what seems to be the new form of harm that is being claimed is this whole idea of social coercion. So the singing of the song is being claimed causes social coercion erosion. Just for a bit of context, Your Lordship, let's firstly understand who the complainant is and what their position is about social coercion. Other than the fact that they're pursuing appeals to gratuitously display the apartheid flag, which is the most prominent symbol of apartheid. This is what they said in the Constitutional Court, in the streets, in the Tshwane Streets matter, where the court held that government can proceed with the name changes. This was their submission. And this is the Chief Justice Mogoeng, as he was then, said. The complainant submitted what the Constitutional Court referred to as the mind-boggling proposition to the effect that, and this is what AfriForum submitted as to why there shouldn't be any name changes in Tshwane. Looking at names linked only to other race groups causes harm and toxicity. Now, we're told this is the same complainant who cares about social cohesion. The point we make, Your Lordship, is this. Social cohesion and its erosion is not a legal question, it's a factual question. Because there must be a link between the song and the erosion. That's not a legal test, it's a factual test. It's a test that requires socio-political analysis, for example, as to what the consequence of the song is to the social fabric. It can't be a thumbsuck that this is the consequence of the song. There must be evidence that is presented to sustain that claim. Nowhere in the pleadings, Your Lordship, do we have this concept of social cohesion being a form of harm that is threatened by the song. It's a mere claim that appears for the first time in the heads of argument. It's unsubstantiated by any facts or evidence whatsoever. In any event, social cohesion is not an idea that there must be uniformity and that we must all agree. That's not what social cohesion is. It's an understanding and appreciation of our diversity within the collective. So the fact that I may sing or say something that offends you does not in itself result in erosion of social cohesion. And even if it does, it's one that is protected by the freedom of expression. We've already made the point about prohibited grounds, Your Lordship, that nowhere in the pleadings do we get a definition of what, or rather, a clear sense of what the prohibited ground that's relied on is. Now, for the first time, we're told that actually it's the word boer, and the word boer is a prohibited ground. Well, this is interesting, because when I don't know if I asked the question or my learned friend did, but Mr. Rhodes was asked, it could well be in his book as well. When he was asked what is the meaning of the word boer, his response was, it is the Afrikaans word for farmer, but it is also a word referring to a particular ethnic group. That was his answer. And we make reference to where we find that. It's in the transcript of the 8th of February. That was his answer. He does not take the point further to say, notwithstanding this dual meaning of the word, this is the one that the song implies. He does not take the point any further. Your Lordship, in the Masuku decision, for example, the question of Jew and Zionist rather, was integral to the case in the same way as the interpretation of what boer means is integral in this case. Experts were called to testify on the meaning of the two words. Similarly here, Your Lordship, you can't just be told this is the interpretation you must prefer of the two meanings of the word boer, without any underlying evidence that justifies why you should prefer this meaning of boer instead of that, particularly in light of the fact that Mr. Rhodes himself says boer means one of two things. Well, in which context then is boer used in the song? No evidence to that effect. And you're going to hear for the first time in reply as to why you should prefer that meaning. Nothing in the pleadings. And we suggest, Your Lordship, you must adopt the meaning farmer to the song, not the Afrikaner reference or meaning to the word. And we say this for a number of reasons. One of them is this. The lyrics to the song are, kiss the boer, kiss the farmer. It is an interchangeable use of the same word. Once said in Afrikaans, second time said in English. Kiss the boer, kiss the farmer, interchangeable use of the same word. That has not been controverted, neither have been told why we should prefer the Afrikaans interpretation, the Afrikaner interpretation of the word boer. And then, of course, Your Lordship, and this is what was puzzling about the prohibited ground that's now being proffered by my learned friend. Because for the first time, where there's an attempt to give a meaning to the word boer, they say in their heads of argument at paragraph 271, the tenor of songs like Kill the Boer have an evident and obvious vilification effect. whites and Afrikaners are portrayed as the eternal enemy of black South Africans. Now, is Boer both whites and Afrikaner? And if not, where in the lyrics does the word whites come in? Again, there's that, there's no disambiguity as to what the word Boer stands for. That's the first point. But of course, they also appreciate that it's actually a song about farmers, because in 272 they say, there is a good reason to believe that the chanting words that call on people to kill farmers in a climate where farmers are frequently tortured. So now the focus is not on Afrikaners, it's on farmers. But we of course know that the demographic of farmers is not exclusively Afrikaans-speaking people. So again, there's that shift of what exactly does Boer mean. So now, on just these paragraphs, it could mean an Afrikaner, it could mean a white person, it could mean a farmer in general. Again, we make the point then, it could be either meaning could be given to the song, and we've never been told precisely which one they're relying on, and in any event, there's no evidence to contradict our version that it's a reference to farmers. And I think the biggest indicator that there's an appreciation that this song is about farmers, the entirety of the evidence by the complainant, from the first expert witness to the last expert witness, including the two lay witnesses, has been evidence exclusively about farm attacks. Not once did we hear evidence about attacks on Afrikaners or any of the prohibited grounds. That's the biggest indicator of what this case is about. The entirety of the evidence has been evidence exclusively on farmers. But we of course know, by the admission of Mr. Ross himself, that farm attacks and farm murders are not exclusive to one racial group or any of the prohibited grounds. So the stats that he himself quotes might well include race dynamics, where the white person kills a black person. It could be a black person killing a black person in a farm context. That's the entirety of the evidence we've had. Nothing about the evidence of Afrikaners being the target. Not a shred of evidence in that respect. So this case is about farmers. The difficulty my learned friend has with respect is that farmer is not a prohibited ground, which is now why he must give it a different meaning that fits nicely with the Section 1 definition of prohibited ground. That is how they end up with an interpretation that Boer must mean an Afrikaner, whereas there is no evidence whatsoever on the murder and attacks of Afrikaners specifically. And then, Your Lordship, as I had said, Section 10 says there must be a clear intention. The Constitutional Court in the decision of Kula Ide said the following about statutory interpretation: they must be interpreted purposively. The Britannica Dictionary defines clear. Now, it's important to understand what the context of clear is. Section says there must be clear intention that this is what Mr. Malema is intending with the singing of the song. And once there's doubt in your mind, in other words, not just intention, but clear intention. What does clear mean? Very obvious, not causing or allowing doubt. So once there's a shred of doubt in your Lordship's mind, on the basis of the evidence that I've presented to you about what the intentions of Mr. Malema and the EFF are when they sing the song, then you can't find that it is hate speech. This is particularly so because former leaders of the ANC themselves, who were there when the song was formulated, attest to what the song means. Of course, we accept that we will not take their versions of the song, but it's part of the context that once evidence starts piling up and looked at cumulatively, suggests that there's no clear intention to cause harm, then you can't find that there's hate speech, Your Lordship. And I'm making reference to the speech of Mr. Thabo Mbeki, which was broadcasted here, about what the song means. They were there when the song was formulated. They know what the song means. The only person coming close to even giving an interpretation of that song on behalf of the complainant is Mr. Rhodes, who for one reason or the other only knows the meaning of the song post-1990. Now, I don't know what the relevance and importance of 1990 is, that it's only at that point he knows of the song. But once he makes the concession that he does not know the philosophy of the song and the origins of the song, which was his eventual concession, then, well, what other evidence do we have of what the song means? Similarly, Mr. Putamukaba, who popularized the song, gave us a view of what the song means, and it is nothing that has been suggested by our learned friends. And then, Your Lordship, I've already dealt with the question that there was an official state-sanctioned report that said 83% of the murders, farm murders, are caused by robbery. And within that 83, for all we know, there are workers who are being murdered. 2% only is race-based. And then Mr. Rhodes criticizes this idea. He calls it the single cause effect, I think he calls it. And it's this idea that simply because it's a robbery does not mean there's no secondary or even primary motive. You can have a fusion of motives for the same act. And we accept that. But that is precisely what the report itself says. It makes that point. And let me read the extract. Perhaps before I do, let me take you here, Your Lordship. Case lines 1330 of the report, which is the report, sorry. There seems to be a perception, this is now the report we dealt with earlier. There seems to be a perception that it happens frequently that a farmer or his family are attacked but nothing is stolen. That is often seen as proof that the motive for farmer attacks is not robbery but something more sinister. Often these cases receive much publicity, reinforcing the belief that it is a common phenomenon. The committee's investigations show, however, that there are relatively few farm attacks where nothing is robbed without there being a logical explanation for it. And then they make an example of a case that received quite prominent publicity, where there was a claim that farmers were murdered but nothing was taken, only to find out there was actually evidence of the car and property being stolen on the property. But the more important point I want to make, Your Lordship, in response to this criticism to the report not taking into account that other factors may have played a role. Could bear with me, Your Lordship. I can't seem to find it. I'll revert as soon as I find it, Your Lordship. But all the report simply says is this, that it accepts that there are various factors that may inform a robbery. But what is crucial is that for you to reach a conclusion that a robbery was also motivated by a race element, there must be evidence to suggest the race element. It can't simply be, simply because 100 Rand was stolen, then it must be that it was racially motivated, because that's the argument by my learned friend. Well, that begs the question. What of instances of a black person in the township murdering another person in the township and they only take 100 Rands? Is that racially motivated? There's no logical flow between the argument that simply because I took something minuscule of no great value, then it must follow that it was a race-based robbery, or any other factor for that matter.
If I understand, the argument is that, and then I think we dealt with this early on, is the issue of causality. They're saying they're not relying on causality in as far as the harm is concerned, but what they're seeking to show is that the singing of the song is sung in the context where the farmers are faced with a high level or incidences. Let's not even go too high.
Yes.
Because as I understand, our constitution protects everybody. It's not going to be based on we will determine how many crimes are committed in the country and then determine whether there's need to prohibit. What the legislature sought to do was to prohibit any harm being done to any person. Now, their case is the singing of the song in the climate where there's already murders in the farms. It's inappropriate, and the court needs to intervene for that reason.
Well, with respect to your lordship, the test is not that simple. It's not just a question of does this song cause harm, and to the extent it does, the policy decision of the Act is that it must be prohibited. It does not start off, is there harm? It says, on one of these prohibited grounds, someone publishes information or ideas or sings a song with the clear intention to cause harm. What that means, your lordship, is it is not enough that it merely causes harm. You must first find that there is a prohibited ground that has been implicated. And now it's suggesting they failed to prove that. The second and the fundamental aspect your lordship must decide is, when Mr. Malema sang the song, did he have a clear intention to cause harm? Because even if harm results, but there was no clear intention on Mr. Malema's part, then that's not prohibited. So with respect to your lordship, it cannot be that simply because there's harm, therefore it's prohibited, with disregard to the fact of prohibited ground and clear intention on the part of Mr. Malema. Which is why I say, your lordship, they failed. Because even if we want to mitigate against the risk of harm being caused, the fact that you can show that the song can lead to harm in itself is not enough. You must have no doubt in your mind that Mr. Malema intends to cause that harm. Now, in light of the evidence we've heard from Professor Ghana, Mr. Malema himself, about what the song means and what it's intended to mean, once there is an element of you buying that argument, then it can't be hate speech. Your lordship, I'm going to fast forward to the question of res judicata. We say, your lordship, certainly in respect of Mr. Malema, res judicata is clear. We're going to suggest that the same principle should apply to the other respondents as well. But let's start with Mr. Malema. At paragraph 335 of our heads of argument, we've set out what the test for res judicata is. It says there are three requirements that are required for you to rely on res judicata. The first is that it's the same parties. The second, that is based on the same cause of action. And the third is that it's in respect of the same subject matter. It says once you establish those three factors, then you can rely on the defense of res judicata. That's the Bafokeng tribe decision. It says once you show those three elements, then you can rely on res judicata.
And they must be shown all the three.
Well, with the qualification, let's start with the all three. There's a qualification, your lordship. They are not immutable requirements, but let's start with the three. For Mr. Malema to rely on res judicata, he must show that they're same parties. It is common cause that the complainant in this matter and Mr. Malema are same parties, in a sense that when the Duwulupuno matter, they were both parties. Same complainant complaining about the same respondent. So the first requirement is met. The second is that it's based on the same cause of action. Same cause of action, pepuda, hate speech. That requirement is met. Thirdly, in respect of the same subject matter, kiss the boer, the wilipun. And we know it's the same song because the pleadings by the complainant, or rather the complaint affidavit itself says it's the same song with different translations. So once he's met those three requirements, then you can't find against him again on the basis of res judicata.
But in the context of this act, it then means you can make statements that in circumstances exhibits clear intention to cause harm, and your defense would be res judicata. Let's assume in the previous case, and we've already said that in the previous case, the test applied was not the test that now has been determined by the Tolani case. Now, taking that into account, it means you can plead res judicata on the basis of same issues or same pleaded complaint.
Are we assuming there's an order that prohibits you, Your Lordship?
That prohibits who? Me or the other court?
So let me understand Your Lordship's question. Let's take the effects of this case.
Yes.
Your Lordship, once there's a judgment that says you may not sing the song, same parties, same facts, same subject matter, of course then your remedy lies elsewhere, contempt of court. Because the problem now you're dealing with is contempt of court, not a question of whether you're allowed to sing the song or not. What I'm simply saying, Your Lordship, is this.
But sorry, Mr. Kasibota, sorry to interrupt you. Contempt of court. Which court, when the court that made the decision, the court never made an order that prohibits the singing of the song. All what the court said was there'll be harmony and peace between the parties. Because as I understand your argument, res judicata would arise from the SCA judgment. It can't arise from Judge Lamont's judgment because that judgment was taken on appeal and the party, for whatever reasons, decided to, I would call it, amend that order.
No, Your Lordship, with respect, res judicata applies to your brother's judgment. Let's read the extract again. From the aforegoing analysis, I find that the essentials of acceptable res judicata are threefold. Namely, the previous judgment was given. In other words, a judgment was given between the same parties, same subject matter, and the same cause of action. But let's assume I'm wrong on that score, Your Lordship. Let's assume res judicata applies to the SCA order. The same principle applies. All we're simply saying is there's finality in the matter in respect of the same parties. Because let's have reference to what the order says. Paragraph 3 of the order. The parties have agreed to a full and final settlement of their dispute on the following terms. What that says to me, Your Lordship, this is not Mr. Malema's agreement, because the impression that is being created is that he's not abiding by his obligations. It's the parties' agreement. It's reciprocal. So all these obligations that are shown here are not just obligations that bind Mr. Malema, they equally bind AfriForum. But the point I'm simply making, Your Lordship, is that the parties themselves have agreed. AfriForum and Mr. Malema have agreed that in respect of Duwulibunu or Kill the Boer, the parties have come to a full and final settlement of their dispute, and that is made an order of court. The difficulty you have, Your Lordship, is this.
Yes, go ahead.
If you find against Mr. Malema and you say it's hate speech, you must pay 500,000, how then do you square that up with the order of the SCA. The effect of that is you overruling the order of the SCA. I need not make submissions, Your Lordship, as to why that is inappropriate. All I'm simply saying is AfriForum, for whatever reason, and if they want to come back and say it was an ill-advised decision, then they must deal with the SCA order and how to expunge it. Then perhaps we can have this debate again. What is unacceptable and untenable is the High Court saying to Mr. Malema, you are guilty on the one hand for the exact same act, whereas the SCA order says, well, we will not find you guilty of the same act. Then which of the two orders binding? That's the difficulty that you are seized with, Your Lordship. What should have happened if AfriForum wanted to pursue this matter is to expunge or get rid of the SCA order that they themselves are party to. Then we don't have an issue of, well, Your Lordship, then what do you do with the SCA order? Because that's the live issue in front of you. Hence, we raise the res judicata argument.
Seems to me the difficulty is a typical difficulty of making settlement agreement orders of court.
It could well be, Your Lordship, but it is what it is now.
Yes. Okay.
In sum, Your Lordship, what we've shown is that there's an SCA order that says, in full and final settlement of the dispute. What's the dispute? Dubule/kill the Boer. Who is it between? Same parties in front of Your Lordship. Cause of action, the song. Subject matter, Dubule in terms of Section 10. Once those three are met, then you can't find against Mr. Malema again. We say, Your Lordship, with respect, and let's correct this misconception, Your Lordship, that Mr. Malema is in contempt of this order. Firstly, you are not told how. That's the first problem. It's not in the pleadings.
Which order are we referring to?
The SCA order, Your Lordship.
Okay.
The allegation is that Mr. Malema is in contempt of this order, which is why you must refer to criminal investigations. What you're not told, however, in the pleadings is how. How is he in contempt of the order? We haven't been told. Even in oral submissions, we've been told how he's in contempt of this court order. And it stems from this idea that Mr. Malema has got unilateral obligations in terms of this order. Well, let's read what the order says. The parties have agreed to a full and final settlement of their dispute. And then they list them, mutually recognize and respect the right of all communities to celebrate and protect their cultural heritage and freedom. How is that Mr. Malema's obligation and not AfriForum's obligation? Because if the argument is he keeps singing this song when it offends a sector of society, well, he's got a reciprocal right to the freedom that and heritage that he's being told he's also entitled to in terms of the order. So where's the contempt there, Your Lordship? Then there's an allegation that he hasn't undertaken to meet up with AfriForum. Well, have they undertaken to meet up with Mr. Malema? And he refused. No evidence to that effect. And I could go on and on and on, Your Lordship. The point I simply make is there is nothing in this order on evidence that evidences that Mr. Malema breached the order. In any event, these are reciprocal obligations. So the fact that the parties have not met despite these undertakings is not Mr. Malema's fault, particularly if there is no evidence to suggest that he's acted in contravention of any of these orders. That's in respect of Mr. Malema. Your Lordship asked me earlier on whether all three requirements must be met.
Well, then let's deal with the other party. In the other case, the party was the ANC. In this case, the party is the EFF. Is the still res judicata in as far as the EFF is concerned?
That's the point I'm getting at, Your Lordship.
Okay, I'm sorry, I beg your pardon.
No problem. Your Lordship asked me earlier, and it links to this question you're posing again, whether all three requirements must be met and in these exact terms. Well, this is what the court says. requirements 2 and 3 are not immutable requirements of res judicata. In other words, you can dispense with 1 or 2 of them if context so requires. The subject matter claimed in the 2 relevant actions does not necessarily and in all circumstances have to be the same. And then if we read further down where we underlined, conversely, in order to ensure overall fairness, 2 or 3 above may be relaxed. A court must have regard to the object of the res judicata that it was introduced with the endeavor of putting a limit to needless litigation, and in order to prevent the recapitulation of the same thing in dispute in diverse actions, with the concomitant deleterious effect of conflicting and contradictory decisions. What's the court saying there, Your Lordship? They say it has to get to a point where even if an individual was not party to the initial proceedings, can rely on res judicata. And then the question is, under which circumstances does that happen? In circumstances, to use the words of the court, with the endeavor of putting limit to needless litigation and in order to prevent the recapitulation of the same thing in dispute in diverse actions, with the concomitant deleterious effect of conflicting and contradictory decisions. What that means, Your Lordship, is if you find against the EFF today, you have created a situation where the same cause of action, the singing of the impugned song, is dealt with in different ways. That's what this judgment is trying to work against. It's
sorry, give me a second. No, Tulade. Thank you very much.
What the court is saying there, Your Lordship, you must relax some of these requirements in an instance where continuing with litigation on the same subject matter will have the consequence of conflicting orders in terms of how the matter is to be dealt with. If you find against the EFF, for example, in this trial, what we'll have then is an order of Your Lordship saying it's hate speech, stop singing it. You've got an SCA order that does not say that. These are the conflicting judgments and orders that are envisaged by that qualifier in Bafokeng tribe, in the Bafokeng tribe matter. And what they're trying to do with there, Your Lordship, is this. This is the absurdity of allowing the recapitulation of matters over and over. Should AfriForum lose here, for example, nothing then stops them from finding another member of the EFF and charges them for the same thing, simply because they were not party to these proceedings. That's what this court is trying to stop. It says once you've fully ventilated the issues and you've come to a final determination of how it's to be resolved, and I've made reference to the SCA order, and it's clear on how the matter is finally resolved. It says in full and final settlement, this is the outcome of the dispute. It says once that has taken place, to avoid the recapitulation and contradictory orders, you must apply the res judicata principle, even if it wasn't the same parties. For the simple reason, I hope Your Lordship captured the point, so I'm going to repeat it again because it's quite important. Because if AfriForum were to lose here today, what they can then conceptually do is find any other EFF member and charge them for the same thing, simply because they're not party to these proceedings. That's the absurdity that's being prevented by res judicata. And it also creates a situation where if you find against the EFF, by implication you're finding against Mr. Malema, what then does it do with the SCA order? That's in respect of the first respondent, because there's no charge against Mr. Ndlozi in respect of the Kiss the Boer song. Your Lordship, let me deal then with the question of whether Lamont J's, your brother Lamont J's decision is binding. My learned friend correctly points out that you may only set aside a decision, an earlier decision, if it's erroneous. But I'm saying, Your Lordship, you don't even need to get there.
You may ignore it or refuse to follow it, not set it aside.
Well, it's a semantical difference, but the point is the same, Your Lordship, that you're not bound by it ultimately.
Okay. I thought we may end up in a conceptual program about reviews and appeals. Okay.
Understood, Your Lordship. We say you don't even need to get there. We're saying, Your Lordship, the most obvious reason why you're not bound by the decision of your brother is the very fact that it is premised on an act or provision that has since been found to be unconstitutional. And it's not a semantical or just a mere technical point for the sake of technical points. It's important because, by and large, you can do a word search. I undertook this exercise, Your Lordship. You can do a word search on your brother's judgment, and you'll see the number of times where his ratios are premised on this idea of hurtful. Now, what I'm saying to Your Lordship is this. In as much as I accept that the Kwelane judgment only did away with hurtful, and the rest of the test still stands, there's a problem not of the doing of your brother, but there's a problem if that judgment is premised by and large on this concept of hurtful, which has been since found to be unconstitutional. That's the very obvious reason as to why you cannot rely on that judgment. Secondly, you being asked to do what you did and found the way you found, i.e. just follow because you're bound, is to rubber stamp his decision. Then why are we sitting in trial, Your Lordship? What you've been called to do is to exercise an independent mind as this court in terms of how you should decide the matter. To then say simply because Judge Lamont said kiss, kill, semantical difference, substantively the same thing, and for the sake of, well, it's a judgment that came before me, I can do nothing but agree, why are we sitting in trial? And the second important point, Your Lordship, to bear in mind is this. The judgment is being bandied about as if it's the be-all, end-all. Let's recall, Your Lordship, how we got to the SCA order. It was by mutual agreement between the parties after Mr. Malema and the ANC filed an application for leave to appeal, which, by the way, was granted by your brother. Now, as a result of that SCA order, which was the mediation agreement, they've forsaken, or rather, they lost the opportunity to challenge that judgment. So again, it is not because of the doing of Mr. Malema or the ANC that we don't have the opinion of the SCA. It's simply by agreement between the parties. Surely then that can't be held against the respondents in this case. The substantive difficulties we have with your brother's findings are these. The first, your brother, and I cite the paragraphs in his judgment, he says, if the words mean different things, he was talking about Duli Bono now, and this is paragraph 304 of our heads of argument. If the words mean different things to different portions of society, then each meaning for the reasonable listener, in each portion of society must be considered as being the appropriate meaning. Now let's just stop there for a second, Your Lordship. What your brother is saying, let's assume this debate is about the Afrikaner community versus the black community for argument's sake. Let's suppose that's the issue here. Your brother says, if a sector, the Afrikaner sector, gives this interpretation of this song, that's the reasonable understanding of that song. If the black sector understands the song to mean this, that is the reasonable meaning of the song. Now, those are obviously mutually destructive propositions. It can't be both if our understandings of the song are not the same. That's the first difficulty with the judgment. But having said that, it takes it a step further by preferring the interpretation of the one sector over the other. On what basis, Your Lordship, is that done? If his own finding is that both readings are reasonable, firstly, they can't be both reasonable, but let's suppose they are. On what basis then did he align himself with the proposition of AfriForum and not of the ANC? I've already dealt with the question of Section 10. The third reason...
No, but doesn't he say there that you take the two interpretations and you reconcile as to which one is the most reasonable one? Because if you weigh the meaning of words and you find that the two propositions, there's evidence before you that shows that there are two mutually destructive interpretation, then ultimately it's for the court to then say which of these is more reasonable than the other.
Well, except for that's not what he's saying, Your Lordship. That's the difficulty, which is precisely why we say you can't rely on the judgment. We accept that is the proper test. We're saying that's not the test he applies. He says, if you are from the Afrikaner community and your interpretation of Dubulibunu is that it is hurtful and hateful, and then you are from the ANC community, in the case of Dubulibunu, and your view is it's just a political song that's calling for land redistribution, whatever the case may be in relation to land. He says, for both those respective communities, provided they apply their reasonable minds, then both those interpretations are acceptable. That's mutually destructive, and that's the quote from the judgment itself, Your Lordship. You can have reference to it at one point or the other, but that's the argument by your brother, which is, with respect, of course, fallacious. And then, thirdly, Your Lordship, your brother, again, the criticism is that he relied on the Human Rights Commission internal appeal, which firstly relied on Section 16.2 of the Constitution. We, of course, know on the principle of subsidiarity that when you've got an act that gives bolts and nuts of the constitutional provision, then you must apply that act. The Human Rights Commission did not do that exercise, they applied 16.2. That's the first problem. The second problem, Your Lordship, is that since then, and I'll get the right party, it's called Freedom Front versus South African Human Rights Commission. That matter, Your Lordship, was without the presence of the respondents in this matter. It was an internal appeal that was done between Freedom Front and the Human Rights Commission itself. So it can't have a bearing on a party who was not there. That is the basic natural justice principle. Fifthly, Your Lordship, we make the point that, with respect, your brother moralized on the question of Dubulibun and went beyond the call of duty of a judge, which is to confine himself to the principles of law. He says, the message which the song conveys, namely destroy the regime and shoot the Boer, may have been acceptable while the enemy, the regime, remained the enemy of the singer. The enemy has now become a friend. Now, this is where I'm asking your Lordship to have regard. The enemy has now become the friend, the brother. Members of society are also enjoined to embrace all citizens as their brothers. Hence, the Equality Court allows no justification on the basis of fairness for historic practices which are hurtful to the target group but loved by other groups. Now, the difficulty here, Your Lordship, again, is that point that this finding of how society should organize itself is premised on this idea of hurtful. So even though we accept that it's just hurtful that was taken out of the test, but the very fact that he premises his finding on this concept of hurtful and makes a finding on how we should organize a society is the very problem. The second problem.
Can you just find out? Oh, okay. So somebody's just going to help us to find out what's the story.
Sorry, they just locked us in. Just trying to check the door.
Okay.
Go to the toilet.
Okay.
Your Lordship, I'm in your hands. I don't think I'll take more than 30 minutes. I don't know whether you want
You're not saying not
there's
more
going to
than
be
30
reply.
seconds.
Because my learned friend also has to do reply.
Yes, I know.
Also, we can proceed.
What option do I have?
In which case, Your Lordship, I was at the point where I was saying the other criticism of your brother's judgment, because you had invited us to say whether you should be bound by the judgment or not, and if it's applicable here. And the heads of argument, we didn't have the benefit of the heads of argument from our learned friend in terms of what their position is. So these are our bases. We're saying, firstly, that citizens are endowed with this idea of dignity and urgency. And there's case law to that effect in relation to the question of freedom of expression. The difficulty with the judgment by Judge Lamont is the failure to understand this whole idea of pluralism. It is not for the court to moralize on who should be friends with whom and who should be enemies with whom, that previous foes must now become friends. We of course accept that the Constitution has these lofty ideas about where we should go as a nation, but you can't take away the urgency of actors who are endowed inherently with this right to dignity and urgency of who they should be friends with. Because the upshot of what the judgment says is, stop singing this song. What you must do is become and play nice with AfriForum. Forget the historical issues that you have amongst the two of you. This is where you should be going. Now, with respect to your Lordship, that is moralizing rather than giving a legal interpretation to the question before the court. And then, your Lordship, it's the same with my learned friend's argument, which is to say, simply because when Mr. Malema sings the song, he gestures with a gun sign. The argument is, well, then he must mean the words literally. Well, again, there's a difficulty with that, your Lordship. I'm yet to see a political song sung standing still. The gesture is nothing but added performance to align with the words that are being sung. Your Lordship made an analogy of football during the trial. I'll make one too now, and hopefully the point comes across. There is a song, Tibagamona, Tibagamona, Ribulai Dinchatzen. Block that side, let's kill the dogs. Now, the very fact that the gestures are being used to kill these dogs, which is opposing fans directing to the other team's fans, does it now all of a sudden simply say, let's kill these dogs, gesturing with a gun, means suddenly now the speech or the song is literal? All the hand gesture does is add performance to the songs that are being sung. No political song is ever sung standing still. Lastly, your Lordship, on the question of your brother and his judgment, is the question of the clear intention you spoke about. And your Lordship, I cannot say this enough times. It's clear intention, not intention. Have regard to his judgment at paragraph 109. The test he applies is intention and not clear intention. To the extent he fails to understand that the threshold is higher than just intention but clear intention, in other words, with no scope of doubt, then of course then he's going to reach the wrong conclusion. And Your Lordship, I'm not going to go through our rebuttals. Our rebuttals speak for themselves at page 359, our rebuttals to our learned friends' written submissions. And then lastly, on the question of the remedies that they seek, if I can find them. Well, the first is obviously this question of contempt. Firstly, we've made the point that there's no evidence to suggest there's any contempt of the order at any point. Secondly, the question of the 500,000. I mean, of course, the SCA judgment binds Your Lordship. Without a trial dealing specifically with the question of damages, you can't entertain the question. There's been no evidence, albeit in trial, to suggest or justify the 500,000 rands. All we're told is my client wears Gucci, therefore he can afford 500,000 rands. Nothing on how do you get to the quantum of 500,000 rands. Manual judgment is quite clear on that score. And then the second remedy they seek is, where's it in my head again? Do you remember? I'm just trying to find the remedies they seek, Your Lordship. There you go. And then they're looking for perjury. Well, they're asking that you refer the matter for criminal investigation for perjury, because for the first time, we're told by my learned friend that the EFF received 3 million rands. He wears Gucci, therefore he must afford to pay 500,000 rands. Well, firstly, that's evidence from the bar that is uncontested because we've never had an opportunity to contest it. It can't be simply because you wear a certain brand that necessarily means you can afford a certain amount of money. In any event, there's never been any evidence other than the evidence of my learned friend on that score. And Your Lordship, I know I've really overextended myself. On the question, I just want to be clear that we do not abandon the question of or our defense in relation to the unfair discrimination. We don't think it's genuinely sought. It's just put there as an alternative and a second bite to the cherry. The heads of argument speak for themselves. Firstly, there's no been raised or prohibited ground that has been shown there. We also make the point that that provision on a proper interpretation deals with the questions of labor laws, access to parks, and so on. It is not meant to deal with this because it deals with the concepts of propaganda and this idea that on the basis of a prohibited ground, you're not allowed access to certain things. That, Your Lordship, is more concerned, like I say, with labor laws and access to parks. You may not simply because someone is white not allow them to a park, for example. That's the sum total of what 7 is about, and the heads of argument speak for themselves on that score. So just so there's no confusion about whether you're abandoning it or not. And we're saying for those reasons, Your Lordship, the complainant must prevail. Lastly, Your Lordship, you asked us to comment on the costs issue. We suggest, Your Lordship, that this ought not to have run for as long as it did. From the start, we did say a large part of the evidence by the complainant was unmerited, particularly the evidence of the 2 lay witnesses. What was intended with those 2 lay witnesses, despite your advice that we don't need evidence outside of the pleadings, what was being done there, Your Lordship, is to try and link the two, the song and the harm. All they've simply told us is that I suffered a robbery as a farmer, and I suffer from psychological effects as a result of that. That's Mr. Prince's version. Ms. Muller says, I don't suffer any consequences as a result. Well, then we must ask the question, what was their relevance? What value did they add to these proceedings with respect? Similarly, the evidence of Mr. Rhodes dragged on for nothing shorter than 2 days. on matters that have nothing to do with the case, political matters where Mr. Malema was targeted politically. Evidence about genocides were being led to a point your Lordship came and intervened to the effect of, let's focus on what the subject matter is. We certainly shouldn't have run for as long as we did. And certainly my respectful view is this, particularly in respect of Mr. Human. It is wholly unacceptable and untenable that in a trial we spend time listening to hearsay evidence of someone without any corroborative evidence, Mr. Human specifically. No affidavit is brought to support his version. We're sitting here listening to his ipse dixit. And with respect, that is precisely why I was never cross-examined, because this court can't seriously take his evidence. And Your Lordship, in respect of the submission of the evidence, the new videos, we make reference to, well, in my heads of argument I do, but I don't in the version that I've given you, Your Lordship, and I promise this is the last point. What my learned friends have cited in the application to submit this evidence is one part of that judgment. And I'm asking Your Lordship, because it's not in the heads, to make note of it. This is a paragraph 40 of Woodway CC versus Valley. They rely on that decision in their application to have this evidence admitted.
Just give me the judgment again.
It's Woodway's.
Oh, Woodway.
Yeah, Woodway's CC versus Valley. It appears in their application. They are replying affidavit to the application for admission of the evidence. And it's paragraph 40 specifically that I rely on, which they did not make reference to and which is dispositive of the application. And it's their own judgment, but they failed to cite paragraph 40, which says, it is correct that where the parties are asked in a court of law to plead their cases, they would normally not be permitted to venture outside the ambit of the disputes outlined by those pleadings. And you've been at pains, Your Lordship, to make that point, that, Mr. Oppenheimer, is it in your pleadings? Multiple times you've asked that question. That was obviously an invitation to amend their pleadings such that the facts that relate to this matter are discussed by myself and the client, and we make submissions in that respect. And the reason why there must be an amendment, Your Lordship, the court continues, a party cannot rely on cause of action or defenses which are not put up in issue, were consequently not fully investigated. In other words, you can't simply because, well, it's a relaxed court, you just bring up evidence which has such an important bearing, by the way, because it's not some innocuous evidence. It goes to the heart of the matter. The court says, where the court says you must bring an amendment because you kept asking the question, have you amended your pleading such that you include these videos? The answer was no. And the court says that cannot be permissible because it deprives the other side of the opportunity to fully investigate the matter. Of course, we could not fully investigate the matter because the first witness that testified on it was someone I was given literally 10 minutes to talk to, and then he came and gave testimony. Similarly with Mr. Malema, he was attending SON at the time. He comes here, he's confronted with these videos, he's asked to answer to them, and they go to the core of the case. Clearly, there was not ample opportunity to fully investigate. We ask Your Lordship to have consideration to that paragraph, and it builds on this idea that at pains you've been making the point that they must bring an amendment or at least supplement their papers such that we can properly respond to the allegations that are being made. Your Lordship, unless you've got questions for me, I wish to not detain you any further.
No, thank you very much. In reply, Mr. Malema?
My Lord, I endeavour to be as brief as possible. My learned friend has an unbelievable ability to invent legal tests on the spot. Your Lordship was told you must have no reasonable doubt in your mind when you're applying the test. There's no reasonable doubt test from any of the courts when they're interpreting what Section 10 says. He invents this. He says that the complainants brought a case that was premised on this idea that there must be a strong causal link between the song and real-world attacks. He invents this. That's never the threshold test that the complainant ever had to meet. The point of all the evidence that was led, as I started out by saying, was to meet the actual test, which is what's the context in which the speech occurs. There's further inventions with regards to what the intent test is. My learned friend said on many occasions, we must find out what was in Mr. Malema's mind, what was his intent. I stated earlier, that's not what the test is. The test is, what is the meaning of the text? It has nothing to do with what the intention of the speaker is. We're not in a criminal standard here. We're not trying to peer into the mind of someone who kills someone else and we work out, did you do it intentionally or not? We're in a situation where we're doing an objective reading of the text. My learned friend makes reference to Professor Gunner and says, she's given us the definitive meaning of this text. And it's uncontroverted. But he neglects to mention that the Constitutional Court in Kolani says it is only this court that gets to determine what the meaning of the song is, and that any evidence laid on it by an expert is irrelevant. So of course there's no need to counter it with our own expert of what the meaning of the song is. That evidence has no status whatsoever. It is only this court that can determine what the meaning of the song is. With regards to these sort of claims about hearsay evidence, firstly we must ask, what is the purpose of the evidence that was led by the complainant's witnesses? Well, it matches exactly the structure of the evidence of the witnesses in Kolani. It's to give evidence of what does the society look like, to give this broad sociological evidence or criminological evidence. That's what Mr. Roots does. So this notion that when he talks about specific instances of someone being tortured, that person needs to come and testify to endorse that, that's not the purpose of the evidence. The purpose is to give this broad sense. What you have in the Kolani case, for example, Ms. Mokwena talks about a number of people who'd suffered homophobic violence. Those people weren't called to come to court to corroborate it because she's giving evidence of a general trend. It's also useful to get the story from the horse's mouth. So MN, who testifies in camera in that matter to protect her identity, talks about what she personally endured. She doesn't say, people in my community read Mr. Kolani's article and because of that I was harmed. She says, I just want to tell you what it's like to be a black woman who's a lesbian in townships. And let me give you an indication of what the social climate is. And that's exactly what the evidence of Mr. Prinsloo and Ms. and De Leon's evidence is to say, this is what a farm attack involves. That's giving all the context that's required by the case law. Now, Lamont, in his judgment, when he's talking about evidence, makes reference to the fact that in that matter there was hearsay evidence that was led. But we're not dealing with a criminal case or a civil case where it's hearsay evidence to prove a certain thing, because we're not saying, on this occasion, Mr. Malema sang this song, and this person was killed, and we need to tie up all the pieces in that manner. That's not the obligation that's on the complainant. The obligation is to say, this is the song that was sung. It constitutes an incitement to cause harm, because it calls on people to perform a harm. It tries to persuade them, to agitate them to perform this harm. And that harm would, of course, be of a physical nature if you're calling for those people to be killed. And then there's direct evidence of Mr. Prinsloo saying, well, let me tell you what it's like when I hear that song. The fact that he says, look, I don't know if the people that attacked me were motivated by the song or not, that's not relevant. What's relevant, he says, when I hear that song, it causes this re-triggering of my trauma. That meets the other element of the test in Kolani, which is the speech itself directly harmful in the sense that it causes a psychological trauma? And that's very much what we have. He says, when I hear that song, it brings back these painful memories of my wife being murdered. So I'd submit that the evidence led by the witnesses is all relevant and meets the tests, the actual tests, not the tests that are invented by my learned friend. There's also this sort of move to try and paint certain witnesses black by saying, Mr. Krauser works for the Institute for Race Relations, and the Institute for Race Relations once received money from AfriForum. Mr. Krauser testified, firstly, that he said AfriForum paid for certain projects, unrelated to the work that he does, that they specifically take a view of, we are not paid to say things. And he gave evidence about them holding up a letter from Rand Merchant Bank, where Rand Merchant Bank said, we don't like some of the stances that you've taken publicly, we're going to withhold our funding. And they said, well then, I guess that's the end of our financial relationship, because Institute for Racial Relations will continue to say what it needs to be said. And so they've shown themselves not to be beholden to any funding at all. But it's this sort of cheap tactic to try and discredit Mr. Krause's testimony. Mr. Krause gives enormously useful testimony because he says, I was present in Senekal. I was there when the EFF held their rally. I could hear members singing the words, kill the Boer. Now, this line that, how could we possibly know what affiliation these people had? My learned friend even goes so far as to say they weren't wearing EFF regalia. Well, the video that we started off showing shows very much red T-shirts with EFF badges, hats, shirts. This is members of the EFF crowd. If we want to take the view, well, we didn't personally inspect their pockets to see if they had membership cards, it starts to take things to an absurd degree. And again, this kind of recalcitrance on this, Mr. Malema, when asked about the members outside, says, those people are my voters, those people are my supporters, those people are EFF members. And then very quickly renounces that and says, well, how could I possibly know? But doesn't denounce what they're doing, doesn't distance himself from that. If you really had a situation where the party said, or Mr. Malema said, look, I don't know who these people are, and I distance myself from what they're saying, we don't believe in singing Kill the Boer, and what they're doing is reprehensible. If they are members of my party, we'll discipline. If they're not, I denounce them. That's not what we have at all. My learned friend cites the Gordon case and does quite an artful job, I must say, of picking the points that would try and make this line that, well, that speech wasn't hate speech, even though there's a racial reference. What Judge Sutherland does quite clearly, at paragraph 20 of that judgment, he says, in my view, the attack to the applicant in the utterance was personal in nature only. In other words, he says, when we're talking about beating the dog, it's referring to Gordon himself. It identifies him as a member of the Indian group, but it's not aimed at the Indian group, and that's why it doesn't meet the hate speech threshold. So the nature of hate speech is that it targets groups. And so if what Mr. Malema had said in that instance was, we need to go out and beat the Indians, well, then it would meet the hate speech threshold. But what he's talking about here was beating Gordon, and that's why it doesn't meet the hate speech threshold test.
Just give me 1 second. Thank you. You may proceed.
There's also this strange line to say, I mean, we couldn't possibly understand what the word Boer means. Or Boer can only possibly mean farmers, and farmers aren't a protected category. What we have are two legs here. The one is farmer and the one is Boer. Those are the two groups that have been targeted. Mr. Malema's testimony is farmers means white people. He says, when I hear the word farmer, I think about a farmer, I envisage a white person. So even if it was just a case on farmers, the threshold would be met. It's on the grounds of race. But it's also about Boers. And there's ample case law that says Boers are people of Dutch heritage. They are an ethnic group. They're a racial group. Throughout Mr. Rutz's testimony, he refers to white Afrikaners. The two witnesses who testified about their attacks are white Afrikaners. The huge list of people that were murdered are white Afrikaners. It's very evident what Boer means. It's true it can have a dual meaning. In other words, it can mean farmer, and it can also mean someone of this heritage. And Lamont in his judgment says Boer means Afrikaans, people who are white, and also including that subset of them who are farmers. So it's clear that it's both. It's a finding that was made by the Human Rights Commission. They say it's obvious that it's on the grounds of ethnicity and race, and I'd say it's obvious in this situation as well. And yeah, there's something sinister about saying we suddenly don't know what Boer means, and you can say whatever you like about these people and call for their extermination. No one could possibly know who it referred to. I mean, in the Masuku case, this kind of question comes up, where Mr. Masuku refers to Zionists throughout, never says the word Jew. And the court sees right through it and says, look, not all Jews are Zionists, not all Zionists are Jews, but the overlap between the two is absolutely gigantic. And it's clear that when you're referring to Zionists, you're referring to Jews, and that makes it a ground on the basis of religion, and therefore a prohibited ground. With regards to my learned friend's critiques of the Lamont judgment, insofar as the term hurtful is used, it's true that that's been scrubbed from the test, but ultimately the ratio in that case, Lamont uses the full, complete test, in the sense that he says it's propagation of hatred and incitement to harm. So that meets the new threshold test. And so that's the ratio, and that's the basis where he makes his findings. And so all the elements where there's ratios on that test are presumptively binding on this court. And the res judicata argument, it's astonishing. It's to have a situation where, let's say, Valapi Kumalo, who's held liable for hate speech, where he says, he says, white people, we should do to white people what Hitler did to the Jews, and there's a finding against him, and it's found to be hate speech, he's made to apologize, and then let's say 2 weeks later, he does it again. And a fresh complaint comes up and says, on this later occasion, you went and did exactly the thing that you were punished for before. He says, well, res judicata, you can't possibly punish me. I've already been punished for doing this. No, but it's a fresh instance. In other words, if AfriForum laid a complaint against Mr. Malema and said, in 2010, you sang this song, well then yes, it's res judicata, obviously. In other words, that particular instance has been dealt with by the court.
Isn't the question of res judicata really an issue of public policy? Now, I wrote in a judgment recently, and thanks to the people sitting in front, they were able to find it immediately. It's in Novella versus Shomwani and others. It's an unpublished judgment, and I said something to the following, at paragraph 14. It is tried that the doctrine of res judicata is founded on the public policy that requires finality on issues in dispute in litigation. It is a defense for a litigant faced with continued litigation of the same matter concerning the same issues and involving the same parties. The inquiry into whether the defense of res judicata is sustainable is not whether the judgment is right or wrong, but whether there is a previous judgment which concerned the same parties and whether the issues raised in the current litigation were resolved in that judgment. That's the judgment I penned recently.
Yes, my lord, I'd submit that's a very accurate representation of what res judicata involves. My learned friend talks about the dispute being resolved, and by this agreement. What was the dispute? It was the singing of the song on these particular occasions in 2010. That's resolved by an agreement. One can imagine if you kept going after someone for the same set of facts on the same occasion, well, of course you'd be protected by res judicata. But if someone performs a new offence on a later occasion, well, that's not protected by res judicata. The example that's given in Beck's Principles of Pleadings on this issue is someone who sued successfully for failure to make a rental payment in a particular month. And there's a judgment that says you must make this rental payment. And then the next month, they don't make a rental payment. And they are then sued for that failure to make a payment. Beck says, well, it's the same parties, it's the same issue of non-payment of rent, but it's a new cause of action because it's a new occasion in which rent wasn't paid. And so obviously it's not res judicata. And that's what we find ourselves here, in that it's a new occasion in which Mr. Malema sings Kill the Boer. I mean, what's astonishing, if we thought about applying my learned friend's res judicata test, is that basically you could have a situation where we say, let's treat all crimes like declaratives. One person has committed a murder. We now know that murder is unlawful. We don't need to have any more murder cases. We know murder is unlawful. There's no point in prosecuting anyone. They're all protected by this res judicata principle, and therefore no one should ever be prosecuted for murder. Now, your Lordship correctly pointed out that if what was sought was identical relief between the parties, let's say a permanent declarator about the song, and that was granted by one court and held, wasn't set aside by the Supreme Court of Appeal, and then the same relief was sought between the same parties, and there was no other relief about interdicts or punishment or anything like that, it was just solely on the declaratory question, then I think that would be res judicata. But that's not the situation we find ourselves in. The declaratives were made in the Lamont judgment about those specific instances. The order itself was set aside, and what we have here are new instances of the singing of the song, therefore cannot be res judicata. And this court has all the power in the world to make findings of fact and determine whether Mr. Malema should be held liable for hate speech and unfair discrimination. With regards to the Fire Brigade song, as I say, my learned friend was at pains to say, well, there was this insinuation that there were farms that went to light a couple of days later, and that must prove a causal connection. No causal connection needs to be shown. What Mr. Krauser said is it at least raises the question of the fact that farms are being burnt 3 hours away, close by, a couple of days later, and Mr. Ndlozi is saying, let's go burn these Boers. It's not definitive proof that there's a causal link, and it's not what's required. But it at least raises the question. What's required of the complainants in this case to say, does it constitute hate speech? So is it propagating hatred against the group, saying burn these Boers? Does it call upon people to do something? Yes. It tells the crowd, go and burn them. Now, it turns out that we've had a number of fires, and in the bundle, there are a number of instances where Mr. Ndlozi is seen to discuss these kinds of fires. The most famous one, of course, is the burning of Parliament. Now, at page 1622, the bundle, Mr. Ndlozi says, we must welcome the fire in Parliament as an opportunity to move Parliament to Tshwane. He says, then showing an image of, this is at 1624, an image of Parliament burning, a tale of a beautiful fire. No lies about best-run city and or province will stop it. Parliament building in the self-destructive mode to offer us the gift of a new beginning. We must move to Tshwane. So this is someone who celebrates the burning of the Boers, of Parliament. There have been a number of fires of other kinds of structures in South Africa. This is a dangerous thing. And I don't have to prove that there's a causal link between Mr. Ndlozi saying these things and Parliament being set alight. But there is a question that gets raised when someone says it's okay to go and burn things, and then they do actually burn, that we should take notice. We should say, well, the speech is an incitement, and it might very well be worth punishing that speech and encouraging people not to engage in that territory. My learned friend also cites a number of songs where he says, well, clearly the song is metaphorical. So there's songs about, I will never visit Natal. Well, just because there are some songs that are metaphorical doesn't mean that all songs are merely metaphorical. Some songs can be very literal. Some songs can use metaphors that have a literal meaning. So in Rwanda, when they said we must go out and exterminate the cockroaches, it was using a metaphor, but it literally referred to a particular ethnic group, saying these people must be exterminated. So, and even the evidence of Professor Ghana is to say that, well, songs can, in the right circumstances, be calls to action. That in the Rwanda cases, they were seen as promoting genocide. So these instances where a song only has a figurative meaning doesn't mean that the clear case of Kill the Boer doesn't have a literal meaning. One thing, my learned friend refers to an article by Rosenfeld, which implies that we should have different rules for different races. In other words, those that are marginalized should be treated differently. That article is from 2006. It's a foreign article. It's not binding on this court at all. And I would submit completely at odds with Judge Sutherland's finding in Kamala, which talks about enshrining the value of non-racialism and equality before the law. That those that are subaltern are not treated differently from those that are ascendant. My Lord, then I have no further submissions.
Thank you. Mr. Kasiboto, just one point that's been raised about the membership of EFF. I think it's at Senekal. Your case is that there was no evidence to prove that they are members of the EFF. Now, again, I wrote a judgment also very recently. Facts are not the same as the current facts, but very similar, where I'm trying to see. I'll get the name of the case in a moment. But the essential facts were that this particular individual walks into a shopping mall wearing a red T-shirt, presenting himself as an EFF member and demanding that the shop owner should dismiss everybody else and employ only the EFF members. And the argument of the EFF was that, well, look, he can't be our member just simply because he's wearing an EFF T-shirt, and also that he's claiming to be wearing an EFF T-shirt. And in my judgment, I looked at the whole issue of vicarious liability and also the issue of, which was addressed in one of the election cases, which dealt with the issue of the fact that political parties are registered parties, and that the relationship between the political parties and their members are very much akin to an employment relationship, which, as you would know, that vicarious liability concept is grounded mainly in the employment relationship. They really mainly emerges from cases involving employer-employee. But in that case, it was indicated that's the relationship. I'm trying to get to where I made my finding. Yes. In summary, a political party similar to an employer can be held liable for the wrongs committed by its members and supporters on innocent third parties. The underlying consideration for this is that the political party recruits members and supporters to promote and advance its political goals and put them out to interact with communities at large. Now, I think I emphasize this, that they interact with communities at large on the understanding that the communities see them as members of that particular political party. In doing this, it puts community members and other entities at the risk of harm or wrongdoing by such members. The recruitment of membership is put in motion by the political party, and thus there is no reason why, in fairness, the political party should not be held vicariously liable for wrongs committed by the member of the third party. In this case, we're not talking about wrongs being committed, but we're talking about people participating at a political gathering who are seen to be wearing the regalia of the EFF, as I understand it. Of course, a political party should be held liable for the conduct of its members when it is fair in the circumstances to do so. The underlying principle is to ensure that the public is not put at the risk by lack of discipline on members who fail to uphold the ideals and the values of the Republic's Constitution. Here we're not talking about them committing any wrongdoing, but as I understand their case is, for all intents and purposes, standing there looking at the people who were present, they represented the members, or they had the regalia of the EFF.
Well, I'm grateful for the engagement, Your Lordship. And it sounds eerily like the Cream case in Midrand. Was it perhaps that matter? As I understand it, it never came before you, but the facts are similar. And Mr. Malema, in fact, testified on this. Something similar to that happened, where someone who presented themselves as an EFF member, which they were, in fact, wearing the EFF regalia, conducted himself in a manner similar to that, something along the lines of, by X date, you must have fired X number of foreigners and employed South Africans. Now, that case shows the exact danger of the line of reasoning that's been proposed. Because Mr. Malema, because now the accusation was, that's the EFF's position. We accept he's a member, but that's the EFF's position simply because they're an EFF member. Evidence was led by Mr. Malema in this very court on that very issue. And he shows evidence where he denounces specifically that position adopted by that member. Now, that's the difficulty with vicarious liability and absence of urgency. It's very important to understand, Your Lordship, that simply because I am an employee, for example, that does not mean at all times without qualification, whatever I do, provided I represent myself as an employer for a particular employer, then it must follow that they're guilty. Particularly in this context, Your Lordship, because here we're talking about, this is why there must be a full investigation of what happened outside. and that paragraph 4 I made reference to. The difficulty is that what this court was told in Senekal is that EFF members sang the song. The difficulty is the video that was being shown, and I'm pretty sure you watch it again, Your Lordship. Watch it carefully. No one wearing EFF regalia sings "Kill the Boer." 2 individuals sing "Kill the Boer" in that video, both wearing black T-shirts. Now, to then say it's EFF members because they're surrounded by EFF members creates a problem for the EFF, because then, to quote-unquote Mr. Cross, then you have vigilantes infiltrating a good cause. And simply because they're associated with a group, EFF, it must follow the EFF is guilty. It can't be. This is precisely why we're saying, Your Lordship, even with the events that happened outside of court, I alluded to this problem to court, and I said the danger with calling Mr. Malema to testify on this, and he did not take my advice, to his detriment. But the point I was making is the case law says you must allow a full investigation, because once you do a full investigation, you start to see these cracks. These people were unled, Your Lordship. There was no leadership of the EFF leading them in song, nor asked them to come to court for that matter. Mr. Malema could not identify any of them other than the fact that they were wearing EFF T-shirts. That's the difficulty we face, Your Lordship, because we might face the same issue with Senekal. We are accused of being part of rogue elements, when in fact, once you investigate, you find out that what is apparent is actually not the truth. And that's the point, Your Lordship, we're trying to make.
You said the other case you were referring to, what's the name of the case?
Your Lordship, I was asking if that's the case you dealt with, because that was quite recent.
This was a case which was brought, I think, on an urgent basis. I'll give you the full citation now. This, I think, came before me on an urgent. No, it came on the opposed motion as an interdict. No, it served before this court as an urgent application, yes. And that's the case of AfriForum, Pty Limited versus Economic Freedom Fighters.
I very much suspect it's the same case. Is that in Centurion Midrand Cream Restaurant? It sounds like it. If you're familiar with the facts, it's not that one. Well, be that as it may, Your Lordship, the point we simply make is that even on the basis of vicarious liability, once employees act out of their own volition without mandate, without urgency from the principal, you can't be held liable. My learned friend has failed to show the connection between the people that are outside and the EFF's mandate, or that they were led for that matter. For all we know, it's the same scenario that happened in Senekal. We're not denying, nor are we presenting evidence. We're simply saying it requires full investigation.
Well, you see, in this case, the argument was also around the question of mandate.
Yes.
And EFF's argument was, we actually have a structure, I think they call it employment desk. And they say the only way that you would have a mandate to go into a shopping mall and demand to employ certain people is if you are mandated by the employment desk. But then I looked at one of the cases which also deals with this issue. I think it's a case involving the ANC, where the court said that the political parties are parties registered under the some legislation, I think it's referred to in their country called now, and therefore they enter into some form of a contract with their members. But look, it seems your argument now is that in this particular case, in your case, the facts are not similar to, well, the facts are different, but also the facts are distinguishable in that there, people were not, the people who were identified as singing didn't have the EFF regalia, but there were people from the EFF present at the gathering.
When you say EFF people, Your Lordship, we're simply saying people wearing red. We're not suggesting the leadership of the EFF, particularly when that song was being sung. But the crucial point to make, Your Lordship, is there is no evidence that they are members of the EFF. So it could well be that they sang the song. Even on vicarious liability, you can't link it to the EFF until you establish that they're actually members of the EFF. And that's the point we're trying to make, Your Lordship. So you can't even apply vicarious liability and the principles of urgency without establishing first that they've even got an official relationship with the EFF.
So your case would be you need to produce proof that these are members of the EFF.
1. 2, the case law says if you're going to introduce new material, then you must allow full investigation so that you can properly plead to the case. What we are saying is the 2 witnesses of the EFF who commented on the videos, 1, I only had 10 minutes to consult with the first one. 2, Mr. Malema was inundated at the zone. I couldn't consult with him. He was asked the questions on the spot. And I'm saying until we're given due process in terms of proper consultation on the issue, then a determination cannot be made where you say the EFF is vicariously liable, having not even established whether the persons in question belong to the EFF or not. The EFF dishes out T-shirts on the daily at the rallies, Your Lordship, so it doesn't follow simply because you got a T-shirt on that means you're the member of the EFF. And that's the point we're making, that there needs to be an investigation. Mr. Malema could not identify any of the parties on the video. They were unled. A proper investigation has to happen, a proper supplementing of the pleadings has to happen, and then we can plead properly to the case.
Just give me 1 second. Yes, I found that the ANC case, it's actually the Ramakatsa versus Mahashule case, where the court said that common law, a voluntary association like the ANC is taken to have been created by agreement as it is not a body established by statute. The ANC's constitution, together with the audit guidelines and any other rules, collectively constitute the terms of the agreement entered into. Thus, the relationship between the party and its members is contractual. So this was dealing with more the question of whether what he did was permissible under in terms of the law. But okay, I hear what you're saying. Thank you very much. That was the point. I don't know, Mr. Oppenheimer, any follow-up from the point I raised?
Just something brief. My little friend points out that in the case of Oba King, who was going around as an EFF member and telling restaurants who they can and can't hire, Mr. Malema denounced it. He said, no, that's an unacceptable thing and this guy shouldn't be doing that. Mr. Malema is given an identical opportunity with regards to the people in Senekal, the people outside of court. He says, I'm not going to denounce them. He says, they must be allowed to sing the song. He says, I will sing the song. That shows you, in other words, that people who purport to be members of the EFF, wear the regalia, attend the rallies, are willing to come outside this court and protest. I imagine some of them are quite fervent members. That gives you an indication of what the party does, and that's why the party must be held liable. And when given an opportunity to distance itself, Mr. Lema says, no, we're not going to distance ourselves. We have no problem with what they're doing. And that's why there must be liability for the EFF as a party for what's done by its members or those who purport to be its members.
Yes, except to say that sorry, I picked these judgments as we were going along. As you saw me passing on the papers, they were just coming to mind, and I asked the secretary to look for them for me. But in this judgment, I actually underline one of the judgments, the National Party versus Jami, and another, an electoral appeal court tribunal, where the court, amongst others, said, not going to read the full quotation, it says, it would be necessary to allege and prove facts which at common law would give rise to vicarious liability on the part of the political party, if it were sought to hold the political party liable for acts committed by its members or supporters. And I think that's the point that Mr. Kasiboto is making, that what ought to have happened here is they ought to have been given an opportunity to disprove that these are their members. Although here it says you have to prove the facts. So it means you had the burden of proving that those people who were singing there are in fact members of the EFF.
Yes, I suppose the question is what would count as proof. And I'd say the video evidence of people wearing the shirts at an EFF rally is sufficient evidence to show it. The idea that you should check the membership cards, and by the way, there are many people who are members of parties without holding membership cards. It's quite a rare thing, people to spend the 10 Rand and sign up. But one is a member. Mr. Malema identified those people outside. He says they're my members, they're my supporters, they're my voters.
Thank you very much. Thank you. That brings us to the end of this hearing. I'm going to reserve judgment in this matter. You will be informed as soon as judgment is ready, but I can just underline that I want your attention on Wednesday to send me an email that where the judgment. You are going to fall in the queue of the reserved judgment of last week's agent court judgment. But in any case, by its very nature, it is going to require me some time. Thank you very much.